All right, good morning. This is the Colorado Oil and Gas Conservation Commission. It is Thursday, March 10th, and we have a general session ahead of us. We will start with a roll call.
Thank you, Mr. Chair. Commissioner Bogue, Commissioner Gonzalez,
Here.
Commissioner Hackett, Commissioner McGowan,
Here.
Commissioner Mesner,
Here.
Commissioner Nanjapa,
Here.
Commissioner Robbins.
Here.
Mr. Chair, you have 5 out of 7 commissioners present.
Great, and that is a quorum. Good to see everybody. Good morning. We already have 49 participants participating with us. We welcome everyone to our meeting. We have 2 matters on our agenda. We first will take up docket 2104-00052. That is an oil and gas development plan called the Peanut Fed 3403 matter, and that is for Verdad Resources. Following that, we will take up the continuance of 2107-00114. That is the Longs Peak Oil and Gas Development Plan second. And we have agendized this so that we would take up the peanut matter first, and Longs Peak is going to start on no earlier than 10 a.m. We do have one public commenter on 2104-0052. That person is Keith Lemay, and we are looking to see if Mr. Lemay is in the meeting room.
And Mr. Chair, I am not seeing Mr. Lemay in the room at the moment.
Okay, then why don't we go ahead? We do have the applicant in the room and move forward with the applicant's presentation, and then we can come back if Mr. Lemay is available later for public comment. Good morning, Mr. Fraschala. Are you on your own? Do you have others that we should elevate?
It looks like the representatives from Verdad are on the line. I see Ms. Mitchell, Mr. Cugnetti. I don't see Mr. Jarrett, but he may be attending through one of the others. There should be Andrew Jarrett would be the third representative and our main presenter.
Okay, maybe if Ms. Mitchell and Mr. Cugnetti could unmute and turn video on, we can see if they have the other individual with them.
Mr. Jarrett actually is coming in right now.
Great. Well, great.
Ms. Larson, a note for the record that we have Mr. Hackett, although he is labeled Ms. Larson.
We will change that. One moment.
Mr. Fraschala, are we ready to go or?
Yeah, I thought we were waiting for Miss Larson. I'm prepared to begin.
No, go ahead. We are ready for you to get started.
Excellent. Okay. Thank you, Mr. Chair. Good morning, commissioners. My name is Joe Fraschala. I'm an attorney with Wellborn, Sullivan, Meck, and Tooley, and I'm here on behalf of the applicant, Verdad Resources. Also with me today are Andrew Jarrett, the Vice President of Exploration and Operations for Verdad, Heather Mitchell, the Regulatory Manager, and Mike Cognetti, Director of EHS&R. Verdad is a registered operator in good standing with the Commission, has met all financial assurances as required by the state of Colorado. Verdad's application requests that the Commission approve an oil and gas development plan covering 1,280 acres in Section 3, Township 9 North, Range 59 West, and Section 34, Township 10 North, Range 59 West in Weld County, Colorado. The oil and gas development plan requests one new oil and gas location, the Peanut Fed 3403 pad, to allow 5 horizontal wells to be drilled from that Peanut location, to modify the spacing order number 5351068, which established a 1,280 acre drilling and spacing unit for the previously described lands, and to reduce the number of permitted wells from 12 to 5, and reduce the unit boundary setbacks from 600 feet to 300 feet. And this is all for the exploration and production of oil and gas and associated hydrocarbons from the Niobrara, Fort Hays, Codell, and Carlisle formations. The Peanut location is in the northeast quarter of the northwest quarter and the northwest quarter of the northeast quarter of Section 34, which is all within the proposed the established drilling and spacing unit. Verdad has leasehold that covers more than 45% of the drilling and spacing unit and is an owner with the right to drill and produce in the application lands. The Peanut location is on fee surface in a rural part of Weld County. There are no residential building units within 3 miles of the location, no schools closer than 14 miles. The nearest municipality is 14 miles away, and the nearest disproportionately impacted community is more than 33 miles away. Verdad has a surface use agreement with the surface owner and has met with the owner regarding the siting of the location. Of the Rule 304B2B criteria, this location meets only subsection 8 as being within a high priority habitat, specifically mule deer, winter concentration area in severe winter range, which would have required an alternative location analysis. However, following the pre-application consultation, Colorado Parks and Wildlife has waived the ALA requirement as permitted by rule. During that consultation process, Verdad worked with CPW to prepare a wildlife mitigation plan to mitigate the impacts to mule deer, including winter timing stipulations and compensatory mitigation fees for direct and indirect impacts. The relevant local government is Weld County, and it has approved the location at WOGLA 21-002. There are no proximate local governments. Verdad has not requested any variances. Verdad did request lesser impact exemptions that have been granted by the director, and those are for noise mitigation plan, light mitigation plan, and a geologic hazard plan. With respect to notice, Verdad has given proper notice pursuant to Rules 303E and 504. No petitions or interventions have been received. On March 4th, 2022, the director issued her recommendation, which recommends approval of the application. The application satisfies the Conservation Act and all commission rules, and therefore Verdad respectfully requests that the commission adopt the director's recommendation and approve the application. I'd like to turn it now to Mr. Andrew Jarrett, who will introduce you to Verdad and give you an overview of the Peanut Oil and Gas Development Plan. And Ms. Mitchell and Mr. Cognetti are also available to answer commissioner questions. Thank you very much.
Good morning. My name is Andrew Jarrett. Thank you, Mr. Fraschala, for the introduction. Again, I'm the Vice President of Exploration and Operations for Verdad Resources. We have prepared a few slides to help aid this discussion, and I will try to share them now. Okay.
Mr. Jared, we can see your slides. I just want to note for the record that by sharing them, these are public documents. And I note on the top right-hand corner, it says strictly confidential. So just be apprised of the fact that they are now no longer strictly confidential.
Understood. Thank you very much. Thanks again for giving us the opportunity to discuss the peanut fed OGDP. And we'll spend a little time introducing Verdad Resources as a company and talk more specifically about this location. As an introduction to the company, we were formed in 2015 and drilled our first well the next year in 2016. We're a team of 60 highly experienced professionals. Most of us are in Denver, but we also have an office in Dallas, and our field team is located in Fort Morgan, Colorado. In total, we operate 245 wells, all of which are in the state. And since inception, we've drilled 132 wells, all horizontal, including drilling 46 wells last year in 2021. And we are currently running a rig not too far away from this peanut fed location. We prioritize safety in our culture and are proud to have an excellent record in that regard. We've prepared a map of the area to help orient you to the peanut fed 3403 location. Again, we are in far northeast Colorado, in a rural part of the state. On this map, you'll see quite a few elements. I would first note that the northern border of the state of Colorado is along the north side of this map. The red outline, the map is centered on the peanut fed location itself. And the red outline is our 2-mile, 1,280 acre spacing unit. The concentric circles around the location show distances to the pad, 5, 10, 15, 20 miles. And the white shaded outline shows the high priority habitat, which is winter range for mule deer. The thin brown lines are existing roads, and the green dots are residential building units, the nearest of which is about 3 miles away. And as Mr. Fraschala mentioned, the nearest school is 14 miles away. With the location falling in high priority habitat, that is the only criteria that would have triggered an alternative location analysis. And we will discuss a little bit more about the other locations that we considered in a moment. This slide provides a little more detail on why we've selected this location. It's a aerial photograph zoomed in a bit. The blue outline shows our 1,280 acre unit where we plan to drill 5 2-mile laterals. Longer laterals are more efficient. Having fewer wellbores means less time with equipment on location and ultimately lower disturbance and emissions. From an early stage, we've worked with the CPW to find this acceptable location and have committed to operate outside of the winter months when the mule deer are most often present in this part of the state. Additionally, you'll see that this location uses an existing 2-track road. It is coming from the west side of the map and moves northeast to the location outlined in red. In total, including upgrading the road, disturbance is 11.5 acres. This slide shows a little more detail on the alternatives that were considered before we decided on the location that we're discussing. Alternative location A at the south end of the image, it has the yellow shading, was around an archaeological site and therefore was not an appropriate location for development. Alternative location B in the middle of the image, shaded green, is an existing location that has 4 producing wells on it that we operate. Developing this 280-acre unit from this location would have required 10 one-mile laterals, 5 going north, 5 going south, instead of the 5 total wells, 2-mile wells going from north to south. Again, by developing with long laterals, we think it's more efficient, and we anticipate 30 fewer days of operations by drilling the 5 longer wells versus the 10 shorter wells. And with that 30 fewer days of operations and time on location, greatly reduced truck traffic, dust, noise, odor, and would have a much larger location to have a safe operation. As part of this application, we plan to plug and abandon the existing wells, those 4 wells on alt location B, and fully reclaim the site, returning it to its natural state. Alternative location C in the northwest corner with blue shading involves federal surface, which had quite a bit of uncertainty, and alternative location D in the northeast could not be accessed through an adjacent parcel. On wildlife mitigation, early on in our evaluation of these locations, we consulted with the CPW to find an acceptable pad and to help us mitigate the impacts on the mule deer population. Again, we agreed on development timing with the CPW and have committed to avoid operations in the winter months when the mule deer are using the area. We plan to construct the location this year in the summertime and have our drilling and completion operations next year in the summertime, 2023. For further mitigation, we plan on moving oil on pipeline off of the location. And once we're in the production phase, we'll be able to perform interim reclamation and reduce the pad area down to 4.38 acres. Here we list a few benefits of this development plans. We will provide funding to the CPW for habitat restoration. As mentioned, we'll reclaim the existing pad, which in total will remove 16 tanks from that location, as opposed to adding 10 tanks at the new facility. So a net decrease in tankage. I'd like to point out a few of the best management practices from our OGDP application. We will adhere to light and noise level guidance put forth by the county, Weld County, and we plan to have a quiet frac fleet for completion operations. And our tank light design will reduce the largest sources of emissions during the process, the tanks and the trucking. Lastly, we include a summary of our consultations where we've discussed this location with the county and the CPW from an early stage to help guide our process. And we note that we did not sign a service agreement until working alongside those 2 groups and receiving guidance from them. We end with the director's recommendation that was issued last week. We feel that we've chosen the safest location for health, the environment, and the local wildlife. And we appreciate the opportunity to discuss this OGDP with you today. To help answer questions online are also Mike Cognetti, our Director of EHS&R, and Heather Mitchell, our Regulatory Manager.
Thank you very much for the presentation. I want to comment that I am appreciative of the timeline here, whereby Verdad did the initial consults ahead of time, had the CPW review consult, Weld consult, and the SUA was not executed until after. I think that is the appropriate method of approaching oil and gas development of under 181. So I appreciate your noting that for the record, and just wanted to comment on that point for you. Other commissioners with comments or questions? Commissioner McGowan, then Commissioner Najapa.
Thank you, Mr. Chair, and thanks for the presentation. And do you mind going back to the slide that shows where the location will be and where the existing locations are? So super helpful for me.
It was it.
Yep, this one. Yep, thank you. I just want to clarify, because I was the one who sent the question ahead of time of why you didn't just add wells to the green location B. And even though it's more wells over time, it would be in an already existing footprint. So I just want to clarify, B is actually the wells that you've committed to P'ing and A'ing. That infrastructure will be going away. And then you'll have those new wells to the north. And so we are still kind of trading one set of infrastructure for another. But we're not adding to the per square mile operations. Does that make sense? I think I'm understanding what you're saying, and I'm really appreciative of this.
That summary is correct. The green location will be abandoned and reclaimed.
I just wanted clarity around that. Thank you. Sorry.
Commissioner Najapa.
Thank you, Mr. Chair, and thank you all for the presentation. Yeah, appreciate it. It's really helpful, some of these diagrams, et cetera. And Commissioner McGowan asked, similar to what I was going to ask, I just wanted to tag on to that. What is the time frame approximately for the reclamation of that location B, the Timbro pad?
So we're planning to P&A those wells prior to completing the wells proposed for the peanut fed. Reclamation of the facility and decommissioning of the facility would follow very shortly after.
Okay, and I understand that reclamation can take multiple years. I was just curious when you were intending to initiate. So sometime within the next, or before you begin drilling at this location that's proposed, then those locations would be, that sort of decommissioning would have begun. Is that correct?
I would say prior to completion, not necessarily prior to drilling, but
okay,
certainly do it prior to completion of the well. So before frac starts.
Okay, all right, fair enough. There was, let's see what's up. Okay, and then the other piece, we kind of mentioned this in a prior application last week that came up, and I know that there's been discussions about kind of a process for the waiver, but ideally a waiver, is going to be a separate document that discusses, the reasons why the ALA was waived. I also just want to express appreciation for the fact that you did an alternate location analysis that you presented here and kind of explain that, why that was necessary. But given that it was in the high priority habitat and you had the CPW consultation, et cetera, I think just for clarity, it would help us to have a separate document rather than just the correspondence between you and CPW. But otherwise, that's all I had. Thank you.
Commissioner Messner.
Thank you, Mr. Chair. Appreciate the presentation and the application. I've just got a couple of comments, just generally about applications. I think as it appears that you're continuing to potentially will continue to provide OGDP applications in the future. I think that the WOGLA process is a from a local government standpoint is a strong process. And I think that, that initial consultation and the timeline you provided was good to show the different levels of consultation and process that you go through. And I know that, at least I believe that the WOGLA process does require that alternative location analysis, which is good, because as I'm reading the director's recommendation, I think between Commissioner McGowan's questions, perhaps Commissioner Najapa's questions, there was some lack of information that was in there as far as determining what potential cumulative impacts would be associated with some of the different alternative locations. And, you know, it appears through the presentation that you've given now, probably in response to Commissioner McGowan's initial questions, that by plugging, abandoning, remediating, reclamating the existing site, then you're minimizing some of the cumulative impacts associated with that, which in my opinion is a good thing. And so it was a well done alternative location analysis. But that's why, from this commissioner's standpoint, it's important that we be limited in the utilization of waiving alternative location analysis from CPW, because this is important information both for staff and for commissioners to look at when determining things other than wildlife. But I don't have any heartburn with the proposed location that you put forward, and it seems like the appropriate location in this situation. I also know that the local government through the WOGLA process has standards for light and for noise. And in your presentation, you've indicated that you would meet those standards. At least from my perspective, you know, we do offer the ability for those local government standards to be utilized as substantially equivalent to our standards in an application submittal. And so just for, and it's just a suggestion, because you can certainly ask for those lesser area exemptions, but you know, having read that WOGLA process and the information that you provided through that WOGLA process, it would have been good just to have those light and noise plans associated with your application to COGCC as well, rather than asking for that lesser area exemption, because in my opinion, they met the substantially equivalent standard, and so would just create a better holistic application. But those aren't criticisms, those are just suggestions for the future. And I had enough information in this application to review, and so I'm comfortable. Thank you.
Commissioner Gonzalez.
Thank you, Chair, and thank you to Mr. Jarrett, Mr. Carnegie for the presentation today. I've got a question. I'm pretty comfortable in general with the location of the application itself, but I'm curious about the federal minerals inside the DSU, as I understand there to be. Is there a federal permit associated with this?
Yes, there will be a federal permit associated. It is a fee fed location, meaning it's on fee surface over fee minerals, and we will then develop through the lateral federal minerals. And so we'll have one federal permit. Yes.
Okay, so that's a full federal permit, not just a CA.
Yes, for the wellbore.
Okay, what's the status of that? Has it been submitted yet? Are you guys working through that?
It has not yet been submitted. We were waiting to make sure we got through this process, and then we will be submitting that.
Fair enough. Thank you.
Other questions? All right, seeing no further questions, thank you to the panel for the presentation. You can stop the screen share, and we will all gather again via Zoom. And we will now turn to that portion of this application, which is the deliberation of commissioners on application 2104-00052. Does anybody care to start? Commissioner McGowan?
Thank you, Mr. Chair. And I appreciated the application contents and the presentation today, and I feel like I have enough information to support approval of this permit application.
Commissioner Najapa?
Thank you, Mr. Chair. Yeah, I appreciate the presentation. agree with Commissioner McGowan that there was sufficient information presented. I appreciate the wildlife mitigation plans, especially to avoid operations during the winter activity of the prime winter activity of the mule deer, and also the intent of reclaiming the other pad, given that you're not going to be using that one. And I also feel that what you have provided here demonstrates that you have done what we required and have gone above with some of the BMPs, and appreciate that. And I can also support.
Very good. Commissioner Gonzalez.
Thanks, Chair. I'm in support of this application. I'll go ahead and put forward a motion to approve the application for the OGDP, the peanut fed 34. Oh, hold on, I lost it. 3403 OGDP.
Second.
We have a motion and a second. Is there further discussion? Seeing none, all those in favor of the motion signify by saying aye. Aye. Any opposed? Motion carries. Thank you very much, folks. Appreciate your presentation. Thanks for being with us.
Thank you very much, commissioners.
Okay, we will roll into the next portion of our agenda, which is taking up the continued item of docket number 2107-00114, Pierre McGee Oil and Gas Onshore LP, and this is the Longs Peak Oil and Gas Development Plan. Commissioners, I would like to sort of talk through process on this matter with you. We've got 76 some odd public commenters. We've got a petition. We've got an applicant. We've got a lot of things going on here. I'd like to roll through sort of my ideas about how we would most successfully process this matter today. And then I'd like to open it up for thoughts about that from my fellow commissioners. And then once we identify a process, then we can roll into sort of next steps. So we do have the application before us. We had taken this up a couple of weeks ago. I don't remember exactly when, and we had provided instruction to the applicants that we wanted to see some additional information developed. That has occurred, and that information is within our e-filing system, and we've all reviewed it. We did have a robust public comment section at our initial hearing. We have before us another robust public comment section. We have about 76 people that have signed up for public comment. And then we have received a petition filed by attorney Michael Freeman, who is on the panel. Good morning, Mr. Freeman. And in that petition, he asks that we grant party status to certain individuals, as well as to Logic, the League of whatever Logic stands for, I can't remember. It's a group that plays before us quite a bit, and we appreciate their attendance. And so they asked for party status. The relief requested is also that they be granted a 15-minute time block within which to make their presentation on behalf of the clients. And so I would like to suggest a couple of things. One, and this is just one commissioner, and we look forward to hearing from the rest of you. I do not necessarily need, at least I don't, oral argument on the petition. We've received the petition, we've received a response, we've received a reply. I've read the pleadings, you've read the pleadings. I think I am ready to determine the petition and the requested relief. Second, I, as one commissioner, am not inclined to grant the petition in terms of granting party status. I believe that we created a great deal of additional standing requirements with notice requirements in our rules, and they are well past that time frame. And I think that granting it at this late date would not be an appropriate move. However, having said that, I am inclined to as prerogative of the chair, as chair of this commission, grant Mr. Freeman and his clients their requested relief, which is to give them an allocated 15 minutes to make their presentation. I would suggest that if other commissioners are in like mind, that process-wise, we start today's hearing with Mr. Freeman and with his presentation and with the allocated 15 minutes, so that we can hear sort of the narrative from his client's perspective at the beginning. We then could move into a Q&A with Mr. Freeman. I would then suggest we follow that up with public comment. As I mentioned, we have a long day ahead of us and we've got a lot of public commenters. I would suggest we consider 2 minutes per public commenter as opposed to 3. That would reduce the overall public comment time from approximately 4 hours without Q&A to about 2.5 hours, or 3.8 hours to 2.5 hours if my math is correct. I then would think that it would be appropriate to take up the applicant's continued presentation and then move into question and answers from commission, followed by deliberation. So I'm not trying to say we got to do it that way. Those are my thoughts. I just wanted to get all that out there. I now would open up the mic to my fellow commissioners with thoughts about that process or any other process or how folks want to move through the day. Commissioner Nanjapa, and then Commissioner Gonzalez.
Thank you, Mr. Chair. I want to first express appreciation for the petition that Mr. Freeman and colleagues have provided. I think you know, there's some important information there, but I agree with you, Chair Robbins, that I think the appropriate course of action is to grant the relief requested and to allow the presentation and to move forward. I'm also supportive of the 2 minutes per public commenter.
Thank you, Commissioner Nanjapa. Commissioner Gonzalez.
Thank you, Chair. And I agree with your suggestion about how to move forward from a process perspective. I do have a comment just in general to express maybe not my appreciation, more frustration with the timing of this application. You know, it seems to me like the latest that the affected parties knew about this was late December. We had a hearing on February 16th. Didn't hear anything from that date. At that time, we extended public comment to this hearing. We decidedly did not extend opportunities for petition to this hearing, yet we still received one 3 days before the hearing. I can appreciate Mr. Freeman and his client's concerns. I've read through their petitions. I've read through the other materials associated with that, including their comments or kind of their consolidated comments sheet as well. But, you know, we've got these processes for a reason, these deadlines for a reason. I found it a little bit disruptive to shift focus from consideration of the matters at hand to consideration of this petition, whether or not we were going to grant it, whether or not I was going to take a position on it, and really kind of all that was associated with it, when really Mr. Freeman and his clients have had opportunity to get this before us, perhaps not within that November 8th deadline, but perhaps a little more timely than the 3 days we've had here. So I am frustrated with that. I find it a little bit disruptive. That being said, I'm comfortable granting Mr. Freeman and his clients the 15 minutes they requested. And I'm comfortable with I think we have 72 public commenters, maybe more, and hearing from them in 2 minute increments.
Great. I thank you, Commissioner Gonzalez. I echo that frustration. I also will alert applicants that I'm a little frustrated that they didn't meet the deadlines that we asked for supplemental information, and that they filed stuff even as late as this Monday when we asked that filings be last week. You know, it's just a subtle reminder, guys. These are very important topics. We as commissioners are doing our darndest to make sure we're up to speed, and for everyone's worth, if you can meet the deadlines, it is very helpful to allow commissioners the opportunity to have slow measured steps in kind of reviewing everything. Commissioner Messner, Commissioner McGowan, did you guys want to weigh in one way or another? Okay, Commissioner Messner.
Thank you, Mr. Chair. I appreciate the comments around the timeliness of submittals. I mean, I think that in an attempt to be as well-informed and well-versed as possible on all the topics that we come before the commission, I think the deadlines associated are designed to provide time for this commission to be able to review the information as thoroughly as we possibly can. I think that regarding the petition, I think it is appropriate to provide the relief requested in the petition. I do think that the intent of shifting dates for being able to request party status has to do with the timing associated with the start of a hearing, not for any continuances associated within the hearing. And so I would agree to not allow the party status, but again, I think it's important that we honor the request for relief. And I do appreciate the submittals that have been provided by Mr. Freeman and his clients. I thought that was good information, and I was able to review that. And so I will talk just a little bit about the public comment piece. I mean, I think public comment's important, and certainly it is a valuable piece of information for me. I also think we need to be realistic about the amount of time we have associated with being able to review applications and the amount of public comment associated with that. And so I think it is appropriate to limit public comment to 2 minutes, but I think more importantly than that, it's while I want everyone to be able to have the opportunity to share their thoughts, oftentimes in public comments, the thoughts that are shared are very similar to other thoughts that have been shared. And I think that while we received significant public comment at the onset of this hearing on this particular application, there have been changes to the application. And I would strongly encourage that the public comment we receive on this application is focused on the changes that have occurred in the application between the initial hearing and today, as that's the most relevant piece to our decision making that will occur today. And so not an attempt to limit public comment at all. I think people need to have the ability to share their thoughts, but I think we also need to be realistic about the amount of time in the day and the fact that I think we need to come to a decision on this particular application. And so I would just like folks to take that into consideration as they're providing public comment and the focus of their public comment. So thank you.
Commissioner Messner, Commissioner McGowan.
Thank you, Mr. Chair, and I agree with everything that my fellow commissioners have said thus far. I will add, during public testimony, I'd like to know where the folks are from. I understand that there are a lot of folks who have a passionate opinion about what's being considered today, but I would also like to know which folks testifying today are directly impacted by what we're discussing. I'm also a little crabby also about when things are submitted and what the expectations are for people to read and be able to absorb. So, you know, I'm getting paid full time to do this and I will read everything, but there are other people who are trying to participate and try to understand what's going on. And I know I've said this multiple times. It's also unfair to the various folks who are participating in order to be able to respond in timely and have thoughtful responses. Things that are turned in like the day before our hearing are really not a good way for us to conduct business. So that being said, I also am supportive of allowing time for Mr. Freeman to talk about concerns from folks in the neighborhood. I think that's appropriate. But I do think the deadlines we have in place for party status are there for a reason as well. So I think this is a good compromise.
Okay, thank you, commissioners. It's good to hear we're kind of all of like mind. I appreciate all the additional comments. I would like to recognize Ms. Wazelinski or Ms. Jost as the attorneys for the applicant. if they have any initial concerns, thoughts, et cetera, with regard to process discussion that we just had.
Thank you, Chair Robbins, and thank you, Commissioners. Kelsey Wazelinski from Jost Energy Law here on behalf of Kerr McGee. We certainly appreciate your decision on party status and agree with that. We certainly agree with the timelines here and that those deadlines were missed. We also appreciate the perspective of residents within 2,000 feet. And so if the decision is to have these citizens, make their comments during public comment, I don't think Kerr McGee would oppose that. Also would like to just make a brief mention on the timeline. We do understand your concerns on the date of submittals on our end and apologize if any of that was late. We did submit a pretty thorough PowerPoint and list of best management practices on the 3rd as requested. We admittedly didn't really recognize the fact that you all would benefit from a narrative until the Friday after we submitted. And therefore we did supplement the materials with an ALA narrative, which really just describes the PowerPoint that was already submitted on Monday. And so we do apologize if that was submitted after that deadline, but wanted you to understand the reasons why.
Thank you, Ms. Wazelinski. With that, and yeah, we're not quite ready for morning break. So why don't we go ahead and get started with this application. Again, it is docket 210700114. And given the process discussion, I believe we will now recognize Mr. Freeman. And Mr. Freeman, if you have any preliminary matters, let's take those up first, and then otherwise we will get a clock ready and give you the 15 minutes that we've all agreed to allocate.
Thank you, Chair Robbins. And we very much appreciate the opportunity to present remarks on the substance of Kerr McGee's new analysis. Before the commission votes on our petition for party status, though, I would just like to note a couple of other points that I don't think were discussed during your discussion a moment ago. And that's the key problem here is that the affected residents we represent were never sent.
Hey, Mr. Freeman, I'm sorry, I'm gonna interrupt. We've already decided we do not want to hear oral argument on your motion or your petition. And so I do not need to hear that this morning. And in fact, I would look for commission to for a motion on whether to grant or deny the party status at this point. And then we can let Mr. Freeman go into his oral argument for 15 minutes, which is well above the 2 minutes allocated to everybody else. Do I have a motion?
So moved.
Second.
We have a motion and a second. AG Davenport, do you have any commentary? I see you've unmuted.
I'm sorry, I apologize for interrupting. Just to clarify for the record that my understanding is that the motion is to deny the petition, but as within the commission's discretion to grant, well, who the folks we've been referring to as petitioners a 15-minute public comment period.
That is my understanding.
Okay.
Commissioner Gonzalez, is that?
That is my motion.
Thank you.
And Commissioner McGowan, is that consistent with a second?
Yep, I'm seconding so we can discuss and vote. Thanks.
Okay, great. All right, any discussion on the motion? And my comment on the motion is we really appreciate what you're bringing to the table here, Mr. Freeman. We're not dissing you or your clients, but we did make a decision that we did not need oral argument. And so we're going to move forward, and we look forward to hearing from you for the full 15-minute allocated time plus Q&A following the motion. With that, is there any further discussion? Seeing none, all those in favor of the motion signify by saying aye.
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 Opposed? Motion carries. Okay, with that, Mr. Freeman, the floor is yours. We do have a timer up for 15 minutes. You have been allocated 15 full minutes for your presentation. I would note that your presentation should be sort of your opening, your closing, your rebuttal, all the above. You're a well-versed attorney, and I know you can do that. You have seen all the filings that have been made by the applicant, and so I think you're well poised to provide us good perspective on the application. I do reserve that following the presentation, there will be a chance for Q&A, and that Q&A will not count toward your 15 minutes, so you've got a full 15 to present your client's position, which is, I think, consistent with the relief requested.
Thank you, Chair Robbins. Before I begin, could I ask that Tom Delahanty be added as a presenter as well? He's going to be managing our slides for the remarks here.
Yeah, that sounds great. And hearings manager Amaro, let's remove the screen share of the time. I'm running a iPhone with a 15-minute clock, so I'll keep track of time and we'll subtly remind the folks when they're getting close to the end. And let's bring Mr. Delahanty to the panel so that we've got co-counsel available for slideshow and otherwise.
Great. Okay. And thank you, Tom, for adding that. I'll go ahead and get started. Thank you, commissioners. My name is Michael Freeman, appearing on behalf of the affected neighborhood residents and lodging. Kerr McGee's application should be denied. The company has had multiple bites at the apple, but has failed to comply with Rule 604. First, following the CDPHE consultation, Kerr McGee is submitting additional information and make changes to its application. And following questions raised by this commission on February 16th at the hearing, Kerr McGee has provided a whole new alternative location analysis addressing some of those questions. Despite those opportunities, Kerr McGee has failed to bring its application into compliance with the setback rule. And as a result, we asked the commission to deny the application. Next slide. First, Kerr McGee still has not even attempted to show that the impacts from its proposal will be substantially equivalent to complying with the 2,000-foot setback. The point of Rule 604 is to avoid impacts to residents by putting distance between drilling and homes. This commission recognized in 2020 that distance provides significant benefits in terms of avoiding impacts from air pollution, odors, and other harms that go well beyond the typical control measures or BMPs. In its application, Kerr McGee ignores the avoid part and focuses just on minimizing and mitigating impacts from drilling near people's homes. But just applying control measures or BMPs to reduce impacts or to minimize impacts is not the same thing as showing that they are substantially equivalent to compliance with the setback. In fact, under this commission's rules and SB 181, every oil and gas development plan is supposed to minimize adverse impacts. So what Kerr McGee is offering here isn't anything more than it should be doing regardless of the 2,000-foot setback. The substantial equivalence exception here requires more than that. I'd also note that doing the analysis to show substantial equivalence is totally feasible. The CDPHE recommended one approach, which was to do air modeling. And with our supplemental comments, we submitted a report from Dr. Lawrence Meckel that provides a more detailed description of what ought to be done. And essentially, what he recommends is that Kerr McGee needs to actually define what metrics it's using to show substantial equivalence, so benzene emissions, traffic, or other impacts, and then compare the exposure of those impacts to receptors at 2,000 feet compared to the impacts to residents under Kerr McGee's proposal. Kerr McGee hasn't done any of that analysis. And moreover, as other commenters have noted, and the CDPHE itself noted, the best management practices Kerr McGee proposes are really not that compelling. Those measures are already being used at pads in Broomfield, and they haven't prevented issues from arising there. All of these steps that it's taking are things they should already be doing to minimize adverse impacts, regardless of the 2,000-foot buffer. The bottom line here is that if an ad hoc application of BMPs could qualify and satisfy the substantial equivalence standard by themselves, that effectively renders the setback meaningless. When this commission adopted Rule 604 in 2020, the setback was the centerpiece of the mission change rules and made Colorado a national leader in protecting neighborhoods from drilling. But adopting Kerr-McGee's approach would set a terrible precedent and undercut all the good work this commission did in developing and adopting Rule 604. Next slide. So next, I'd like to address the new alternative location analysis that Kerr-McGee produced this week. As an initial matter, I want to emphasize that while the ALA is certainly relevant under Rule 604, the focus of 604 and the substantial equivalent exception is on the impacts to residents' health and welfare. And operators claim that it can't recover all the minerals while complying with Rule 604 does not warrant an exception, and it doesn't satisfy the substantial equivalent standard. That said, our review suggests that there are in fact ways that Kerr-McGee can recover a reasonable amount of the minerals here while still complying with the setback. Before I go into those though, I want to note, take a step back and note a little bit of the history here. Kerr-McGee's original ALA was supposed to require, and was required to evaluate all potential alternative locations. And back in January and February, Kerr-McGee was telling you all that there were just no technically feasible alternatives that would further reduce impacts to residents here. Well, that turned out to be not quite true. After this commission pressed Kerr-McGee at the February hearing, the company's new ALA shows that there is in fact an approach that will reduce the number of affected homes within 2,000 feet by about 75%. That's alternative A shown here. And it basically involves drilling from the less populated eastern area and then significantly shrinking the size of the McGavin pad. Kerr-McGee is rejecting this approach because it would be, in its view, less efficient for recovering the minerals. But what alternative A would do would be likely reduce impacts well beyond Kerr-McGee's proposal. And the alternative A demonstrates in part why the proposed approach should be rejected and denied. Next slide. That said, even with alternative A, the new ALA is incomplete and it's still focused on justifying the proposal Kerr-McGee wants to pursue rather than focusing on avoiding and minimizing adverse impacts. What Kerr-McGee still hasn't done here is to seriously consider a development approach that doesn't include its preferred McGavin or Columbine paths. All of the three top alternatives that Kerr-McGee analyzed here retain both of those well paths. On the other hand, its consideration of options without those paths was framed so that Kerr-McGee could reject them for leaving minerals stranded, and that's what's shown on this slide here. But what's notable here is that all of these alternatives it rejected because of stranded minerals only involved two well paths. And Kerr-McGee declined to consider any alternative that didn't involve McGavin and Columbine, but that had a third pad to address more minerals. The bottom line here is that Kerr-McGee can't have its cake and eat it too. If it needs to look at options that may include a third pad, but don't involve the McGavin and Columbine pads and that do respect the 2,000-foot setback. I do want to note also quickly here that even under its analysis, it's not the case that all these options are unreasonable. Alternative 2C in particular, we think would be a reasonable approach. But that said, there are a number of options to access all the minerals Kerr-McGee wants to get while still respecting the 2,000-foot setback and avoiding the McGavin and Columbine locations. But Kerr-McGee just hasn't looked at those options. Next slide. So there are a couple of solutions to do this here that Kerr-McGee hasn't looked at. First, Conservation Colorado has submitted comments showing how Kerr-McGee could use 3-mile horizontal wells to reach the entire development area while avoiding nearly all homes. In its analysis, though, Kerr-McGee does not appear to even have looked at the option of 3-mile horizontals. In addition, Dr. Meckel's report with our comments reviewed the March 3rd maps in Kerr-McGee's analysis. And what Kerr-McGee's maps did was to depict areas in the region here that were more than 2,000 feet from any homes, and which also didn't trigger any of the other ALA criteria under Rule 304, things like water bodies or wetlands or wildlife habitat. Those clear zones are shown in Kerr-McGee's base map in white, and a review of those white areas actually highlights several options that Kerr-McGee didn't consider. First, the areas to the northeast and northwest here, locations F and G, could be used to access the northern area of minerals that Kerr-McGee found couldn't be recovered from a well pad to the east. So the northern part of its development area here could be reached by using a well pad and wells from locations F and G. And I note that the long step outs from F and G here in yellow are based on well trajectories that Great Western Operating is using in wells that it's drilled elsewhere in Colorado. So the F and G locations should be technically feasible because those length of wells are already being drilled just a few miles away. And those would be a ready substitute for using the Gavin pad to get at the northern part of the development area. Second, as I noted earlier, alternative A, which involved looking at well pads to the east, alternative A, as Kerr-McGee described it, involved 2 separate well pads in the eastern area. But another option here would be to use a single location to access the minerals from the east. Kerr-McGee's base map shows large areas of white in that part of the region that could be used to drill while complying with the 2,000-foot buffer. Dr. Meckel's report identified option H here as a potential location, again using the same long step outs to cover the full area. But another option would be location 6, which location 6 was mentioned in Kerr-McGee's original ALA, but not fully analyzed with this perspective. And location 6 is within 2,000 feet of only 2 homes, which would be far, far less than anything Kerr-McGee is proposing. The third point from Dr. Meckel's report is that he identified 2 other locations in the southern part of the area. Those are locations I and J that appear to be more than 2,000 feet away from any homes, but could reach many of the minerals at issue here. Kerr-McGee didn't analyze these either. So in short, there are a variety of other ways that Kerr-McGee could structure this plan that would comply with 604, but which the company's analysis doesn't address. Kerr-McGee has had multiple bites at the apple here, but still has not satisfied Rule 604 or the substantial equivalent exception. As a result, the commission should just deny this application. If Kerr-McGee wants to try again, it can go back to the drawing board and develop a new OGDP that complies with the rules and can bring that new application back to the commission for consideration. Thank you.
You've still got 3.5 minutes left, Mr. Freeman.
That's all, Chair Robbins, that's all I've got. I'm happy to answer questions or go into any details I didn't cover there.
Can you go back to, I'll start with some questions. Can you go back to the slide that was labeled alternatives? Yeah, that one.
Yeah.
So you kind of went through this real quick. I want to give you an opportunity to sort of slowly work through it a little bit more so that we can understand it. Is this slide depicting a utilization of 3-mile laterals with potential proposals, or is this slide, because you were talking about that and then you moved into this slide, and so I got a little confused.
Sure. No, let me, in fact, we were trying to make sure we met our 15 minutes and not go too far into the weeds up front, but let me back up and I can provide a more detailed explanation. Tom, could you back up to the prior slide? The prior slide. What we suggest you look at is alternative 2C here is one of the options that Kerr-McGee rejected. And what 2C proposes here is an approach that would have 2 well pads on the eastern part of the development area. And as you can see from the map, the diagram there, that would allow Kerr-McGee to recover most of the development area, the southernmost part of it. We did some quick analysis of that. And it looks like alternative 2C would allow the company to access about 70% of the minerals that its proposed approach would cover. So we think by itself, 2C would be a reasonable outcome here because leaving those northern minerals alone to avoid impacts to residents, it isn't waste and is appropriate under the commission's rules. But Kerr-McGee rejected.
Let me stop you here. Let's have a little dialogue on this if we could. So from my notes, 2C develops 3,040 acres and strands 1,680 acres. And that's from the applicants on additional presentation.
Mhm.
And so from my notes, your clients believe that that is reasonable in terms of developing a subset of the minerals, but not all. And then does the next slide then give some perspective on potentials for developing the northern minerals? Is that
Exactly. Thank you. Thank you, Chair Robbins. That's the idea here is alternative 2C, we think allowing them to recover 70% of the minerals we think is reasonable, but we also think there's options which are on the next slide for recovering those northern minerals. Tom, could you go to the next slide? Okay, so what we're discussing here, and I know this is a really busy slide, we overlay these things on Kerr-McGee's base map, but the idea behind alternatives F and G, or locations F and G, is to let Kerr-McGee access those northern minerals without using the McGavin pad. What Dr. Meckel did was to look for areas in white on the base map and those are areas that are more than 2,000 feet away from any homes. And also outside any of the other, they were white, so they were outside any of the other areas marked as triggering ALA 304 criteria. And so the idea there would be to use F and G as an alternative to the McGavin pad to get the northern minerals. The other part of this that's I think central is that Kerr-McGee and some of the alternatives it discussed but rejected identified that drilling from the east would allow it to recover the minerals that aren't in that northern strip, kind of the southern half or 2/3 of the minerals. Kerr-McGee's approach would have used 2 well pads at the east, which is one way to do it. But Dr. Meckel suggested that you could do it with a single well pad at location H here, which is in the white area, so it shouldn't impact any homes. A very closely related location is option 6, which is actually part of Kerr-McGee's original ALA and is 2,000 feet from only 2 homes. And so the idea here would be to use a 3-pad configuration where about 70% of the minerals would be recovered from location H or location 6 on the east. And then F and G would be used to recover what's left in the north. Now, as we mentioned in our comments, we're not, we're offering these to show that there are other options for doing this that Kerr-McGee hasn't analyzed. We're not proposing any specific permutation or configuration. What we are saying is that this commission shouldn't just jump to the conclusion that Kerr-McGee's proposal is the only way to do this, or that it's not, or that it's impossible to actually both comply with the setback and recover a reasonable degree of the minerals. And so we think, given the multiple iterations of this, that the company still hasn't satisfied the rules and that this application should be denied.
Thank you for that additional explanation. I'm looking to see. And could you, you have mentioned your witness, Dr. something. What's his name?
Lawrence Meckel.
And can you give me his background and his professional expertise?
Sure. He is, I believe, a PhD petroleum geologist who worked for Shell and some other oil and gas energy companies for about 30 years, and is now doing consulting work. And he's based out of Australia, but he's done work in the Gulf of Mexico as well as in South America.
Okay, thank you. Just wanted to get that on the record, knowing that we're, not like certifying people as experts and things of that sort. We have relaxed rules, but we just are trying to, get all perspectives out there. So appreciate that.
Sure. And his,
go ahead.
I'm sorry. Dr. Meckel's CV is attached to his report. So if the commission would like to take a closer look at his credentials, they're right there.
I did, and I knew that. I just was getting it out for the 215 other people that are listening in this afternoon or this morning. Okay, I'm going to stop dominating the Q&A with this panel. Others with questions? Commissioner Gonzalez?
Thanks, Chair, and thank you, Mr. Freeman, for your presentation on this morning. I'll stick with this slide that you have up here. And I'm sorry, I was looking at my notes and pulling up the map while you were talking about Dr. Meckel's credentials. What type of engineer is Dr. Meckel?
Let me just check. I can find out right now. Hold on. Just give me a moment. So he has a BA and Master's in Geology and a Doctor of Philosophy in Geology Earth Science. He was with Shell as a geologist and production geologist for a number of years, about 10 years. Then he worked for another company by the name of Woodside Energy, working in the Gulf of Mexico for about 6 years after that, and he's also done some consulting for other exploration companies as well.
Sure, and I appreciate that, Mr. Freeman. That's kind of what I was trying to understand here. I was curious if you were speaking with a drilling engineer who had experience working on the Front Range or working with the area in the DJ Basin, specifically with regard to technical feasibility for what looks to me like pretty aggressive step outs on what's being proposed with GNF. And so I'm curious, I don't see the measurements up here. What are the step outs being proposed for PADS GNF, the forward build?
Sure. So I would point out that Dr. Meckel arrived and proposed these because these are ones that have already been drilled and are being used by Great Western in some of its wells, just a few miles to the south of this OGDP. So these aren't hypothetical. These are wells that have been drilled in northeastern Colorado. And my understanding, just from looking at it, eyeballing it, is it's about the step out is about a mile, and then the lateral is about 1.5 to 2 miles. But this is not stuff that is hypothetical. It's work that's already being done in this region of Colorado.
And is it Dr. Meckel's opinion that the geology here is identical or substantially identical to the geology that is being utilized under the Great Western PADS? We're in a different part of the field. It differs across the field. So I'm curious if this is one of, kind of a really, really good analogy.
So we compared what formations were being targeted, both at the Great Western wells and here. They're both targeting the Niobrara and I believe the Codell. So there may be some differences, but we're not aware of any dramatic differences that would make this impractical here, while it's practical being done in a few miles away.
Okay. Yeah. I don't know that just saying they're in the same formation is enough of a technical analysis to say that the operations would be identical or wouldn't face any kind of variables that would differ, because as we know, all these projects are different. Geologist has one job, reservoir engineer has another job, drilling engineer has another job, completion engineer has another job. They all kind of put their expertise into the planning of what ends up with a project. So thanks for clarifying that. I don't know if that gives me any more information in terms of technical feasibility. I don't know that I will get any more information in terms of technical feasibility, but I wanted to understand where that was coming from.
If I could, Commissioner Gonzalez, part of our point here, and we're working from limited information. I understand that is that there are alternatives here that look to us and to Dr. Meckel to be feasible, but they just haven't been considered. Kermagie's analysis was focused on reaching the result it wanted, which was to keep McGavin and Columbine locations. And our point is that's not a universe of what's reasonable or feasible here. There are other options that need to be looked at. They just haven't done.
Yeah, and I'm not contesting that may or may not be the case in terms of the planning here or the alternatives that have been presented. But additionally, there's likely alternatives that are just so out of the realm of possibility that they aren't even considered for various reasons. I'm not saying that's the case either, but we're talking about a bunch of hypotheticals here. I'm going to move on from that topic and ask you something a little more specific. So, in regards, we're talking about 604B4 here in the application, right? We're talking about substantial equivalence. We're talking about a 2,000-foot distance. We've talked in our SBP about the application of this rule, about distance not being the only proxy for protection, and that there are others to be considered here. And so I want to understand this. Are you saying that the idea of more pads, more wells, potentially longer timing, potentially greater impacts that aren't necessarily impacts specifically to the residents that we're talking about at this case, that is better than having locations that are simply outside of or that those locations, by virtue of them being outside of 2,000 feet, are simply better than any location within 2,000 feet? Less wells, less pads, potentially less traffic, potentially less impacts.
No, we're not saying that's automatically the case here. What we're saying is that the substantial equivalence standard requires, the whole point behind the 2,000-foot setback is a recognition that distance between homes or any receptors and drilling provides benefits for avoiding impacts that are not normally achieved through typical BMP's control measures, and that in order to take advantage of the substantial equivalent exception to that setback, Kerr-McGee's got to do the analysis to show that the impacts to the folks who live in this neighborhood of Firestone will be comparable to what they would have been if the wells were moved more than 2,000 feet away. And they just simply haven't done that analysis. Their analysis has been simply focused on saying, look, we're doing this stuff. We're using the Broomfield BMPs to minimize our impacts to nearby residents. But all that is the standard they've got to apply to any drilling. It doesn't qualify as substantial equivalent. It doesn't meet that standard. I'd note also, you're that on the map here, if there are certainly other environmental issues or potential environmental factors beyond just proximity to homes. But what this map shows is that a lot of those areas, if not all of them, things like wildlife habitat, other ALI criteria, there are options that avoid those too, right? Those are the white areas on the base map. And so our point is that Kerr-McGee hasn't done the analysis to show substantial equivalence, and that B, there are other potential alternatives here to comply with the setback and to minimize adverse impacts that just haven't been considered.
I take your point about the quantification of metrics as to putting on a case to prove substantial equivalence, and I look forward to hearing what the applicant has to say about that as well. So I'm going to take your point there. We're talking about specifically the biggest concern here seems to be proximity. So I want to distill that a little bit further, Mr. Freeman. Within 2,000 feet. Within a 2,000-foot distance, what are the greatest concerns that would be alleviated by moving that outside 2,000 feet?
Sure. I mean, in this particular example, for the affected residents, traffic is a big one. The haul route that Kerr-McGee proposes to use for the McGavin pad goes right by their houses. There's also noise, air emissions, light, you name it. There's all the we submitted some of the testimony from the emission change rulemaking documenting the kind of health impacts and environmental harms that occur for residents within 2,000 feet of a well pad. All of those are implicated here. And that's part of why the suggestion by the CDPHE for modeling here would have been valuable. The commission could require Kerr-McGee to do air quality modeling and show, okay, here's what the likely emissions impact will be for receptors 700 feet, 800 feet away where those are homes, and compare that to what the emissions would be or the exposures would be for people 2,000 feet away if they actually complied. Kerr-McGee just hasn't done the analysis to show that that any of those metrics are substantially equivalent to complying with the setback.
Thank you, Mr. Freeman. I'm going to hold questions here and go through my notes. I'll pass it to other commissioners.
Thank you.
McGowan.
Thank you, Mr. Chair, and thank you, Mr. Freeman, for your presentation. I think Commissioner Gonzalez has asked many of the questions about the alternatives that you all have proposed, so I'm not going to revisit that. I think what I'd like to hear from you in regards to substantial equivalency is what should Kerr-McGee be modeling against? So if the pad were to be 2,000 feet away, are they modeling and are they going to propose a diesel rig with produced water tanks on site, et cetera, and then they're modeling against best BMP is, which are closer than 2,000 feet. I think what I'm struggling with the modeling piece is, what are we modeling X versus Y, and what is the X and what is the Y? And then can you also please tie that to, I was trying to read through our statement basis of purpose again this morning, that it's the substantial equivalency is not a direct comparison to the 2,000 feet. It's actually an acknowledgement that while distance is the best, most protective to move away, that there should be also consideration of substantial equivalency. So I'd like you to address that as well, please.
Sure. So what Kerr-McGee probably should have done here is when it filed its first application, I guess back in July of 2021, is modeled what it was proposing. So the diesel rig, the so-called tankless approach that actually had some tanks, compare what emissions those would have, what the traffic it was going to generate to residents with 2,000 feet, and then identify some hypothetical locations 2,000 feet away, and measure what those exposures would be there. Without looking at that, there's just no basis for comparison here. And then, once it identifies, is there a delta there, and what that delta is, the difference between exposures for air pollution or traffic, then identify, control measures or other steps that could avoid and minimize and avoid those impacts, and bring the impacts to residents down to what is, substantially similar or substantially equivalent to the benefit of distance. And I think, in terms of the statement of basis and purpose, it does say, multiple times that yes, control measures, steps other than distance can be used to show substantial equivalence and to provide an off-ramp from the setback, that, they have to be measured by reference to the benefits of distance. And that's what Kerr-McGee hasn't done. What Kerr-McGee has done here is essentially said, look, here's some BMPs that we're agreeing to use, electric rig, avoid tanks, and that's going to minimize impact, so that's good enough. But that doesn't provide the comparison that you need to actually establish substantial equivalence. And what Kerr-McGee is really just offering is saying, here's what we can do to minimize the impacts from this operation. We're minimizing them, but again, minimizing adverse impacts is the standard for all OGDPs. It doesn't actually, it doesn't show substantial equivalence by itself.
Thank you. So I guess what I'm trying to figure out here is whether or not we would have operators then submitting an original or a proposed OGDP that doesn't have some of these BMPs to start off with, so that they could compare a substantially equivalent one with the BMPs. And then we're not really truly modeling a relevant proposal against a relevant proposal. So I need to kind of think through that a little bit. I'm wondering if, and I'm just going to guess the answer is no. I think I read in Kerr-McGee's proposal that there was some sort of issue with drilling east-west versus the north-south. And in this, one of your proposals here is the H or the 6, which I think is showing east-west drilling. And so I'm looking forward to hearing some feedback from Kerr-McGee on that. Sorry, I just want to make sure I'm
No, that's right, Commissioner McGowan. What Kerr-McGee said, as I understand it, I'm sure they can add to this, is that the east-west orientation is less preferable in terms of efficiency of recovery, but that they can do it, and it will allow them to recover minerals from the bulk of the area. And again, the test here is not what's the most efficient, most profitable approach for Kerr-McGee. The test here is what does the best to minimize adverse impacts and provide something that's substantially equivalent to distance. And so Kerr-McGee is not disputing that drilling from the east is a feasible approach that it could do here. It's just declined to want to do that.
Thanks. Thank you very much.
Commissioner Messner.
Thank you, Mr. Chair, and thank you, Mr. Freeman, for providing the information and your thoughts on this application. So I'm gonna make sure that I understand what you're saying, at least your point here. So I'm gonna say it in a little bit of different terms. And I appreciate your analysis of substantial equivalency, because that's an important topic of discussion in this particular application and in the applications that are utilizing 604 B4. And so I mean, I've read through again multiple times the statement of basis and purpose, and under Rule 604 B4, the statement of basis and purpose indicates the commission will use categories of information set forth in Rule 604 B4 A through G, as well as other relevant information appropriate to the proposed location to determine substantial equivalency. I think you're indicating, and I tend to agree, that the information is to be provided by the applicant as part of their burden of proof. Statement of basis and purpose also says Rule 604 B4 A through G requires the commission to consider information that reflects whether alternative methods of achieving protection are equal or more effective to satisfy the relevant criteria when considering specific characteristics of a proposed locations. Throughout, I think Rule 604 B4, the commission's intent is to reflect that distance is only one way to protect public health, safety, welfare, the environment, and wildlife resources, as I think some of the other commissioners have indicated, and that the commission rules achieve the required protection in a variety of ways, including but not limited to the alternative location analysis, considerations of facility design, adherence to best management practices, requiring use of specific control technologies, et cetera. And I think what I'm hearing you say is that, understanding that the applicant has the burden of proof, and that even though distance isn't the only consideration here, and the underlying approach to our rules is to avoid first, then mitigate, or then minimize, and if you're unable to minimize, then mitigate, that you do not feel that the applicant has provided sufficient information or analysis in order to be able to show substantial equivalency. Is that my understanding as far as what you're generally indicating?
Yes, Commissioner Messner, I think that's exactly right. First, the rule contemplates applying the mitigation hierarchy, which is to first avoid, then minimize and mitigate. And in effect, what Kerr-McGee has done here is to jump right over the avoid part and go right to minimize and mitigate. But in terms of substantial equivalence, what it hasn't done is provide any kind of comparison of its proposed mitigation to what could be achieved by moving these well pads farther away from homes. And without providing that comparison, it just hasn't made the showing that's required by Rule 604.
Okay. Thank you for your time, Mr. Freeman.
Thank you.
Further questions? Okay, Mr. Freeman, thank you for your time. If you could file your slideshow, that would be great, so that we have ready access to it. We appreciate the time that we've been able to spend with you this morning, and appreciate your representation of your clients before the commission. I would my final thoughts about this is, I appreciate the work that you've done. I appreciate the questions from Commissioner Gonzalez relevant to, your expert and, whether they've got experience within the DJ or not. I also would sort of note that, at least from this commissioner's perspective, is that it's not your burden to prove up, the best locations. That's the burden of proof for the applicant. But I think that what you've brought to the table provides good perspective for us as we move forward in consideration of this, and will provide commission with a good set of questions for the applicant as we move forward. So thank you very much. With that, I would suggest perhaps let's take a 10-minute morning break, and then we would go into public comment. Ms. Larson?
Briefly, if we could ask the representatives from the town of Firestone to raise their hands. I'm not able to find them in the meeting, so if they're there and they can raise their hands, we'll get them in during the break.
Okay, and then we would go to them next as elected officials.
As elected officials, and there are some folks who are raising their hands. Specifically, we were looking for Frank Jimenez, AJ Krieger, and Sean Doherty.
Okay, that sounds good. Ms. Wazelinski, I noticed you've daylighted yourself. Did you have any procedural questions that you were bringing to the fore?
Thank you, Chair Robbins. I would just ask that Kerr-McGee had the opportunity to respond to the points that Mr. Freeman made in your Q&A this morning, and we can do that after our presentation if that's appropriate.
Yeah, no, we definitely, that was kind of my last point there, is that we're definitely looking to have a good, robust discussion with you. We've taken our notes, you've taken your notes, and we'll get into that after we get through public comment, if that's okay.
We appreciate that. Thank you.
Mr. Chair, if you could afford me just one additional comment. I see, for instance, Joe and Sherry Walker raise their hand just so they know they are on the list to speak. And Ivy Pitts, I do not have that individual on our list to speak. So again, the names I called out, if you could raise your hands, I'm looking for Frank Jimenez, Sean Doherty, and forgive me, AJ Krieger. So if those individuals could raise their hands, I would appreciate it.
Okay, and so while those raisings of hands are happening, we'll take a 10-minute break and we'll come back at 10:45. Okay, welcome back, folks. This is Colorado Oil and Gas Conservation Commission. This is our March 10th meeting. It is 10:45, and we are reconvening on the Longs Peak matter. We will now spend several hours hearing from public comment. And we will start with public comment from the elected officials from the town of Firestone. I have on my list Frank Jimenez, AJ Krieger, and Sean Daugherty. I see we have a panel of folks, looks like two people are in the room. Who's in the room there, guys?
AJ Krieger and Frank Jimenez. Trustee Daugherty was not able to make it this morning.
Okay, great. Let's, we will hear from you. We'll allocate 4 minutes, and then there may be some questions. So there is a timer on the side there. Hearings Manager Amaro, if you could turn that to a 4-minute thing, because there's 2 of them, and then we can get that going. Thank you. Let's stop it or restart it. There you go. Okay. Okay, Mr. Krieger, Mayor Jimenez, we look forward to hearing from you.
Thank you, Mr. Chair, Commissioners. My name is Frank Jimenez. I am the Mayor Pro Tem of the town of Firestone. I won't take a lot of your time. Just wanted to reiterate, we've had an opportunity to review the changes that Town Director was proposing you are considering today. And wanted to reiterate our support for that. And I'd also like to comment, in our last meeting, I commented how the applicant has always been receptive to the town of Firestone's needs and our feedback and been willing to adapt. I think this is yet another example of that. So again, I do reiterate our support for the project, and I hope you do approve it. And as you are considering, I do wish that you will consider this board's authority to make decisions such as this on local matters that affect our community. Thank you.
Good morning, Mr. Chairman and Commission members. AJ Krieger, I'm the town manager in Firestone. Our address is 9950 Park Avenue, Firestone, Colorado 80504. Of course, I agree with everything the Mayor Pro Tem just said. I will only add that as a town staff, and I know our elected officials do as well, respect greatly the work of the COGCC, both the commission itself and of its professional staff. And we respect the work that they've done and all the thoughtful and careful consideration here. We think several times today, you're going to hear some of your rules and some of the accommodations there referred to as off-ramps. And we respectfully disagree with that characterization. We know that your rules, particularly those in 604, have been carefully considered and have gone through a process to be properly promulgated. We respect that work, and we respect the work that the commission will do. And I'll end by saying that, of course, the town of Firestone remains supportive of the Longs Peak OGDP application. And that in Firestone, we have a history of being able to balance both oil and gas interests, or not both, but oil and gas interests, private property rights, and prudent and careful implementation of health and safety measures. And we expect this project to be exactly the same. And we hope that the commission will support it. Thank you.
Okay, thank you both. I do have some follow-up questions for you, if you don't mind. Talk to me about the operator agreement that you entered into and the conditions of approval that are applicable to oil and gas development, as well as the land dedication that was a component of the operator agreement. I'd like to get I'd like to dig a little deeper into that.
Happy to. So the conditions, the cooperative agreement that the town and Occidental entered into in April of 2021 includes some operational standards. There are places called them BMPs. They're probably the same thing. But we, I think as we briefly discussed in the first hearing, as a town, we tried to focus on the things that we know from experience are the most important to nearby residents and or neighbors. And so that's what we did. And we want to lay a framework for some measures that would be, some mitigations and measures that would be beyond what is included in our land development code. Of course, I think the commission knows and understands that our purview is really only on the land development side and the specific site plan side. And so our land development code has standards and criteria that have to be met as part of the special review use application process. And that's the process that Kerr-McGee went through here. And the cooperative agreement specifically requires, in addition to those other mitigation measures, that the applicant adhere to town code, and specifically the special review use application process. So I'll pause there if there's any other question about that part of it.
Well, just by way of follow-up, I mean, the applicant would need to adhere to town code irrespective of the operator agreement, right?
Yes.
Okay. Talk to me about the land dedication component of the operator agreement. What's that all about?
Well, as you are describing, there is an element in the cooperative plan agreement that would provide for donation of a 78-acre parcel to the town of Firestone. It was not tied in any way to the town's approval of the special review use application, but it's ultimately triggered by finally being permitted by the COGCC. But I think the agreement, I don't have it in front of me, but I think the agreement says that within 60 days of receiving final approval from the commission, Kerr-McGee will donate the 78-acre piece to the town of Firestone.
But the agreement does indicate that in order to receive the 78 acres, you're not going to object to the proposal at the commission, correct?
I don't specifically recall that language, and I don't have it in front of me, but I mean, I think our board has indicated through the special review use process that it approved of it. So
okay,
I'll speak to that. The board reviewed the application on the merits of the application itself. There was no discussion related to what we're talking about right now. The board considered the application, the evidence presented, and the requirements of our code and what the applicant was providing. The land itself was not a consideration on the ultimate decision.
okay. The agreement does say that you will not lodge an objection at the COGCC for the McGavin and Columbine sites. And if you comply with that, you would then, and if they are approved, you will receive the 78 acres, correct?
Again, I don't have it in front of me. I won't dispute your characterization of it, but I don't have the exact language in front of me. But I think that's right. But if I may, we had spent, by the time we presented that agreement to our board of trustees for approval, we had spent plus or minus 2 years working with Oxy, even before they were Oxy, when they were still Anadarko. We had spent a couple of years working with their staff on the potential of these two pads and talking about mitigations and et cetera. So we felt like we were comfortable as a staff with the plan and with their approach. So I think we intended at some point we anticipated at some point that it would get approved through a local process, and didn't frankly know what to expect from the commission side.
Okay. A few more follow-up questions, and it's true, right, that Oxy bought the surface locations for these pads in 2015?
I believe 2015 is correct. I believe, yes.
Okay. What's if this all comes to pass, what's the town going to use the 78 acres for?
We haven't committed to anything. On the 23rd of this month, our board of trustees will consider adoption of a historic Firestone neighborhood sub-area plan. And part of that sub-area plan contemplates the implementation of some specific design guidelines for some adjacent parcels, the 78 acres being one of them. I think what I would broadly say, and I would be careful to note that this has not been approved or adopted by the Board of Trustees. So at this point, I'm giving you town staff's expectation. What we would anticipate is an expansion of Hart Park, an expansion of some open space and trail corridors through ultimately a residential development. And we further anticipate that the development will include some specific affordable units. Those may run a range of from senior affordable or just generally low income or low mod income affordable units, but there'll be some affordability aspect to the eventual development there.
Okay. Thank you. A final round of questions involves the Planning Commission, who reviewed the proposal and who recommended. They just make a recommendation. I was a local government lawyer in my former life and represented a bunch of planning commissions, and they are a non-elected appointed board by the Board of Commissioners or the Board of Trustees, and they look at land use approvals with an eye from the citizens, and they recommended denial. Is that right?
Yes, they never made findings. Of course, as you're alluding to, they're an advisory body, and they offer the Board of Trustees advisory opinions as part of a quasi-judicial land use application process. They never made any specific findings, but they indicated their preference was for denial of the application.
Okay. Thank you very much, gentlemen. We really appreciate you being with us this morning. Do any other commissioners have questions? Commissioner Messner?
Thank you, Mr. Chair, and thank you both for being here and presenting here today. I did have a couple of uses or a couple of questions about your land use code. Understanding that local governments and the state have a dual regulatory authority, and that an applicant needs to get approval from both the local government as well as the state in order for an application to move forward. But as part of our 604 rules, we do consider the local government's land use decision-making in our decision-making process. And so in an attempt to consider that as part of my decision-making process, I just had a couple of questions about your process that may help me better understand. So Chairman Robbins asked a few of the questions that I was going to ask, but is it my understanding it's my understanding, you can correct me if I'm wrong, that oil and gas development in the town of Firestone is an allowed use in any zone?
That is correct, yes.
Okay.
Via the special review use process, yes.
Okay. And in order for an application to be approved in a residential area or a commercial area or an industrial area, there has to be a finding to determine that that use is compatible with the surrounding land uses. Is that right?
Yes, our code, the special reviews process lays out approval criteria. So our, in this case, our planning and development staff performs that review or approval criteria analysis and offers a recommendation. And as you probably know, in this case, our professional staff recommended approval because of adherence to those approval criteria.
What was the finding that determined that that it was a compatible use in this particular situation?
Well, I don't think there was a specific one, but I think it relied on several factors. One, that the town's overall master plan contemplates oil and gas and energy production in any classification throughout the town. Second, that via the special review use process, there is a route to it being permitted in every land use classification. And then third, the ability to adhere to our specific requirements in that section of the land development code.
So the code doesn't say that there has to be a finding associated with it. I guess I misread that then.
No, I mean, the code lays out approval criteria. Our staff presents that analysis through the process initially to the Plan Commission in their advisory capacity, and then ultimately to the Board of Trustees, and the Board of Trustees makes a determination within the context of a quasi-judicial public hearing.
Okay, thank you. I appreciate you answering my questions.
Let me dig a little deeper there, Commissioner Messner. I have the town code in front of me. And Mr. Krieger or Mayor, if you could, so the code says that in order to approve it, the proposed use is found to be compatible with adjacent uses in terms of scale, site design, and operating characteristics, hours of operation, traffic generation, lighting, noise, odor, dust, and other external impacts. That finding has to have been made. Number two, that any significant adverse impacts anticipated to result from the use will be mitigated or offset to the maximum extent reasonable practicable. And there's a couple of others, but the other one that's important is any significant adverse impacts on natural environment will be mitigated to the maximum extent reasonable practicable. Along the lines of Commissioner Messner's inquiry, how was it that the town made those three findings?
Well, again, I think it's a combination of two things. It's I mentioned its compatibility within the context of the town's overall master plan and its permitted use status via the special review use process. There's also a corresponding site plan, which we call an FTP, There's also a corresponding site plan application that gets reviewed. Our staff goes through the same process I described a second ago and presents it ultimately to the Plan Commission and to the Board of Trustees. So I think the short answer, I think I understand your question. I think the short answer is that the staff goes through a review and determines the compatibility and makes a recommendation to both the Plan Commission and to the Board of Trustees. And then those boards act as they deem appropriate.
I'll speak a little bit to the question about compatibility. During the hearing itself, I had commented on specifically on compatibility, and what I had commented on is the site in question. There is really feet away a similar ONG site. So when we talk about this site in itself, there is already activity nearby. And when we talk about just, I don't know how many feet, but to the north and east of the site, there is another site that is not too distant from the proposed location. So when we talk about compatibility, we already do have similar uses in the area. What I found particularly noteworthy of this application is both those sites are proposed to be plugged and abandoned. So by approving this, I found it was beneficial that in approving this, we would P&A two sites that are close by and have this site in a similar location that already exists. So that is something I consider when we talked about compatibility with the area.
Mr. Robbins, may I just offer one more comment to expand? In our master plan, there's a specific section that encourages oil and gas operators to drill wells, even specifically in residential areas prior to residential development commencing. And so the underlying, I mean, I appreciate that the Longs Peak application has two sites, Columbine and McGavin. It feels like all the focus is on McGavin. But in both cases, we anticipate there'll be residential development that will happen in close proximity, if not on that exact site in the relative near term. And that also having the ability to have the wells drilled and the production occurred now prior to development is consistent with the guidance within our master plan.
I'm aware of a subdivision near the Columbine, obviously, that's part of the record that is to be developed. But help me, are there planned development near McGavin that is also?
So the site itself is zoned for residential. And so we anticipate a point at which there may be residential drilled on the back, or residential developed on the rest of the site, post drilling and completions. So that's possible.
Okay, but that's not platted or otherwise at this point. Is that right?
I'm sorry, that was muffled. I couldn't quite hear you.
I'm sorry, but that's not platted or planned at this point. That's just the master plan calls for it.
The surface for McGavin is not platted or not platted at this point. That's correct.
Okay, but for Columbine, it's already platted. Is that right?
There was a previous approved plat on the 78 acres that the town would eventually acquire. That has probably lapsed. There is platted residential inside the town of Frederick. I think you quickly made reference to that a minute ago. And the land directly north and to the northwest, we are going through active planning processes with potential applicants right now.
Okay, great. Thank you very much. We really appreciate your being with us this morning. Are there other questions from commissioners? Okay, seeing none, we will let you two fine gentlemen go. Thank you again for being with us. And I would turn to Hearings Manager Larson. Did we have other elected officials that we wanted to recognize? Just jumping into our list.
So Ms. Lori Anderson from Broomfield City Council is up next.
Okay, let's bring her to the table and then we will hear from Ms. Commissioner Anderson or City Council Member Anderson.
Ms. Anderson declined to join us. Oh, let's try this one. Apologies, I perhaps selected the wrong Anderson. There you are.
Thank you. Thank you for this opportunity to provide public comment on Longs Peak OGDP. My name is Lori Anderson. I live near the Livingston site in Broomfield, and I'm also a Broomfield City Council member, though I do not represent the entire council or organization. Please note my comments are related to future development and not in protest or objection to any existing permit. I submitted a written comment on Monday, which I'm sure you have all received and hopefully had time to review. I just want to make a couple comments to highlight our experience in Broomfield, which is relevant to the Longs Peak OGDP. Extraction's 84 well plan in Broomfield was approved in 2018 and continues under that agreement, including the BMP still today. It was neighborhood drilling such as this that led to the need and passage of SB 181. The subsequent COGCC rulemakings took into consideration public testimony of impacted residents, including residents impacted by Extraction's Broomfield development, as well as studies such as the 2019 CDPHE study, which showed the potential for acute short-term health impacts from residents 2,000 feet from a well pad. Additionally, the health complaints filed by residents align with the types of health impacts the CDPHE study predicts. I provided more in-depth information in my written comments, but for a quick overview, adverse health impacts, safety concerns, emissions, noise, and odor issues persisted in this pre-181 operation, despite having all the BMPs in place. Hundreds of health concerns were filed in Broomfield with the top reported health impacts, including difficulty sleeping, headache, anxiety, stress, nosebleeds, and irritation of the throat, eyes, or nasal area. We know that noise is more than just a nuisance, and the most disruptive noise was reported during the hydraulic fracturing and coiling and tubing phases. Broomfield has captured emission spikes estimated at as high as 224 parts per billion benzene for a 1 hour duration, over 20 times the ATSDR standard, and that's just one chemical. From a safety perspective, data shows accidents like explosions, fires, well blowouts, leaks, and spills are not rare. The closer residents are to these pads, especially those living within 2,000 feet, the greater the health and safety impacts are. Our experience in Broomfield unambiguously shows residents within 2,000 feet of new oil and gas operations will suffer adverse health and welfare impacts. Requiring BMPs like those used in Broomfield will not change that fact. We know it didn't in Broomfield. Putting a large-scale operation like the proposed Longs Peak OGDP that close to residents is not consistent with the protection of public health, safety, and welfare as mandated by SB 181. I request that you prioritize the health and safety of nearby residents and deny the Longs Peak OGDP for the above reasons. Thank you for your time today.
Thank you very much. We appreciate your being with us this morning and for testifying.
Thank
We
you.
now will call upon Randy Gurul.
Hello, can you see me?
We can hear you, yes.
Okay, well, that's good enough, right?
It is good enough, yes.
Okay. My name is Randy Gurley. I'm a Colorado native. I moved to Firestone in 2004. My comments are in regard to the latest update. When I moved out here, all the roads had numbers. When I gave directions to my house, I would say I live between Road 11 and Road 13, just south of Road 20. There were a lot more fields with pump jacks. I live in the Delray subdivision, and I'm one lot away from an abandoned well that was capped and plugged. The land was remediated, and 2 homes in the 800,000 range were built on this land. I'm sure the price of my house went up after these 2 homes were built. I'm also very concerned with keeping Firestone beautiful and an enjoyable place to live. In 2004, I loved looking at the open spaces out here. I loved seeing the fields with the pump jacks, the oil rigs, the rabbits, prairie dogs, and the eagles flying around. My eagle sightings are few and far between now. I look around now and I see all new subdivisions. The houses are stacked on top of each other. I do not see the beauty in that. I have to admit, I prefer the open fields with all the pump jacks and the oil rigs. My son at age 19 started working at one of the oil company's shops as a handyman. My son is now 27, and as of a year and a half ago, has started his own service company. None of his success would have been possible if it wasn't for the oil and gas industry. Right now, with the current events going on, it is the best interest of the country that we produce as much oil and gas as we can. Firestone, as we all know, is in Weld County. Weld County extracts 87% of the crude oil produced in Colorado. Weld County is also responsible for 43% of all natural gas produced in Colorado. I find it un-American as well as ridiculous for us to be importing oil when we have the resources to extract all the oil we need. I have no problem with going green and doing our part to control greenhouse gases that cause global warming. But we need to remember that the USA is only responsible for 14% of the greenhouse gases. China is responsible for 30%. China, Russia, and India create 42% of all the greenhouse gases. We need to continue to go green, but not at the expense of national security or inflation. I think we should cut oil extraction as we use it. We should never import oil. Oil was discovered in Weld County in 1923. Weld County and the city of Firestone is known for oil and gas. I have the hardest time understanding how you can move into Firestone.
Your time is up. If you could wrap up, please.
I thought I had 3 minutes.
2 minutes.
Oh, okay. I got one more paragraph. Oh, never mind. I would just like to thank the comments. I would just like to thank the COGCC for letting me speak.
And we appreciate you being with us as well. I don't know if you heard earlier, but some of the commissioners were interested in knowing where folks live in terms of their comments. I can't require that of anybody, but if you wanted to provide your town, that would be great.
I will do that. Thank you.
Okay, just a reminder to everyone else that's speaking, if we could get some perspective on where you live, that would be helpful to commissioners. We now will call upon Jodel Mosino. Sorry.
Okay, can you hear me?
Yes.
Okay, we were told that we had 3 minutes on this, so I apologize if I go over a little bit. These comments are in response to the updates made since the last hearing. My name is Jodel Mosoni, and I'm a Colorado native of 69 years. The state has always been my home and that of my great-grandparents who immigrated from Ireland. I care deeply about the quality of life for my family, friends, and all those who call this beautiful state home. My grandparents' farm now carries a Centennial Farm designation in northeastern Colorado, where my cousin has farmed and raised cattle since the 80s. And the mineral rights to the gas wells there still provide income to myself and my entire extended family. Mineral rights from property in Broomfield has also provided income to my immediate family. Rural Colorado has truly benefited from the oil and gas development in recent years, as it made life easier and to make ends meet for those farming and ranching families. My career spanned owning and operating 3 businesses and raising 2 children. My husband is a manufacturer's rep and now works in commercial real estate as we move into retirement. We have lived the American dream and are presently watching over a burdensome government spend away opportunities for the next generation. Colorado voters killed Prop 112 because we wanted energy and the economy to coexist as what was best for all. SB 181 overrode our voters' wishes. Mineral rights and property rights are assets that have value, and our government should fairly be protecting these rights, not stealing them with their constantly changing mandates. I question why building permits for housing developments were issued within the setbacks, as this land for gas and development was purchased prior to them. The developer worked to meet all the now created exception requirements, so I don't understand what's allowing this questioning and denying of his rights to use the property as planned. The world's current situations make this assault on fossil fuel development lack of basic common sense. The safety and security of our country is better if we do not purchase energy from the world's bad actors. Europe has proven wind and solar does not sustain their energy needs, and the US produces the cleanest natural gas and oil and natural gas. So if your concern is climate change, then buying dirty fuels from other countries does nothing to help our planet overall. The inflation the US is currently experiencing is primarily driven by increased energy costs as they affect everything. Please quit making it harder for those that are trying to provide the American energy. Our economy and safety are more at risk than any time in my life, and American businesses have always innovated and found ways to improve our way of life. And this can happen again if government stops the constant regulating that makes long-term planning and investment impossible. Thank you for allowing me to voice my thoughts.
You for being with us this morning and expressing your thoughts. We now will hear from John Anstead.
Good morning, and thank you for giving me time to comment on the long speak application.
My name is John Anstead. I've lived in Colorado since 1977, and I currently live in Littleton. I'm a geologist and geochemist, and have worked in the mining and oil and gas industries, environmental engineering, environmental restoration fields for over 40 years. 40 years. I've enjoyed our beautiful state, clean water and air, and rigorous economy, and hope to see Colorado continue to be a wonderful place to live, work, and play. Our energy companies have striven to reduce their environmental footprints, be good citizens while providing much needed energy. And they have done so throughout many environmental challenges and regulatory changes. Our modern society depends on inexpensive and available energy. Particularly concerning is the apparent subversion of the definitive will of Colorado voters when in 2018 overwhelmingly passing Prop 112, clearly and decisively saying a very loud no to increased drilling setbacks. Since then, our partisan legislatures made an end run around that decision by foisting Senate Bill 19-181 and then House Bill 21-1266 on those same citizens. These bills seem more like edicts rather than the will of the people. Specifically related to the Firestone permit and recent updates, the Commission has the necessary tools to ensure safe drilling, development, and production. Kerr-McGee has proposed best practices meeting and exceeding those requirements, and the Commission staff agrees the application complies with the rules. Kerr-McGee should be allowed to develop the assets required well before new residential developments recently moved into their area. If someone didn't want to be near oil and gas production, one has to wonder why they moved to Weld County. I fear that unnecessarily heaping additional costs and unknown regulatory burdens on oil and gas developers will result in reducing the amount of inexpensive energy available to all Coloradans, ultimately chasing our energy companies out of our state, reducing good paying jobs and paychecks to hardworking Coloradans, as well as lost revenue to other businesses in Colorado. Overall, reducing many Coloradans' quality of life. Additionally, aggregate cost of lost tax revenue will result in significantly higher income or property taxes or reduced government services, school revenue loss. I urge the Commission to consider these very likely results and move forward and improve Kerr-McGee's application. Thank you.
Thank you, Mr. Onstead, for being with us. Yes, Hearings Manager Larson.
Just one quick question. We're looking for Sharon Anderson. If Sharon is in the meeting and could raise her hand, we will bring you in. Otherwise, we would move on to Raymond Lucas. Or excuse me, Randy Sutton, I believe, is who we have next.
I'm still here.
Okay, let's go ahead with Mr. Lucas, and then we'll come back to Mr. Sutton. And if Ms. Anderson shows up, we'll come back to her. Mr. Lucas, you have 2 minutes.
Thank you. I'm Al Lucas, and I've lived in Colorado for 57 years. And I've spent 31 years working for the largest utility in the state as far as gas and electric. I'm very familiar with working with a lot of the communities along those lines. There are some communities expressing concerns about the safety of gas drilling and maintenance close to homes and neighborhoods. And that limit is currently at 500 feet, but a few communities have pushed it to 2,000 feet. And it's changed a lot of things. The natural gas industry does have pretty exceptional safety results, from drilling, capping, storing products to meet customer demands and delivering to those who refine and serve directly to the customer. Here are the results of the industry over the past 11 years at the 500-foot limit. There were 2,464,164 housing units in Colorado at the end of 2021. In the last 11 years, there were 16 incidents across the state. These are the incidents at the type of wells that we're questioning today. The majority of these incidents were lightning strikes on storage tanks or leaks from the storage tanks and equipment. Unfortunately, 4 people lost their lives in these incidents, and 6 others needed medical attention. Only 1 home was affected from a natural gas well or line. That home was the home in Firestone. Please believe me, I feel that was a horrible incident, and no one would ever like to see this happen again. From the information I found, it appeared that the house may have been within that 500-foot limit, but I couldn't verify that for sure. One thing I'd like to point out, there's gas lines running throughout all of our communities, not just the ones from the wellheads, but natural gas that's served from all the utilities. We do this and operate them every day with virtually no issues, operate very safely. I'm concerned when we overreact to an occurrence and stop focusing on thought out resolutions that can improve safety. And I have to tell you, I was really impressed with what I heard today with everybody trying to work together on that part. So that was I was really glad to hear it. I think the idea that we could stop drilling, that as I'm hearing that more and more, they're using every idea they can to stop drilling in Colorado. If we do that, that will kill our economy. If you look at the results of current safety requirements in the communities, it's not perfect, yet very few issues ever occur. Only one home was affected in more than 11 years. More stringent guidelines have been added to the drilling, maintenance of wellheads and lines around them from what has happened in the past. Many people are using those excuses, like I said, to put this stuff down and to get us out.
Please.
Here in Colorado, we have a very defined guidelines to ensure wells are not left unattended, and efforts are underway to make sure old wells meet the guidelines. The new proposed rulings will significantly change the abilities of industry to maintain all abandoned wells because more businesses will be out of business and won't be able to maintain those lines. And one of the considerations I would ask the commission to do is make sure we look at all angles of this. It's not just an issue of safety, and I'm not a hard-nosed guy that says it's got to be 500 feet. I mean, we all know we have to develop our communities. We have to work around those issues. But when you start out with 2,000 feet, you're effectively—
Your time has been up for quite a while. If you could wrap up, please.
Okay, and if you just look at all angles of our request to make sure that we cover all the things fairly and make sure we don't kill our economy in doing so, that's what I would ask.
Thank you. I think we have Randy Sutton next.
Hello, my name is Randy Sutton. Thank you to the commission for listening to these comments. These comments are in regards to the updates made since the last hearing. I am from Arvada, Colorado, and I am a father of 4 with all my children are under the age of 6. So I'm a millennial, which is a little different than a lot of the people here. And this is all kind of new to me. I'm 37 years old and I'm starting a new business, and I care because the rising energy costs affect my ability to conduct business and provide a living to support my family, which is a wife and 4 kids under the age of 6. So it's all new, a lot of diapers, a lot of diaper changing. And I want to provide jobs for the electricians who work for me in my business, Watermark Electric, and give them the ability to provide for their families. I'm a native Coloradan and I've been here for my entire life. So as I see higher gas prices make everything more expensive for me to conduct my business, commodities, materials, labor, insurance, healthcare. So as we're already suffering from the inflation of COVID-19, the added inflation for energy costs is really tightening down on my ability and what I can actually do. So I love the earth. I believe that God created humans to use its abundant resources, steward them well, and learn from our mistakes. But for practical reasons, we cannot throw the baby out with the bathwater here. Let's work together and try to make this something that we can come together on. So please consider the impact on small businesses and working class families. So please give these permits to so that small businesses can survive. Thank you.
Thank you, Mr. Sutton. Commissioner McGowan.
Thank you, Mr. Chair. I just for clarification, we're having public testimony right now about this particular proposal in this OGDP, correct?
That is accurate.
Okay, so I would really appreciate if folks could focus on the OGDP that we're considering and their comments about the proposal, so we could focus in a little bit. That would be appreciated.
I think that's the point that the reason we're having public testimony today at this time, instead of this morning, if you just wanted to talk in general about oil and gas development.
Great. Thank you.
Mr. Chair,
Forrest. Yes.
yes, next up we have Scott Cozy or Koski, forgive me. He's calling in on the telephone, so we will unmute him and proceed with his public comment.
Good morning. Can you hear me just fine?
We can hear you just fine, Mr. Koski.
Okay. I apologize for the lengthy. I was told as well as others that this was going to be, we were going to be provided 3 minutes. Good morning, and thank you for allowing me to speak at this hearing. My name is Scott Koski. I'm a 59-year-old native Colorado living in Wellington, Colorado. By education, I am an engineer with extensive international experience and possess a unique combination of being an independent rancher and farmer with my wife. The changes invoked by the state of Colorado, beginning with the Senate Bill 181 toward the oil and gas industry, starting in December 2019, have severely impacted our operations. Well County operates a gravel pit on our farm. Incomes of $7,000 to $10,000 per month were enjoyed during the boom years of the oil industry. The gravel from our pit maintained or built new roads and was the base construction material for the oil drilling pads. Since December of 2019, the incomes from the gravel pit have dwindled to a meager average of $150 a month. This reduces the potential taxable income for the state of Colorado by $80,000 a year. This reduction in revenue, combined with the increase in fuel, maintenance, and equipment costs, have caused us to scale back our farming and ranching operations, equipment maintenance, thus forcing a reduction in our livestock herd sizes. I fully agree we need to live in a world with breathable air and potable, drinkable water that can be used currently and passed on to future generations. However, I do not support rules, regulations, and means which sacrifice and kill the primary income generators for Colorado. I ask this commission to carefully review and understand the long-term impacts of the new proposed stringent requirements. They will only result in costs continuing to skyrocket for oil-based products, the fuel put into your vehicles, and those used to transport all consumer goods. The end result for all will be less income left to live on, business stagnation, and most likely worse, more business failures. If the naive thinking that the Russians and OPEC will beckon to the United States pleas for help for energy, please remember the impacts of the early 1970s OPEC oil embargo and the Black October of 1963 during the Cuban Missile Crisis with the Russians. Once again, I ask this commission to carefully review and understand your impacts you're going to create by decisions you make today. Thank you for your time and the opportunity to speak.
Thank you. Now we have Marty Anderson.
Thank you very much. Thanks for the opportunity to address the commission today. My comments are in response to the updates from the last hearing. Again, my name is Marty Anderson. I'm a resident of Colorado for over 25 years. I am in the energy business. I have friends and family that are in the industry. I live in Larimer County, and I see the value of the oil and gas industry here and along the Front Range. Businesses benefits for over 400,000 jobs from the oil and gas industry. I know friends and family that own coffee shops, restaurants, service companies that all benefit from this industry while it's going strong. I see families getting good health care from these companies, good pay, and paid time off. I do feel that if we increase restrictions and restrict permits further, like the ones in the Firestone area, it will impact these families both in and out of the industry. Wouldn't want to see any families losing health care and businesses struggling on top of coming out of this COVID restrictions. We don't need to see any increases in unemployment or lost revenue. I do enjoy having the freedom that we have here in Colorado, the ability to travel the country. Having energy independence allows us to travel unfettered. I feel that if we continue to restrict permits, we're going to increase our dependence on imported oil, and we will run the risk of limiting our abilities to enjoy our freedoms. I thank the commission for allowing me to speak, and I do hope that you vote in favor of these permits passing. Thank you.
Hearings Manager Larson, who do we have next?
Next up, we will hear from Michael Jones. If Conrad Hop is in the meeting and could raise his hand, we will hear from Mr. Hop, but I don't see him at the moment, so we'll move on to Mr. Jones.
Thank you for the opportunity to speak to the commission. I appreciate you hearing my comments.
Mr. Jones, could you move a little closer to the mic? It's really hard to hear you.
Okay, is that better?
Yeah.
Okay, I'll speak a little louder. I'm Michael Jones. I live in Firestone. My family and I have lived in Firestone for 14 years. I'm an IT consultant. I fulfill contracts lasting between 2 weeks and 2 years in an area stretching from Castle Rock to Fort Collins so far. My family and I chose to locate our household in Firestone because it's close to the highways and we enjoy the quality of life the community provides. Location has enabled 2 of our children to commute to pursue their degree programs in Boulder and Fort Collins. My livelihood depends on being able to service IT clients in this large area. My family and I enjoy the freedom that our location and mobility allow. We have sparse access to public transportation, depend greatly on our cars to get around. We've enjoyed becoming established in the Firestone community, being able to choose from a broad variety of professional and personal pursuits. Freedom to choose is the keystone of our well-being. Some of us like to hike, others like to ski. Some enjoy Denver's cultural and entertainment options. All require transportation and energy. How can we say not in my neighborhood and not in my backyard when we expect others not to do the same? Allowing responsible exploration and production is not too much to ask, and we ourselves have a substantial energy facility less than 2,000 feet from our own home. It's been no burden at all. We barely know it's there. That our area's history has given it the nickname Carbon Valley is a proud tradition. As we persist in our lifestyles and livelihoods in a way that gives us continuing freedom to choose, I ask that we enable the responsible exploration, production, and transport of the energy that it takes to make it possible. Again, thank you all for allowing me to share my family's story.
Thank you, Mr. Jones. Ms. Larson?
We may have Mr. Hop. A person on the telephone has raised their hand, so we'll allow this person to talk, and hopefully it's Mr. Hop.
Telephone number ending in 0526, please unmute yourself. That might be.
Can you hear me?
Yes, we can.
Thank you. My name is Conrad Hop. My wife Martha and I live at 11413 Well County Road 13 in Firestone, where Martha was born 84 years ago. She was the youngest of 7, and all 7 growing up on the same farm. I was raised north of the St. Vrain River, now known as Barefoot Lakes subdivision in Firestone. In the late 1800s and early 1900s, it was known as Hayseed Land and Cattle. William F. Cody, aka Buffalo Bill, owned the property. Just a bit of history. Agriculture has been our livelihood for 3 generations. Thank you for giving me the time to share my thoughts about the town of Firestone. These comments are in response to the updates made since the last hearing. Look how far we've come in just 30 years. Martha and I both remember when Wall County 13, now Colorado Boulevard, was a dirt road, and the only lights you could see for miles was a ball field in Frederick, Colorado. I was 8 years old when we finally got electricity.
I grew up thinking a three-room house with a bath was being modern. We both grew up here and feel we are part of Firestone's history. Now we need to look at the larger picture. What made it possible for Firestone to grow? Infrastructure, electricity, domestic water, sewer lines, oil roads, and natural gas, which is today's topic. Think about all the tax money that goes into these cities, counties, and schools from the petroleum industry, which has been beneficial for all these industries. Mineral rights should not be taken away from owners without compensation. If you have water rights or land rights, those rights are not taken away, and neither should your mineral rights. We all care deeply about the environment and need to keep in mind the greater good that comes from the oil and gas industry. 1/2 of every barrel of oil is used for things like ballpoint pens, floor wax, tires, sports helmets, basketballs, footballs, dashboards for vehicles, life jackets, antihistamine drugs, insect repellent, speakers, water pipes, guitar strings, heart valves, crayons, and soft contact lenses, just to mention a few. There are over 6,000 items made from petroleum. Just look it up. Do you want to depend on other countries for natural resources, or do you want to use your own natural resources? Make sure you consider these vital aspects when you make the decision, do we drill or don't we drill? I personally receive a royalty check every month for many years, and I hope this month's check will pay for my hot water heater that went out and the garage door that don't work. But it sure makes retirement for two old people a lot easier. And I thank you for allowing me the time for these comments.
Thank you. We now will hear from Peter Cunningham.
Good morning. My name is Peter Cunningham. I'm a 60-year resident of Fort Collins in Larimer County. My family arrived in 1873 and began farming, eventually moving into oil and gas production in the 1920s. They continue to do so, and today my daughter and her husband, my grandson and his wife all work in energy production. They have good paying jobs that allow them homes in an expensive real estate market, new vehicles from local dealerships. They can purchase goods and services from small businesses in town. They send their kids to local schools, and they enjoy Northern Colorado's beautiful environment. The energy industry has provided money for them to do that. They put their payrolls put money in the pockets of thousands of workers across Northern Colorado, and that includes Firestone. Money is spent supporting Colorado jobs, Colorado businesses, and Colorado communities. Severance taxes and fees fund local schools. They fund local infrastructure, and they fund local social programs. The energy industry has been a great neighbor to small communities in Colorado. Now, we all breathe the same air. We drink the same water. We eat food grown on the same land. So, of course, we all have a dog in the fight when it comes to high environmental standards. But we can go overboard. Diminishing returns on investment, less gain for the money spent. We have to set standards, and we get them set by people often that are outside the industry and may or may not have any idea how to make them work. More important, it seems that ever-changing standards complicate matters beyond what they should. Businesses like stability and predictability so they can plan and execute. The energy industry is no different, with all the moving parts and all of the timelines and things. All these changing regulations complicate matters. So rather than driving the energy industry wages and severance taxes to lower cost states, keep Colorado energy friendly and energy responsible, grant the permits and keep the production moving. Taxpayers and local governments will appreciate it. Thank you.
Thank you. Are we now moving to Ms. Scatberg?
Yes, we are. Mr. Pasco was to call in. I do not see Mr. Pasco's phone number, and I don't see him in the meeting. So if Mr. Pasco joins us at a later time, we will bring him in then.
You ready for me?
We are ready for you.
Perfect. Hi, thanks everyone. My name is Lindsay Scapberg. Been living in Colorado for 32 years. And you know, we are really blessed to have an abundance of natural resources here. We are blessed. Yet our state and local governments want to restrict the ability to access them. And I'm wondering why. When the energy industry in Colorado has proven itself to be one of the safest and most responsible in the country, if not the world, and I don't say that lightly. Oil and gas prices are currently the highest they've been in 13 years. I'll add to that from CNBC today, and Commissioner McGowan, I do believe this is relevant to the local pad, that the consumer price index for February rose 7.9% from a year ago, the highest level since January 1982. Excluding food and energy, both of which moved sharply higher during the month, core inflation rose 6.4%. Gas, groceries, and shelter were the biggest contributors to the CPI gain. However, worker paychecks actually fell further behind. If you want an idea about what your communities and constituents care about, just check out what they're discussing on social media sites like Nextdoor and Facebook, because I know I have. There's a lot of concern over sky-high energy bills, the cost to fill up their gas tanks. This is real stuff. The cost of groceries and household products. Why do we want to inflict further pain on people that are already struggling? I don't understand it. Take a look at the price of oil and the price of natural gas. We have sites like the Longs Peak development that are ready to go. We need to develop those resources for our constituents and our communities. We have the ability to help them. The Longs Peak Oil and Gas Development Plan has been run through the environmental study process. Please approve the project. Thank you.
Now we'll hear from Tim Walter.
My name is Tim Walter. I have lived in Colorado since 1983 and in Arapahoe County for the last 25 years. I'm here this morning to express my concern about recent regulatory updates of this development plan being considered by the Commission. I'm 2 months retired. My wife and I have looked forward to our new freedom and planned many an adventure in and around our state. But instead, we're already feeling anxious about our future and the future of others like us. I've done my best to plan and prepare financially, but between Washington, D.C. and the state of Colorado lawmakers and rule writers, my fixed resources are threatened by the increased price of everything, and there's little evidence that the government even cares. Farmers and small businesses are hard hit by their own rising costs, and their pain is just passed on to the rest of us. With historical inflation, rising fuel costs, and compounding regulations in every category, literally every product and every service, including groceries and basic essentials, is seeing prices increase and availability decline every single day. And it's only going to get worse. By adding regulatory burden on Colorado's oil and gas industry, our own heating and electric bill is growing as well. Everything is impacted by these restrictive controls that serve no proven benefit other than to make it harder and harder for energy companies to source the energy we need. Even our state's economy is jeopardized, and now national security has emerged as a major issue. I'm not the only one who's anxious. What about those sick, disabled, and elderly who are barely meeting their own needs now? How will they manage? I hope as a governing body you share my concern. And what about those public services like schools, healthcare, and social services that depend on money from severance taxes to serve Colorado citizens? It's citizens of this state who rely on a little help and those resources to live a meaningful and worry-free life. Creating increasingly restrictive standards not only adds significant to production costs, causing prices of everything we touch or consume to climb. Colorado is a beautiful state with great
Walter, your time is up. If you could wrap up, please.
All right. There is reasonable balance to be found, especially at this time, between protecting our environment and affordable way of life. I'm asking you, please, to carefully consider your decisions and the regulations you're responsible for, and to approve permits for drilling companies within setbacks already established and the impact they will have on citizens and small businesses in Colorado. Thank you.
Now we'll hear from Jeff Stoll.
Thank you, Commissioner, for the opportunity to speak to today about the recent updates to the Kerr-McGee Longs Peak OGDP. My name is Jeff Stoll. I have been a resident in Colorado for 40 years, currently residing in Westminster, Colorado. I am a retired public health official, having served local and state levels of Colorado government for 30 years. I'm still active in public and environmental health practice through my own private consulting business. I also drive for Uber to supplement my income. I love Colorado and very invested in the future. I am concerned with the precedent that would be set if the commission should decide to deny approval of this application for oil and gas development on property that was arranged before setback requirements were decreased. And yet the applicant has faithfully addressed the new requirements promulgated since. The application has been approved by local processes of Firestone. A denial of this application would marginalize the processes, steps, and standards that have been established by the COGCC as well as other state agencies. If these policies can't be followed locally and at the state level with a reasonable certainty of success, then the whole program is arbitrary. No industry would survive in that kind of regulatory environment, and there go the small businesses that support them. My Uber driving has supplemented my income by about 30% in the past couple of years, and my cost for fuel has almost doubled in the last year, but the fares have stayed the same. Plus, people are less able to tip as we all feel that squeeze. We face local, state, federal, and global economic and political chaos right now. And therefore, I ask that you approve this permit and leave an open door to provide balance to sustain the well-being of the people, environment, and survival of small businesses of Colorado. Thank you.
Thank you, Mr. Stoll.
Mr. Chair, next up, we have Mr. Stephen Bentz. I've been trying to bring him in as a panelist. Just a reminder to folks who signed up for public comment, we're trying to bring people in ahead of time so we can move quickly through this, so there's not a lot of delay. So if you receive a request for me to become a panelist, please accept it.
Good reminder. Thank you. Looking for you to unmute yourself, Mr. Bentz.
Yes, I just found that block. Thank you very much. Sorry about that. Yeah, hi, my name's Stephen Bentz, Staff Sergeant, retired U.S. Army. I am right now currently retired and have been joyously retired for several years. And I would like to go ahead and continue to do such, but from what I'm seeing with the cost of fuel as it is today, it's going to be tough. I'd just like to first garner my comments in regard to the update since the last hearing. I think what I'm seeing here is Kerr-McGee seems to be a very well-established and very reputable company. They have dotted all the I's, crossed all the T's, and they have complied with absolutely everything they've been asked to comply with. And I really think that right there speaks volumes as far as that goes. I moved back to Colorado Springs from Germany in the beginning of 1989. I was a realtor here in this town in El Paso County, Colorado Springs, for 15 years. And in the whole time I did that business, I never had anybody ask me about oil and gas company setbacks, not once, unless they were maybe from California, but nobody even asked. From what I'm seeing right now, having run my business then, and I haven't been in real estate since 2009. We all know what happened in 2008. And I'm seeing the cost of everything right now in El Paso County is going up. And it's not just El Paso County, it's the whole state of Colorado. And it's all tied into the oil and gas. What I'm afraid of is to deny these permits at this said point in time would set a very, very bad precedent for the state We all know that the cost of getting to and from is getting more and more expensive. I would implore the people who live in Firestone, you move there for a reason. You may be moving back to Denver for a reason. You can't afford to drive anymore. So I would, again, thank the board for their time, and I hope all goes well. Thank you.
Thank you. We now will hear from Austin Nesselrode.
Yes. Hi, my name's Austin Nesselrode. Thank you for taking the time to allow the public to comment on the recent updates since the last hearing. I've lived in Colorado Springs for over 18 years. I support the oil and gas industry because of the high utility costs plaguing many individuals and families in El Paso County. My church operates a warming shelter, senior lunch program, food pantry, and had to pay over $1,400 in the month of January of 2022 for heating and electricity powered by natural gas alone. I advocate for approving the operator to drill because they will produce within the guidelines set by the commission and can help lower the price of natural gas for the next harsh winter we may face in Colorado. Thank you.
Thank you.
Next up, we have Mr. John Sprouse. Another reminder, if I ask you to become a panelist and you've signed up to speak, please do accept that request unless you do no longer wish to speak. Mr. Chair, it doesn't appear that Mr. Sprouse wishes to speak any longer. We'll move on to Bill Hall. Mr. Hall, if you have seen the request to become a panelist, please accept it and we will bring you in. Mr. Hall does not wish to speak. We can move on to Stephen Yazzie. Mr. Yazzie is coming in.
Very good.
Start video. Am I on here?
Your video is not on. Got a couple of
There
kids
it
looking
is.
up and down. There you go.
Thank you. And thank you for the opportunity to speak today on the Longs Peak application. My name is Steve Yowsey, and I've been a Colorado resident for 45 years. I live in Northglenn, Colorado. And seen a lot of changes in the state over the time. And so I think we all care about the environment, and that's why we're all here. But I wonder why we're willing to stop domestic oil production in the name of environmentalism while supporting oil production from dictatorial regimes that care nothing about the environment. And we're talking about Senate Bill 181 that went into effect after these permits were already obtained and the setback rules were put in place. And I understand those setback rules were in response to an accident in 2017 in Firestone that fostered Senate Bill 181. And although that was tragic, many safeguards have been put in place since. And the cause of that accident have since been mitigating, making production much safer than ever. In Colorado, one of the biggest, cleanest energy producers around. As a concerned resident of Colorado, I believe we are all after the same objective: safe, clean, environmentally friendly energy. And with the recent developments in Ukraine, we need domestic production more than ever. With the national average a gallon of gas over $4.30, it's the highest ever in history. And I don't understand why we're willing to send jobs overseas while putting US citizens out of work. This is just hurts those that can least afford it. So I just urge you to approve these permits so that small businesses and local economies can survive during these challenging economic times. Thank you.
Thank you, Mr. Yelsey. Elliot Barton.
Hello, good morning. I guess it's still morning. My name is Elliot Barton. First of all, I wanted to say appreciate all the time and effort that's been put forth on this proposal. My comments are in response to the updates made since the last hearing. And my name is Elliot Barton. I live in Aurora, Colorado. I'm the founder and CEO of BNG Clean Fuel and a Colorado native for almost 65 years coming up in May. I'm a Vietnam era veteran. I've served in many business capacities in my professional career, and particularly in energy development, including solar, oil and gas exploration, and clean energy fueling development, first with LNG, liquid natural gas, and now with blue and green hydrogen production. My concerns and testimony are specifically intended to support the common sense development of this proposed location, preserve the integrity of the environment, the oil and gas industry, its many employees, the tax base that the industry provides to the citizens of the state of Colorado, and also to address critical and strategic national security issues. It's my intention to support the obvious need for ongoing oil and gas exploration and development at this proposed site and others for the foreseeable future, because the up and coming clean energy alternatives are, from my professional perspective, going to take many years to develop, but they will develop. And moving forward from that is that by drastically limiting the accessibility of exploration activities that are above and beyond the necessary safety requirements that are already in place, we as a state of nearly 6 million people will face great financial, national security, and major global ramifications. We need to take particular note of the global geopolitical tragedy occurring in Ukraine, with the realistic potential of expanding into other parts of Europe, which will continue to create crisis level concerns for energy production. Redefining exploration, permitting, and further limiting new drilling activities will create enormous community stress, loss of jobs, and significant tax base loss that will severely impact school districts, infrastructure improvement, transportation, and much more. Job loss of thousands of industry people will also affect the tax base as well. And thank you so much for your time and effort on the behalf of the citizens of the state of Colorado.
Thank you, Mr. Barton.
Yep.
I believe we now got Mr. Sprouse, who is with us. We had skipped him earlier because we couldn't find him. So if you want to unmute Mr. Sprouse.
There we go. Okay, I'm live, and thank you very much for the opportunity. I apologize for missing my spot. Just time flew. I'm John Sprouse. I'm a 25-year resident of Colorado and a 45-year petroleum industry retired professional. I support granting this permit request after the last proposal made by Kerr-McGee. The following reasons are: one, it meets the requirements for waiver of spacing. Two, it addresses the concerns of many with location selection, multiple revisions, multiple reviews, environmental concerns, and allows the operator to access the most reserves of each alternative. The town council voted 4-1 in favor of it. These development plans have been discussed since 2019, at least that's my understanding, with developers and the time. With this plan, the operator is going to plug 39 wells as a result, and the revised plan. The revised state spacing rules were implemented after voters turned down a referendum in 2020 and the legislatures went ahead and did the new spacing rules anyway. That's not the point. I'm sorry if residents were not made aware of by their realtors and developers. It has never been a secret. It's also no secret that the town and the area uses the revenues from oil and gas operations to make a better place, improve schools, parks, and form a robust economy. The U.S. is currently being harmed by our internal destruction of energy development. Let's not be the cause of continued rising prices because we don't develop our own resources. I ask the commission to pass this permit and continue to work with industry to continue respectful, safe, environmentally sound development. Thank you very much for the opportunity.
Thank you, Mr. Sprouse. Commissioners, our agenda calls for a 30-minute lunch break at noon. We're a little bit past noon. We still got quite a few public commenters, but I think taking a break does make some sense. So I would suggest we break now and come back at, let's say 12:40. That'll give us about 34 minutes or thereabouts to grab something to eat. Yes. We are waiting on Commissioner McGowan, I believe. So let's give her a second or two. All right, we are all here. We are ready to go. And we will start the afternoon public comment with Mr. Bill Hull, who I believe is with us. You have 2 minutes, Mr. Hull.
Can you hear me? I'm not seeing any video.
We can hear you. Yes.
Okay, very good. Again, as you just said, my name is Bill Hall. I was born in Greeley and live east of Greeley. My family's third generation Weld County residents. These comments that I'm going to make are in response to the update made since the last hearing. I'm very active in the community up here. I've served on the Weld County Planning Commission, Weld County Master Plan for 2 years, and I'm supporting Kerr McGee's in the Long Peak permit. I feel like that these folks have done everything that they can, agreed to the terms that the town of Firestone has placed in front of them. And, you know, I think it would be a disgrace, or a disservice rather, not a disgrace, disservice if the COGC ruled against them. I was formerly in the oil and gas business, and we used to have such a great relationship with the group. It wasn't adversarial at all. We worked together to have some of the cleanest drilling and oil and gas production in the world here in the state of Colorado. Would also like to speak to the fact nobody's really mentioned the people that own the minerals on this property. And I've seen it up here in Greeley that it's really a huge support to our community, the farmers that have the opportunity to have wells drilled on their place and then get the monthly checks. Also would like to reiterate, we have the cleanest oil and gas production in the world, and please consider the precedent that you'll be setting with this permit. You're not overriding the town of Firestone, you're going along with them, and I think that's an important part of the Oil and Gas Commission. Thank you for your time today.
Thank you, Mr. Hall. Ms. Larson?
Mr. Chair, we can hear from Mr. Darso next. I've been asking if he would come in as a participant or, excuse me, as a panelist. He's been declining. So Mr. Darso, if you wish to speak, please come in. We do have Patrick Purcell in the meeting who could speak in the interim.
Hi there. My name is Patrick Purcell. Can everybody hear me?
Yes.
Hi, I live in Firestone. These comments are in response to the updates since the last hearing regarding the Longs Peak facility. My family has been in Firestone for 124 years. My great-grandfathers were proud coal miners here in this town and eventually operated a real estate business and a grocery store here. I am married and raising 2 small children in this community. I have worked in the oil and gas industry for over 10 years. I have worked on hundreds of wells in and around Frederick and Firestone and Weld County. I have personal stakes in this industry and in this community. My many job positions in this industry have required that I work right on the well. I have done so through the drilling process, fracking process, all the way up to the production stage of a well, maintaining the automation devices and technical devices that run the pad, the whole life cycle. My hands are on them all day, not 500 feet away or 2,000 feet away. I do not have cancer. I do not have hearing loss, and I do not have a respiratory disease from doing so. The proposed site for Occidental is less than 1 mile south of my home. My 84-year-old father lives less than a mile from the proposed site, and a sister lives right down the road. My 3-year-old son goes to daycare right down the road, about a half a mile from this site. And within a 1,000-foot radius from my home are multiple oil and gas facilities. And on a quick trip to either grocery store in town, I pass dozens of wells, some old, some new. I know what each well means to my community, both good and unfortunately bad. Energy extraction is not new to this town or the region. There are wells all over Weld County, Lerner County, Boulder County, and Adams County. What is new are the vast number of housing developments, as well as the rapidly shifting demographics pouring into our community, most of whom are tech industry workers with no community roots, zero energy industry knowledge, and its valuable contextual relationship to our community, zero. My tenure in the oil and gas industry has taken me all over the country. Colorado's oil and gas policies are top notch. We do it better, safer, and cleaner here. From the start of a well to the completion of a well, Occidental takes every action they can to please the communities they operate in. They absolutely go above and beyond regulatory obligations set by the state more so than anyone else. They are responsible, good faith operators with the resources to action those ethics. And they are the crown jewel of operators here. They spare no expense. So they take safety and community engagement seriously, and I have no qualms with them operating in my backyard as they're already here. I see no reason why their proposed project should be hindered, especially in today's geopolitical climate. So please consider their plans. Thank you very much.
Thank you. Next, we have Omar Urigla. If you want to speak, you need to unmute.
Okay, I think I got it now. Good morning. I would like to thank the commission for the opportunity to speak today. My name is Omar Aroglu, and I'm a resident of Thornton. And my comments are in response to the updated situation with the Longs Peak site. I'm in the transportation service business. Cost of energy affects me in business and at home. As a country, we are fortunate to have such supply of these resources, and it is in our interest to produce as much of it as possible to provide it to all consumers at a reasonable cost. Energy industry provides many high-paying jobs, generates all-important tax revenue, and supports many side industries, and sustains just about every aspect of our lives. We should not and absolutely cannot take for granted the importance of energy development, and we must do everything we can to become and stay energy independent. It is true that since the site has been permitted, it is not fair to have a development come in and take away the rights of the small businesses that would be affected with this less than 2,000 feet rule. It is very important for us to keep and maintain our energy efficiency and energy independence, especially with everything that's going on around the world today. I would urge the commission to approve the permit for Longs Peak as it has been requested. And I thank you for your time.
Thank you.
Mr. Chair, next up, we'll be hearing from Sharon Anderson.
Okay, she was earlier on in the list, but now we have her.
Yes.
Thank you. This is Sharon Anderson, and I am a resident of Colorado up in Fort Collins, and I am making these comments being related to proposed changes at the most recent hearing. I'm an educator of at least 28 years, obviously a taxpayer here in the state of Colorado. I believe that we all value education and see it as an important investment in our state. And I am asking that the decision makers, the commission, consider their upcoming decisions and how those decisions would have impact on things that actually support education, such as gas and oil production in our state. I don't have the figures as to how much revenue comes from that industry, although I am relatively sure that it is quite a few dollars. And as an educator, I would hope that decisions are looked at regarding how this industry is looked at and valued in the state so that we can continue to have a strong educational system for our citizens. So thank you. This is, again, Sharon Anderson, and I appreciate you letting me jump back in.
Very good. We now will hear from Janet Jewell.
Good afternoon. I'm Janet Jewell. I'm a resident of Loveland in Larimer County for over 50 years. What I'm sharing is in response to the updates that have been made. My concern is the challenge facing the Occidental Oil and Gas Company in Firestone. They have met all the requirements, and now it's a question whether they will be allowed to begin drilling. From what I'm seeing is that the oil and gas companies have been working really hard to meet all the requirements that the counties in our state have passed for the oil and gas companies after the passing of Senate Bill 181. And now it seems that's not enough. And what I worry about is that not letting these companies do it and making more requirements for them will set a big precedent. Colorado used to have a booming oil and gas industry. Our counties have benefited through the years from the taxes that these companies have given us, especially our Colorado school districts. And I am a former school teacher in the state. We need to work together to keep our state attractive to all companies because all industries are tied in some way to the oil and gas industry. I want to see our economy strong in Colorado, as I know you do too. The oil and gas industry has been and should be still the backbone of this state. Now we need these companies to stay. I'm asking you to work with them and realize the importance of this industry as you do to our state. So please approve the site in Firestone as they have met all the requirements, and also for future oil and gas applicants when they do meet requirements from what you've passed. I urge you to stay with the regulations that have already been passed, and I want you to support oil and gas in Colorado, where our local communities do reap those benefits. Thank you for your time today.
Thank you. Now we'll hear from Scott Walker.
Yeah, these comments are made in response to the update made since the last meeting. I'm Scott Walter. My family and I have been residents of Weld County, Colorado since 1994. We have lived within 300 foot of an oil and gas well and a quarter mile of a tank battery for 25 years with no ill effects. I've been employed in the oil and gas industry for the last 46 years and have seen many ups and downs in the oil industry. Some of these are created by unfair regulations that the oil and gas companies have to deal with. While we support clean air and environmental standards, this industry should not be held to a higher standard than other industries. I believe it is time for the state of Colorado to stop the attack on the oil and gas industries. The residents of Colorado voted to stop the setback rule with 112, yet here we are with the rule in effect. I believe all these new regulations are harming the economy of the state and making this state to be viewed as a state that is not friendly to the oil industry. I received Anderson reports for drilling permits for the Rocky Mountains. In past years, every month there are numerous permits for drilling to the state of Colorado, but in 2022, permits for the state of Colorado are very few in number, while other states are permitting wells every week. I've owned an oil and gas service company located in Greeley, Colorado since 2004. Our company has 20 employees, all with families who live in and support our local communities. We pay high taxes to the federal and state governments and collect thousands in sales tax for the state of Colorado and do other oil field companies. 55% of Weld County schools funding comes from oil and gas taxes. Who's going to step up and pay these taxes if the oil and gas companies no longer want to do business in the state of Colorado? I urge you to approve this project, and I urge you to approve drilling permits to allow small businesses to survive. And I thank you for this opportunity and allowing me to comment.
Thank you. We now will hear from Chris Nelson.
Yes, my name is Chris Nelson. I'm a journeyman electrician from Loveland, Colorado. These comments are in response to the updates that you have made since the last hearing. I agree with the mayor and city manager of Firestone that they approve the well site. Kerr McGee has worked with the town of Firestone since 2015, 7 years. As you, as commissioners, are aware, Colorado has the most strict oil and gas regulations in the world. And so much of our economy through taxes and so much of what goes on in government is affected by the economy of the state, which depends very largely on oil and gas. Our national security depends on it. And there is no good reason we should sit on the largest deposit of energy in the world if we don't, with it being well-regulated and these people having gone through every single hoop to get this far. Think of the precedent this will set if this is turned down, if this well site is not permitted. I respectfully ask you to approve this site and to further our independence in energy, because it's the only thing that keeps us a first world country. I thank you for your time.
Next up is David Jewell.
Yes. Good afternoon, commissioners. My name is David Jewell, and I'd like to thank the commission for allowing the public to comment on issues and decisions that affect them. I started my business in northern Colorado 50 years ago and covered Colorado and the surrounding states, many of them supported by the oil and gas and energy industry. We support thousands of businesses and families. Over those years, I was able to pass my business down to a family member who was expanding the business even more. But certainly the effect of the Senate Bill 181 has affected his business. He just recently hired a person from the oil and gas industry because he had lost his job. All we want is fairness in the state with regards to how the rules and regulations are applied to businesses, contractors, and individuals. It is my understanding that the approved well site in the Firestone community by Kerr McGee and Occidental is now being questioned due to events and actions after the approval. Well, my comments that I'm making here are in response to the updates since the last hearing. The planning and cost to the approved application is considerable. It's been going on a long time and should be approved. The planning and cost to approve the application is considerable. And because of this, we support allowing the project to continue as approved with no new requirements added. We are in support of the approved Longspeak application, and thank you for listening to my comments.
Thank you. Next, we have Keith Lemie.
Thank you. I am Keith Lemie from Colorado Springs. My comments are in direct response to the updates from the last meeting. I am not and never been a worker in the oil industry or the gas industry other than the end consumer. I want to talk about how my experience when I was in the military, that my last duty station was with 3rd Armor, which was in charge of guarding the Fulda Gap in case the Russians came through and tried to invade West Germany. I think the actions that has happened over there where the Russian vehicles ran out of gas showed why we need to keep a good supply chain open and available because I'd hate to see we'd have to insert gas rationing as they did during World War II. So I'm in favor of granting in the permits to allow them to drill for the gas and oil. And using some of my experience as a union steward where I was working for the post office, I'm just afraid of the precedents that this ruling could have on the future of the gas and oil industry in Colorado. That's all I got. Thank you.
Next, we will hear from Bev Hargrave.
Good afternoon, Commissioners. Thank you for the opportunity to speak with you today. My comments are in response to the updates made since the last hearing. My name is Bev Hargrave. My husband and I have lived in Colorado for 17 years. I'm a realtor with my own business in Colorado Springs. On a personal level, as well as on a business level, the inflation we've experienced in the last year has negatively impacted all of us. Soaring gas prices, utility rates, higher priced food, out of control medical expenses. Financially, it has made it difficult for many of us. Inflation is at the highest level in 40 years. 13 months ago, we were energy independent. Today, that's no longer true. According to the Colorado Office of Economic Development, Colorado is home to over 653,000 small businesses, accounting for about 99.5% of all businesses in Colorado. Your decisions will impact these businesses and individuals significantly with possible unintended consequences. I know you all are aware of how many ways we use oil and gas beyond fueling our cars and heating our homes. Wind turbines and solar are dependent on petroleum-based products, diesel fuel, and natural gas-fueled furnaces. All plastic is made from petroleum, and plastic is used almost everywhere. Commissioners, you've been given a sacred trust to serve the citizens of our great state, and I strongly urge you to support and protect an industry that we as individuals, families, and small businesses are dependent upon. And I ask you to help us ramp up our level of production of both oil and gas, and to approve permits to allow for small businesses to survive. I thank you for your time.
Thank you. Do we have Mr. Smith next? Is that right?
Mr. Smith just accepted my request, so he should be coming in.
Okay.
Can you hear me?
Yes.
All right. My name is Randy Smith. I am a 35-year resident of Colorado. I've lived in Thornton for over 30 years. I just relocated to Firestone. We bought a house in Firestone that is within 2,000 feet of this proposed site. We moved to Firestone because we wanted to live in a more family-oriented and open community. And that's what we found in Firestone. We have listened to all the demonstrations put on by this oil company. We feel that they run in safe operation. We feel that all the safety precautions that need to be taken care of that are prescribed by law have been followed. To the minimum, at least, I think they've gone above and beyond on some of those things. I have experience working with city boards. I was on a city board with the city of Thornton for over 11 years, so I understand the planning process. I understand how this works, and I am in favor of this site being built and moving forward. I do not think it negatively impacts the residents. Like I said, I'm within, it's out my back window. I can see what's going to go on. I know what's going to happen. I think I've read all the literature. I've seen all the pictures. I know how it's going to impact us in the short term and the long term. And I think the impact on the short term does not outweigh the benefits in the long term. I think one of the reasons we wanted open space and a community feel, and I think we would lose that if this did not pass and go through. I mean, I do not want to have something else in that community that would be even worse. I have grandchildren that visit. My wife runs an in-home business, and we are in favor of this project. Thank you.
Thank you. Jim Pereño?
I'm here. Good afternoon, commissioners. My presentation that I've been working to reduce it to 2 minutes, I'm hoping to dispel some of the fears that my friends and residents in Firestone may have. Because we just went through this with Oxy and have completed that, and then these wells that they put in are now in production. So my name is Jim Pereño, and I'm representing my community as president of our HOA. And I want to comment today on our positive experiences with Oxy and their predecessor, Anadarko. Our HOA is a collection of 32 homes that are part of a neighborhood of 100 large lot homes. And several of these homes are within, I believe, 1,500 to 2,000 feet of the wells. Now, many of our residents are older and retired, and thus we are home most of the time and are truly hypersensitive to intrusions in our daily life. Our backgrounds are varied, and we include medical doctors, hospital CEOs, nurses, college professors, scientists, economists, police, and firefighters, business owners, and other people from other walks of life. In early 2019, Anadarko approached me as president of the HOA to share development plans to drill nearly 40 horizontal wells on 4 pads. They actually came out and met with me in my home with my board of directors to get our input and concerns and recommendations. And believe me, we had the usually NIMBY attitude. But from community meetings and constant updates, they truly seemed determined to work with us. And on January of 2019, we created a list of 13 requests that we felt necessary to minimize the impact of the drilling process. And Oxy met 10 of those requests and adequately explained why the other 3 could not be. The bottom line is they kept us informed of what, when, and how long the various process would take. They did so with direct mailings, emails, a website, and even a telephone response line. And in all cases, their response was very timely. They actually invited me for a very informative tour of the facility, which further answered my questions and concerns, such as where are the noise and air quality sensors placement? And Commissioner Nanjapa, I believe you were also on that tour, even in the mud of that day, as it had rained recently. Throughout the drilling process, the latest technology was used, not only for noise suppression and lighting, but the wells themselves were state-of-the-art tankless, meaning no large storage tanks. Traffic is less of an impact than I'm certain other land uses would have created. And that's because they're using pipelines to move the product and probably the disposables rather than trucks. And in the end, the final visuals are minimized and with a low profile. In fact, in my daily routines, I personally no longer notice them, and our view of the mountains have been preserved. Again, other land uses would have certainly been more obstructive. There's a Verizon cell tower that they built as an example that's right out my window. My fellow board members and neighbors gave us approval here for me to be here today. They all have positive things to say, and I can tell you that throughout the whole drilling process, our HOA did not receive one complaint. So I ask you to approve this permit and end the residents' fear. Thank you.
Thank you. We now will hear from Cindy Howarter.
Hi, thank you, members of the COGCC, for the opportunity to address the committee. And these are a response into the updates since the last hearing. My name is Cindy Howater. I'm a Colorado native, 4th generation. I'm 63 years old, a Weld County landowner with mineral rights. We have had wells on our land for the last 45 years well within the 500 feet of our house with no concerns. I believe that the oil and gas is important to provide many products throughout the U.S. economy. The war with the Ukraine and Russia has brought to light the dependency of the U.S. and many other countries have placed on foreign countries to provide oil and gas. The need for production has been studied by COGCC or Kerr-McGee and has provided for the safety around those pads. The ruling of the 2,000 feet leeway is open for exceptions, and I believe that exceptions should be more of a rule than not. This gives the opportunity for the Firestone residents to keep our dependency on foreign oil at bay. Please vote to allow the drilling in Firestone, which in turn will keep the economy strong and the U.S. and Colorado independent from foreign oil. And this is also, we need to think about the precedent of not making exceptions to the rule and as we move forward. And thank you for your time and willingness to see all sides of the issue, and please vote to allow this exception. And please keep Colorado strong with the local oil and gas industry. Thank you.
Thank you. We now have Jeffrey Wood.
Can you hear me?
Yep, we can.
That's Jeffrey Wood. Did you say Jeffrey Wood or Jeffrey Witt?
Wood. You're
Okay,
up.
yeah. I live at the Moore Farms. I'm 2,000 miles away from the well site. I've hauled crude oil, and I'm definitely for this. I just don't understand why they want to hold this up. I mean, I've never had a problem with it. I've been in the gas industry for over 20 some years. I've hauled crude oil. I mean, this is great for our economy. I mean, I'm tired of paying all these high bills. I just recently retired 3 years ago, and now it looks like I'm going to have to go back into business again. I mean, the safety on this is just incredible. I mean, I'm grateful for the rules and regulations, especially when I picked it up. It was safer for me and safer for everybody around me. I am definitely for this. You know, this is a good thing. I hope we can keep it. And that's about all I have to say.
Thank you. Sherry Helmer is next. Yes, Ms. Helmer, if you want to unmute.
All right. Can you hear me?
Yes.
Okay, good. My name is Sherry Helmer. I'm a 4th generation Colorado native living in El Paso County and Colorado Springs for the last 40 years. And my comments today are in response to the updates that were made since the last hearing. Thank you for allowing me to speak. I am a retired elementary school teacher living on limited income now that I'm retired, also a grandmother of 6. As a grandmother, I depend on affordable gas for my car to be able to visit my grandchildren that all live in Colorado. My house is heated with natural gas and I rely on fuel resources for day-to-day activities. I want to mention that in 2020, I taught in a low-income school district of Colorado Springs area, and I had several students at that time that were sleeping in their car, living in their car because they could not afford housing. Other students expressed their moms only had a short amount of gas and couldn't take them different places. So I fear with the high prices of gas and fuel that we're seeing now, and could impact these families severely, as well as those living recently retired like myself, or those that have limited income. I also I have many friends and neighbors that are in the military in Colorado Springs, and our military are fighting for the comforts that we enjoy as citizens. I do fear with possible reduction of oil and gas resources, it might weaken the military as we know it today. Oil prices impacts every ligament of our economy, not just gas at the pump. Colorado needs to continue energy production, exploration for our future. I want to urge you, commissioners, to support the Longs Peak Development Project, and please think long and hard about the model that be set if this project is not approved. And thank you, and please support oil and gas in Colorado.
Thank you. Ms. Larson, do we have Mr. Page next?
We do. Mr. Page has asked to speak now. He was on the list earlier.
Can you hear me?
We can.
Okay. My name is Stephen Page. Colorado's been home for most of my life. I'm a former small business owner and as a concerned citizen living on a fixed income. My comments are in response to the updates since our last hearing. We are an energy-based society. Evidence of this is painfully obvious at the gas pump and our monthly XL energy bills. The cost of energy is the primary driver of the current inflation we are all suffering. It is simple. It takes energy to produce and distribute our basic needs. It seems to me that you should be working with energy industry to not only ensure safe production, but finding solutions that lower the cost of energy we require. These include the expansion of exploration and production. In our personal lives and in business, we are uncomfortable with uncertainty, particularly when it comes to regulatory disruption in our lives. It appears that when energy providers and regulators agree on a set of standards, there is a certain segment of our society that want to change the rules. There is no question there is a vocal group that want to eliminate the use of all carbon-based energy. Simply eliminating the sources of energy by taking actions that increase the cost bludgeons the consumer and the economy. And those actors have no clear plan or path to economically replacing carbon fuels. Shouting solar and wind are the solution is not viable or reliable. As I understand, there's currently a ban on drilling within 2,000 feet of residence. There are criteria when met allow exception to this rule. There are those that believe there should be no exceptions to drilling within 2,000 feet. To meet this is changing the rules in the middle of the game and is unacceptable. We should abide by the agreements already made. You have a burdensome responsibility. Your actions have great consequences for those on fixed, lower income, the economy in general, and your decisions set precedents. I trust you look at the loss of revenue and, more importantly, the real impact on jobs and income of Coloradans. I urge you to allow the permitting of Longs Peak, which will have a positive impact on all of us. Thank you for your time.
Thank you. Next up is Heather Sochek.
Awesome. Thank you so much. First, I want to just say thank you to everyone who's taken the time to speak today. Excuse me, sorry, because you guys have done a phenomenal job in clearly stating the economic, political, and financial justifications for this application. And so I won't harp on that anymore, but as a resident that is less than 2,000 feet from the site, I want to speak to the emotional and the aesthetic impact. My name is Heather Suzak. I was born and raised in Colorado, and I've been in the Firestone community for 18 years. I love this community, and like everyone else, my heart was torn apart when a friend of a friend lost a home and husband in the tragedy. I've been talking with Julie and Margaret for a while now, and I'm actually a little excited for the change. They took the time to explain everything that has changed since that tragedy, all the measures that have been taken to ensure the safety and to proactively minimize the impact to the community, the traffic, and the environment. They've bent over backwards to explain everything to me, answer my questions, and ensure that I fully understood everything. And I know I've got their personal cell phones. If I have any questions at any time, they've told me, pick up the phone and call. So what I'm most excited about is something that I know our community has been begging for years. And that is COGCC is building a long-awaited sidewalk on a very busy county road to enable our families to get safely where they need to go. When it comes down to it, nobody wants their view blocked, but I, for one, would much rather have this mostly open space than a huge neighborhood with houses packed next to each other. This way we get to keep most of our view. We have some open space. And while we've been so lucky to have that open field for so long, we have to know that it's going to change soon. So I'd rather pick this all day long, knowing that the company has gone above and beyond to minimize the impact to the environment and the community while providing jobs, resources, and improvements to the community with a sidewalk and open space for the town.
Thank you. Richard, I do not know how to pronounce your last name, but you're up.
Yeah, this is Richard Nigveski, and I thank you for the opportunity to speak today. So good afternoon, commissioners. My comments today, like many others, are in response to the updates made since the last hearing, and I appreciate this opportunity to speak. As I said, I'm Richard Nigveski. I live in Longmont. I've been in Colorado over 25 years now and retired just over a year ago, living on fixed income at this point. My son's been a resident of Firestone for the last 4 years, just blocks from this drilling site, so I'm very familiar with the area. High cost energy, as everybody's pointed out, is detrimental to everybody's pocketbook, raising prices and costs from everything from transportation to pharmaceuticals. It's not an area of our lives it doesn't impact, but especially the most vulnerable, the poor and those in fixed incomes. Just this week, our administration tried to gaslight the American people by claiming that our unprecedented gas prices are due to Russia's war on Ukraine. On the contrary, gas prices have risen steadily since the president's early actions to shut down Keystone, close all federal lands to development of oil and gas. So since November 3rd of 2020 through November 2021, gas prices have risen over 62%. Inflation is now at a 40-year high. In 2019, we had become energy independent for the first time since 1952. Now we're an energy importer once again. We absolutely need responsible domestic oil and gas production to allow people to live and work without undue financial burden. I live near both Highway 119 and Highway 66, and fracking and oil and gas drilling has been going on in this stretch for the last 7+ years. Even at a peak of 8+ simultaneous drilling operations along both highways, I experienced no negative impacts on the communities. Firestone has reviewed this proposal extensively and approved it. The operators agreed to all the stipulations of the law and the additional abatement measures requested. New residents to a community bear the obligation to perform their due diligence before moving there. A handful now seek to overturn the will of the community and a law that has been fully satisfied. This sets a dangerous precedent. I respectfully request that the commission allow the Longs Peak project to continue as is.
Thank you. David Stiver.
Thank you. Can you hear me?
Yes.
Dear members of the commission, my name is David Stiver. I've resided in El Paso County and Colorado Springs proper since 1976. I am in favor of the applicant's request, having reviewed all of the available documents and the news reports and so forth. While I do not reside in Firestone or Weld County, the decision you make today can have far-reaching implications, not only for the local residents, but for the entire state of Colorado. In particular, the mandatory 2,000-foot setback and recent updates to the previous hearing. Section 2.5A of Title 24 of the Colorado Administrative Procedure Act requires that the board or commission consider the following. Of significant importance are item 2, the anticipated economic benefits of the rule or amendment, which shall include economic growth, the creation of new jobs, and increased economic competitiveness. Subsection 3, the anticipated costs of the rule or amendment, which shall include the direct cost to the government to administer the rule or amendment, and the direct and indirect costs to business and other entities required to comply with the rule or amendment. And subsection 4, any adverse effects on the economy, consumers, private markets, small businesses, job creation, and economic competitiveness. I strongly believe that land and land use issues are best resolved at the local level, from the Firestone Township trustees to the Weld County Planning Commission to the Weld County Commissioners. All are entrusted with the responsibility to oversee the land use, water use, and development within their communities. It is my understanding that none of these entities have objected to the Kerr-McGee-Longs Peak project. I ask for your approval. Thank you for your thoughtful and well-reasoned consideration of this application.
Thank you. Jim Rainey. Mr. Rainey, we're not able to hear you.
We can hear you, but you sound like Minnie Mouse.
Mr. Chair, we do have Nadine Jung in the meeting.
Yeah.
She could provide comment while Mr. Rainey is able to work on his audio.
Okay.
Commissioners?
Yes, we can hear you.
Thank you. Thank you for the opportunity to speak with you today. My comments are in response to the recent change in the Longs Peak development. My name is Nadine Young, and I have lived in Colorado for over 30 years in Jefferson and Larimer counties. Several years ago, my husband and I considered moving to Firestone. When we saw an oil pad outside the development, we wanted to buy that very lot with that view. Sadly, we were unable to purchase it. My late husband spent years working in the oil and gas industry in the 1980s and for the last decades of his life. During those latter years, I had the opportunity to visit many of his sites in both Larimer and Weld County. I was never worried about being on any of those sites. Now more than ever, oil and gas is a vital industry to not just Colorado's economy, but the US as well. President Biden has announced a ban on all Russian oil imports, and the polls show that 70% of Americans agree with it. However, our economy has always been predicated on cheap energy. With the president banning imports of Russian oil, it's even more important that we keep production up here to become energy independent, so we don't have to depend on foreign governments and their less stringent environmental guidelines. Colorado is already losing jobs in this sector. My friend Kyle, who is a petroleum engineer, recently moved to North Dakota because he needed a job. We're losing tax revenue and families who stimulate our economy from purchasing groceries and homes to other services and to volunteering in their churches and schools. Commissioners, I urge you to work together with the oil and gas industry and Kerr-McGee to make sure that Colorado remains can meet our energy demands, that and of our nations. They've met all of the requirements, and we should leave the rules to Firestone if they have already approved this. I thank you for your time and for all that you've done for us.
Thank you. Mr. Rainey, do you want to give it a shot again?
Yes, is this better?
You don't know how much better it is.
Sorry, I had my settings fouled up. My name's Jim Rain. I'm a lifelong Colorado resident. I was born and raised in the mountains over on the western slope, Leadville and Gunnison. So I'm very well aware of promoting environmental impacts. I'm speaking today in response to the changes since the last hearing. From everything I've read, it appears that Kerr-McGee has really bent over backwards on this to be a cooperative. As was said earlier, the city of Firestone, the Weld County Planning, those people locally closest to this development and its impacts have all approved it or not objected to it. And I would like to, I think given the current circumstance, it's important to think about something. And I'm going to read a little script here. I looked all this information up. And when we're looking at curtailing domestic oil production, I think you have to remember what the consequences of that are. It takes between 21 and 35 days for an oil tanker from Russia to get to a US port to be offloaded. It takes between 35 and 60 days for a tanker from the Middle East to make the same trip. It takes about 10 hours to unload a tanker or to load a tanker and about 24 hours to unload it. If it has to wait in port to get unloaded or find a docking space, that can take as long as 3 days. The average oil tanker burns 2,625 gallons of diesel fuel per hour of operation. That deposits 22.38 pounds of CO2 are created from burning 1 gallon of diesel fuel. So in 1 hour, a tanker ship, when we buy oil from overseas, produces, hauling it to a port or refinery in the US, creates 58,757.5 pounds of CO2 per hour. Average travel time for the tanker, averaging the travel time for those destinations, that's 27.67 million tons of CO2 per tanker trip. In comparison, on average, a vehicle here in the United States creates 6 to 9 tons a year of CO2. So I would say if we're really concerned about the environment, which I think we are, we should buy less oil from overseas suppliers and responsibly develop our resources here at home, because it's clearly more environmentally sustainable. I appreciate your time. Thank you very much for your consideration. And I appreciate all your work on this issue. And I would urge you to approve the Longs Peak Kerr-McGee development. It seems like they've gone above and beyond.
Thank you. Gary Kay is next.
Can you hear me?
Yes.
Oh, thank you. Parts of my family have been in this state since before it was a state. My father's side of the family came here in covered wagon to homestead. My mother's side of the family built and brought out the first narrow gauge steam engine to Colorado. I have been in the area almost my entire life. When I hear people say not in my backyard, I'd like to remind them that they chose to live in existing oil fields that have shared the land with farms as long as I've been alive. The small amount of revenue my mother receives from oil and gas revenues does not even cover the tax increases that have increased from $189 annually in 2001 to $2,963 in 2021 annually. I fabricate stone countertops for your homes. Diesel fuel is used for its transportation. It requires shipping, railroads, and trucking to get it to your doorstep. Electricity and water to fabricate it. My costs have already gone up more than 25% in the last year. One of those increases being a 25% tax increase this last year alone that our government enjoys. As a native of Colorado and a property owner in Weld County, I urge you to use common sense in the decisions you have been entrusted to make. You need to ask yourself the hard questions. Does it make sense to import dirty oil from around the world and pay more for it when honey crude, which is easier to refine and cleaner, is readily available in our own backyard. Are you willing to give up the highest living standard in the world history? Keep in mind, your sacrifices will not apply to the people in charge. They never do. Thank you for your time.
Thank you. John Smith is next. Mr. Smith, you are muted.
Okay, that's better. Hi, these comments are in response to the updates made since the last hearing. My name is John Smith, and I am a resident of Greenwood Village, Colorado. I've been a petroleum engineer since 1982. As a petroleum engineer, I've participated in oil and gas developments throughout the United States and the world. Like many of my colleagues, I've philosophically adopted the premise that I should think globally and act locally. This means contributing to the local community, both in time and money. For instance, I have been a volunteer firefighter, mentored college students, high school students, and elementary students in STEM, as well as being an adult leader in youth groups such as Little League and Boy Scouts. But it also means doing the right thing in my capacity as a petroleum engineer and responsibly producing oil and gas. In this context today, we have two major global problems: the geopolitical exercise of the power of oil production by the autocratic, tyrannical, war-mongering state of Russia, and the destruction of the environment by irresponsible petroleum production by petrostates such as Iraq and Russia. We also have a local problem, and that is the seriously negative impact high oil prices have on disaffected communities. Encouraging oil production in Colorado is a local step to solving these global and local problems. Colorado, thanks to the joint efforts of the COGCC, the oil and gas companies involved, and the citizens of Colorado, is the world leader in responsible oil and gas production. This project, as proposed, is a responsible project done by a company well known for its responsible production of oil and gas. Consequently, in order to act locally in the solution of these global problems above, I urge you to approve this project.
Thank you, Mr. Smith.
Thank you.
Bill Coffey is next.
Commissioners, thank you for this opportunity to voice my opposition to Kerr McGee's application for the McGavin pad site and to ask you to deny this application. My wife and I live in the Falcon Point at Saddleback subdivision in Firestone and would be directly impacted by the McGavin pad. Other people have come in before me would only be tangentially impacted, have been speaking in generalities, seem to be reading from the same script, and very few actually live in Firestone. Very few seem to be aware that oil is a global commodity, and any oil coming from these pads would be sold on the oil market to the global market to the highest bidder. My wife is immunocompromised, and while we knew Weld County was pro-oil and gas, we never imagined an oil and fracking industrial strike right in the middle of a residential and recreational area. Many studies have shown that air pollutant concentrations increase with proximity to an oil and gas facility, as does health risks such as cancer. The CDPHE has recommended 13 best management practices. As has been mentioned previously, other operators have implemented these best practices at Broomfield sites, and those Broomfield sites continue to see a large number of complaints from people living nearby. The risks in this application outweigh any economic benefits. Coloradoans are seeing a high record number of oil and gas wells closer to residential neighborhoods than ever before. This means more and more people, like my wife, will see adverse health impacts. Air quality is already poor on the Front Range with ozone at all-time highs. State officials have identified people burning fossil fuels and vehicles and the oil and gas industry as the main culprits. Inhaling ozone pollution worsens respiratory ailments and triggers asthma attacks. Getting cuts in the oil and gas sector is key to meeting the statutory goal of trimming Colorado's greenhouse gas emissions. I call on the COGCC to listen to the CTPHE's recommendation, the community's public comments, and current legislation by denying this permit. Thank you.
Thank you, Mr. Coffey.
Awesome.
Kelsey Barnhart. Oh,
Hi there, can you hear me?
yes.
Hi, thank you for the opportunity to give public comment again today against Kerr McGee's proposed Longs Peaks pad. I live in Erie, and just a few weeks ago, I shared my story about what it's like to live through the fracking and flowback phases of mega pads a half mile from your home. Coincidentally, Kerr McGee is the same operator who fracked the 28 wells near my neighborhood in 2021. And I can assure you that no amount of conditions of approval or gifts of land or sidewalks will make fracking wells safe near a residential community, nor alleviate the negative experiences that are certain during fracking and flowback. Because the reality is that after the light and noise disturbances from the constant barrage of trucks to the sites at all hours of the night, and the shaking and incessant humming noises have ceased, the steady low-grade impacts from contaminated air and spill risks remain for the next 20 years. On February 23rd, I collected an air canister sample that was analyzed by Ajax to see what the air is like outside my home. This 30-second sample of air on a normal day showed dozens of BTEX chemicals. The pentane ratio was 0.95, which indicated oil and gas impacts. The ethane of the sample was 9.7 ppb, and the methane was 2.0. So here's the catch-22 I'm faced with. Stay in the house that we absolutely love, but be exposed to airborne carcinogens from oil and gas every day, or relocate my family to a town that's off the shale and doesn't have fracking. I have primary immunodeficiency, which puts me at a higher risk for cancers like lymphoma, and staying would mean exponentially raise my risks. We $1,500, all of the people in Firestone who will be impacted by this project from having to face the same decision we are faced with. In the last 3 weeks, Erie has had a ruptured flow line, daylight spilling, an unknown amount of contaminated fracking wastewater, and we have had multiple canisters triggered in our town. It would do the COGCC well to hold true to the spirit of the SB 181, which is to put health, safety, and environment over profits and deny this permit. Thank you.
Thank you, Ms. Barnholt. Steve Shagri.
Yes, sir, I'm here. I'd like to thank the commissioners as well as everyone in attendance for allowing me to speak and listening to what I have to say. I have been a resident of Weld County for the past 9 years, and for the past 17, I have been a pipeline booster station, compressor station, and refinery integrity inspector. I'm one of the last people that signs off on these projects when they are complete and ready to go in service. The benefits to Weld County as well as to the state of Colorado are tenfold, including the $600 million a year allocated for public education, which happens to make up 70% of all dispersions from the school trust. I'm absolutely in favor of approving the Longs Peak project. And I forgot to note that my comments reference the last commissioner's hearing. I care because I care about this state. I care about my fellow Coloradans. I want to see them economically healthy and secure. In closing, I would also like to remind the commissioners that the largest consumer of oil and gas in this country is the United States military. And as a proud U.S. Army veteran, I can say right now that the men and women who serve our great nation are our German shepherds. So let's do our part to keep their teeth sharp. Thank you for your time.
Thank you, Mr. Shagri. Deb Bjork.
Thank you for taking testimony. Deb Bjork, please deny the Longs Peak application.
COGCC's review of their alternate location analysis quoted staff on both locations saying, quote, "The location would present fewer potential adverse impacts than the alternatives. Fewer adverse impacts is not equivalent to protection as mandated by SB 19-181. Einstein said, no problem can be solved from the same level of consciousness that created it. Kerr-McGee's continued stance for the Longs Peak location is just that. Broomfield Councilwoman Lori Anderson's submission noted that Extraction 6 pad site, which was used as a supportive comparison for Longs Peak application, has the same COAs in place, but does not protect from health impacts, noise, safety concerns, or emissions. Despite Extraction's required COAs, Broomfield has received nearly 1,000 health and noise impacts from one of the pads. Air quality monitoring data shows spikes of emissions, including benzene 20 times above the acute health guideline. Earthworks submission had links to FLIR camera videos showing significant emissions from sites that the CDPHE has cited as having the strongest BMPs. It is not safe to have fracking in our neighborhoods, even with BMPs. CDPHE's health impact study and Director Murphy's concern about the Long Peak application in her February 17th filing, quote, "Staff acknowledges, however, that the proposed developments would result in unavoidable impacts to the public. The Long Peak application cannot be patched here or there with false solutions under the rubric of substantially equivalent protections. Regulations were revised to stop neighborhood drilling, a clear intent of SB 19-181, as was the right to deny permits. Leaving minerals in the ground is not waste. If you grant this application, you are knowingly subjecting these residents to significant and ongoing health and safety impacts: nosebleeds, headaches, nausea, irritation of the eyes, nose, and throat, asthma attacks, lack of sleep, and stress levels impacting heart conditions, high blood pressure, anxiety, depression, and the potential for long-term health impacts, including cancer, premature deaths, premature births, babies with heart conditions, etc., as substantiated in irrefutable scientific studies. As Flannery O'Connor said, the truth does not change according to our ability to stomach it. Please deny this application."
Thank you, Ms. Bjork. Emily Bear.
Good afternoon. You've heard a lot. Thank you for being patient with us and listening to all of our comments. My name is Emily Bear. I live in Erie, Firestone's disproportionately impacted neighbor. I have shared with this commission a number of times my family's story of living with fracking near our home and our 7-year-old son falling gravely ill during drilling and flowback of the waste management site that's 2,500 feet north of our house. I recognize the importance of showing up here and telling the truth about neighborhood drilling. My son's illness isn't the whole story of our experience here. We've experienced a lot of impacts, and it's hard to convey them all in 3 minutes. Or 2. From nosebleeds to headaches, asthma flares, anxiety, nausea, vomiting, eye irritation, throat irritation, all of these through maintenance and production. We've experienced all of these things and more. I want to use my time today to bring us back to the COGCC's mandate to protect public health, safety, welfare, and the environment. Residents living near oil and gas production along the Front Range have continued to show up here. We have told you the truth over and over again. We are suffering impacts when this activity is conducted near our homes, neighborhoods, parks, and schools, even with the best management practices. The truth is, when fracking is approved near homes, you are volunteering those populations to suffer for years. We have to move away from the idea of sacrificial populations. The truth is that your mandate gives you the power and the moral directive to protect these people in Firestone. I implore you to use that power and deny the Longs Peak OGDP, all of it. Thank you.
Thank you. Kathleen Scott.
Hello, can you hear me okay?
Yep.
Okay, thank you. I apologize if this goes a little bit long. The email said we had 3 minutes. I've tried to cut it down. But anyway, I'll get started. My name is Kathleen Scott. I live on Falcon Street in Firestone. We just moved here in December, My house backs directly to the proposed McGavin pad and is within 2,000 feet. I am asking the commission to deny this application. Regarding the responses to the McGavin BMP recommendations, response number 2, tankless design and produced water pipeline. The response indicates it's contingent on acquiring easements, licenses, and crossing requirements. How do we know these contingencies will be met? Response number 11, ozone mitigation measures. The response indicates they will voluntarily participate in Ozone Action Days mitigation as feasible. What does as feasible mean? Page 9 of KMOG's presentation lists 5 advantages to the current application, but there's not one advantage for the residents who live near the proposed site. KMOG indicates the McGavin location would present fewer potential adverse impacts than the alternative locations analyzed, but there is nothing mentioned in the ALA about traffic, odor, and air quality impacts to nearby residents. KMOG is focusing on what they prefer rather than avoiding and minimizing impacts. The analysis seems incomplete and is not fully considering other options. They should be less concerned about losing some mineral recovery and more concerned about the protection of public health and environment. Their statement in the proposal for continuous community engagement and updates is not reassuring. KMOG's outreach has been almost non-existent to us. We had no idea we had any right to file a petition or become parties to the opposed drilling. I really question the accuracy of the engagement efforts listed in the application. I am very worried about health concerns. I've heard from folks from other extraction sites like Broomfield and Erie, and the negative impacts they have experienced is very concerning. Headaches, nosebleeds, breathing difficulties, noise, traffic, bright lights, and house foundations, cracking and settling issues. Also, I would also like to note the Firestone Trail is within feet of the McGavin pad. And about a week ago, I counted 36 residents walking the trail throughout the day and 4 people on horseback. So I'm just emphasizing how many folks use the trail and will also be affected by the development of the 26 wells there. The bottom line is the well pads do not comply with the 2,000-foot setback rule, and there is still no analysis or evidence that the impacts from the location would be substantially equivalent to locating the pad further from homes. There is no evidence that the protections are adequate. There is no way they can promise this is safe, this close to residential homes. This is not the right spot for these wells. Again, I request the application be denied. Please do not protect the industry's interest rather than fulfilling your mission under SB 181. Thank you for your time.
Thank you, Ms. Scott. Susan Johnson.
Hi there, my name is Suzanne Johnson, and I'm a new resident in the Saddleback neighborhood like the prior 2 ladies who have spoken, and I'm a 22-year Coloradan. This is my 4th time speaking against the proposed Longs Peak OGDP because I want to preserve the beauty of these areas of Firestone and Frederick, and I want to protect families like mine from the adverse health effects caused by oil and gas production in residential locations and recreation areas. Unlike the past 3 times that I've spoken, I'm speaking today for the millions of Coloradans who have already spoken against residential oil and gas drilling when they stepped into the ballot box and elected people to represent them and their families. 4 of those representatives sponsored SB 181, and the legislature then passed it. This changed your mission from that of fostering to now regulating the production of oil and gas in Colorado in a manner that protects public health, safety, welfare, the environment, and wildlife resources. In my opinion, there are not enough substantially equivalent standards or best management practices that could be proposed to mitigate the health effects and the possible risks that are inherent in an operation of this size and scope within less than 900 feet of people's homes and our beautiful recreation areas filled with wildlife. So I'd ask you to consider the will of the voters and what they are saying and have said through those representatives. This legislation, now the law, is designed to protect. I would ask that you be very, very thoughtful and careful when making this decision. The ramifications of this will be felt far past this little town of Firestone and its wonderful people to other people, just like me and my family, in communities across the state. Please value people, wildlife, and our environment by denying this permit. Thank you.
Thank you. Marilyn Hughes. Mr. McGahee, you're down the list. Let me see if we can get Ms. Hughes on board first.
I'm back.
Okay, good.
I'm having some computer problems, sorry. Good afternoon. My name's Marilyn Hughes. I attended the first hearing online and turned in testimony opposing the Kerr-McGee Longs Peak application. I understand that the applicant is now willing to add more safety practices, but I disagree that a large number of health and safety protocols is tantamount to having drilling 2,000 feet away from people's homes. Evidence of that statement can be found in a recent Colorado Sun article that points out all the problems people are noting that the Broomfield wells are causing, even with extensive health and safety protocols. I urge the commissioners to read the full article. I spent most of 2019 volunteering as a community activist with bill sponsors to help get 181 passed. The hearings were long and arduous and often went as long as 3 a.m. in the morning. I did it because I live in Longmont and care about health and safety. And I'm saddened that protecting the public health is considered government overreach. Longmont monitors the volatile gases that wells produce in Weld County. We get benzene, methane, ozone regularly recorded coming into the Longmont area. Those levels can be found through Longmont city government. Bill 181 was passed in the legislature to protect people and not to provide drilling within 2,000 feet. I'm worried that if this application is approved, it will be the end of 181 and the Colorado public will be back where we were before 2019, at the mercy of wherever drillers will want to drill. Please vote no on this application. And it feels like as if people are confusing not approving this application with no drilling at all. So I think I appreciate all your patience and thanks for listening.
Thank you. Mr. McGehee, you're up.
Thank you, Mr. Chairman, commissioners, and the commission staff. I appreciate the opportunity to speak with you today. And I want to speak to the new application materials submitted by Kerr-McGee that they submitted in support of their application. My name is Bill McGehee. I live at 8837 Falcon Street in Firestone in the Falcon Point at Saddleback subdivision, just outside the 2,000-foot boundary, I would note. And the view from my back looks over west and would look over the development that's proposed as well. I'm here today to ask you to vote no and oppose the approval of Kerr-McGee's Long Peak Oil and Gas Development Plan. I've been disappointed today that many have used this hearing to try to litigate the value of the oil and gas industry. That's not why we're here. This is about a specific proposal and the proposed mitigations to meet the substantially equivalent mitigations. And as a previous speaker mentioned, I do appreciate your patience with everyone. Even with the updated BMPs that Kerr-McGee has submitted, this facility within 2,000 feet of my patio and backyard places me and my family at an unnecessary and avoidable risk. It's exactly what the Commission's regulations are meant to prevent, creating unnecessary and avoidable risks. Quite frankly, no amount of BMPs or mitigation is substantially equivalent to it not being put there in the first place. Nothing Kerr-McGee has proposed will reduce the unsafe conditions proposed by all the additional traffic in particular. Also, I believe Kerr-McGee's proposal to remove the produced water from the site, as they put in their BMPs, rests on a house of cards and proposed what ifs that may or may not occur. In my mind, while I acknowledge the efforts they have made, and I applaud Kerr-McGee and their individuals who have worked hard on this, they failed to meet the burden of proof of substantially equivalent. In the end, no amount of mitigation can change the fact that approval of this application will result in wells and a production facility that create harm and risk to nearby residents and permanently alter the landscape and environment in an area where it should never have been placed. Please deny the application for approval. Thank you so much.
Thank you. Kate Christensen.
Hi, thanks for taking the time to hear my comments today. My name is Kate Christensen. I live in Lafayette, Colorado. I am going to tell you a little bit about me and how it relates to denying the Longmont, or sorry, not Longmont, Longs Peak OGDP. I am a trained bilingual speech language pathologist. I graduated from CU in 2005, and I worked all over the DJ basin with little kids. I'm talking about like toddlers who were just screaming and you had to teach them a few words. I am good at it. You give me a screaming toddler, I can really help teach them to communicate. Most recently, I was clinical faculty at the University of Colorado, helping to train graduate students. But the more I learned about fracking, the more I learned that I could help more kids if I tried to work so they didn't live near these facilities. There's so much research from the CDPHE, from Dr. Lisa McKenzie, and there's a whole compilation from Physicians for Social Responsibility that show that kids who live near fracking sites closer than 2,000 feet will have low birth weight, asthma, cancer, are more likely, I mean, not all of them will develop these conditions, but they're more likely to develop those conditions and therefore more likely to end up on my caseload. So I don't work as a speech therapist anymore. I dedicate all my time to trying to prevent kids from ending up on my caseload in the first place. So the thing about the Longs Peak OGDP that is new and not new and hasn't changed is that it still has a ton of homes within 2,000 feet, and it puts all these kids at risk. So deny it. It's not safe. It's not, people are conflating the house that blew up and killed Joey Irwin and Mark Martinez. That was an abandoned flow line. We're talking about the benzene, the VOCs, the methane, the ozone. Nothing protects kids like distance. So please deny this permit. Thank you. Oh, and by the way, just to remind Commissioner Roberts, LOGIC stands for the League of Oil and Gas Impacted Coloradans, which I think maybe could have been a party to this because they're impacted. So anyway, thanks for your time. Appreciate it.
Appreciate that. I knew that. I just spaced. So long day.
Yeah, no problem. I brain fart too sometimes. I was just going to throw it out there.
Very good. Thanks for being with us again, Ms. Christensen. We appreciate it. Louise Vanderkool.
Lois Vanderkooi, Broomfield. I know it's been a long day and thanks for listening. And I'm jealous of Commissioner Najapa's cat as we've had some mice issues in our house. So if I screech, you'll know what happened. I served on our Oil and Gas Committee in 2017 and have been involved since. These words are my own. Extraction's multi-well pads in Broomfield were a test case for neighborhood fracking, and residents fought to gain protection. Although unsatisfactory to many, the operator agreement was considered the best we could do given state law and the COGCC mission at the time. During our committee work in 2017, extraction alternated between reassuring and promising and then resisting recommendations. After our last meeting, I walked out with extraction representatives and overheard them complaining to a committee member who owns an oil and gas company. He replied, "Hey guys, this is Broomfield." There was great pride in our work, and our extensive BMPs were touted as the best ever. But they weren't good enough. Staff had to renegotiate some, and extraction refused to change some. The city had little recourse in providing actual protection, but rather spent millions gathering data, which was correlated with health symptoms, some of which you've heard about already. The city did win one lawsuit over a citation that involved a $400 fine for disturbance of burrowing owl habitat. Please believe our data about impacts and don't trust the BMPs proposed. Put a strong burden of proof on operators as to whether their substantially equivalent off-ramp is truly as protective as a 2,000-foot buffer. Thanks.
Thank you. Chris Escalante.
Hi, I spoke at the last public meeting to express my concerns as I am an impacted resident. I even joined that logic group that was mentioned earlier because of the concerns I have. And when I spoke last time, I can see it hasn't stopped the push for Kerr-McGee to look for their minerals and look for it in my backyard. So I want to say it's a huge impact to my family. We're concerned about my entire family's health. So during this meeting today, I want to focus my discussion on the impacts to my family and my life. And I do want to point out, we did do our due diligence before purchasing our home in 2020 and saw that it was zoned residential. We're now planning to move out of state. We're packing currently, and I'm doing that to protect my multi-generational family. There's 6 of us living together, and we had planned our life retirement, picked a home that we could age in, and our life is literally turned upside down right now. My husband, a vet, I know people mentioned veterans earlier. My husband's a vet. He's having to retire 3 years early from his company in order to allow us to move. So we can pick a state that we're comfortable with, that he unfortunately can't work in. We're giving up our dreams, our friends, and I will not get over it. I thought I would be protected from harm in Colorado, and I thought even Senate Bill 181 would be protecting us, and I'm hoping it still will. I'm hoping, and I know you guys are listening. And I want to mention, I find it particularly despicable that those speaking during this public meeting that are outside of the impacted area, it's cool, they can speak. Everyone has a right to speak. But I find it really despicable and irritating that they're aggressively complaining about the concerned citizens like myself, that I'm just speaking up because I don't want harm to my family if it's approved, and they're pretty much trashing us. And another thing that really bothers me is the words they're using are almost exact phrases, exact words here and there peppered throughout what they're saying. And I'm wondering who fed them those words. I think that's really irritating. They're spouting off information that it's coming from them or somebody who fed it to them. And I hope that y'alls are listening to what they're saying. That's what I have to say today.
Thank you. Ramesh Bhatt.
Thank you. My name is Ramesh Bhatt. I am the chair of the Conservation Committee of the Colorado Sierra Club, which has over 100,000 members and supporters in the state. I'm here to urge you to deny the Longs Peak OGDP. I want to first say, though, that we agree with the comments made by Mr. Freeman this morning. Seems like a long time ago now. So I won't repeat all the points. But in particular, we agree with his observation that Kerr-McGee failed to submit a complete ALA. We also note that Kerr-McGee did not even attempt to show their plan would be substantially equivalent to a facility located 2,000 feet away. And we are concerned that this permit is even being discussed without even any such attempt. When the setback rules were first debated, it seems like a year and a half ago or so now, the Sierra Club urged the commission against variances. We said the following at that time, quote, provisions for setback exceptions should not be included because the site-specific exceptions defeat the purpose of a uniform setback to set a floor to protect the public health, safety, and welfare. We are concerned now that variances will be used as loopholes to circumvent the 2,000-foot rule. The Sierra Club hopes that our fears don't come to pass. We hope that you will not allow unsubstantiated claims of equivalent protection to deny the setback rule, to circumvent the setback rules. The choice is clear when it comes to the Longs Peak OGDP. If this is not denied, what is going to be denied in the future? Please deny this permit. It is too close to homes. There are too many homes close by. Thank you very much.
Thank you. Now we have Mr. Bill Hawkins.
Hi, this is Bill Hawkins, and I want to thank you for letting us speak to you today and getting everybody's concern, because everybody does count. I've worked in the oil and gas industry off and on in Colorado since 1980. And I would like to speak for the Longs Peak, and that's letting it move forward. These people's concerns are justified, so is the industry's. But living in Greeley, I can look west to the mountains, and all I see is pollution from every one of those people who are concerned driving up and down I-25. That pollution stays with us. Oil and gas, very concentrated, very local. People don't want to have gas-powered vehicles. I understand that. The electrical grid cannot support the electricity use now. You cannot just stop it. They still have to look at oil and gas as a bridge to the electrical. You can't even make your solar panels without oil byproducts. You cannot mine the material that you need for your windmills without oil products. To cut it off just at once, stop it completely, you can't do it. I'm sorry. But I understand their concern. I have concern. I raised 3 children here. I also have 2 son-in-laws that are in the business also. I'd just like to say, go ahead and let this project continue on, put in your regulations and stuff, but you cannot just stop it all at once. You have to have some type of a bridge to get you to where you want to go. Thank you for your time. I appreciate everybody's comment.
Thank you. Alexis Schwartz.
Good afternoon, commissioners. Thank you for the opportunity to speak today. My name is Alexis Schwartz. I'm a Coloradan who lives in Denver, speaking today because the pollutants and detrimental impacts of drilling and fossil fuel extraction do not observe or adhere to artificial boundaries. I speak today to express my disappointment that the McGavin Pad's proposed location is not appreciably different than from the most recent proposal submitted for consideration. Chair McGee is claiming that unless they adhere to their original plan, they will leave lots of fossil fuels in the ground, stranded minerals, stranded as though those fossil fuels are sentient beings in need of rescue. Chair McGee is more concerned about stranded minerals than they are about impacts on actual people with homes, families, and health to protect. But it is the mission of the COGCC to prioritize protecting public health, safety, welfare, the environment, and wildlife resources over industry profit. There is great need for changing these permitting review activities to meet this legal mandate. It is not absolutely necessary for operators to turn every pocket of land inside out, to turn residential communities upside down at the expense of the health and wellness of the nearly 100 homes residing in close proximity. The COGCC must deny this drilling plan. There is no place for residential drilling. Thank you for hearing from me.
Thank you. We now have Catherine Merlin.
Thank you, everybody. Hi, my name's Kate Merlin. I'm the climate and energy attorney for Colorado for Wild Earth Guardians, and I live in Boulder. I'm asking you to deny the Longs Peak OGDP. I brought the Martinez v. COGCC case on behalf of our Children's Trust. I was extensively involved with SB 19181. I worked heavily on mission change. I've been extensively involved in challenging the extraction project in Broomfield on health, safety, and welfare grounds. I also represented Janice Butterfield and Stephanie Nilsson and brought them to you to testify about the impacts they experienced from a well pad just about exactly 1,000 feet away from their home, which was severe. You might remember the video of their entire home rattling and shaking. They were unable to be outside for months at a time, experienced long lines of semi-trucks idling outside their homes. They had headaches, dizziness, and nosebleeds, which we believe were likely a result of benzene exposure. They stopped letting their grandkids visit. The foundation of their home was literally shaken apart by vibrations from the different phases of development, and oily residues were deposited in a sheen over their property. Another well pad to the south that was 2,000 feet away had impacts, but the closer pad was an order of magnitude greater. Kerr-McGee Occidental can still develop the vast majority of these minerals, as Dr. Meckel showed, without putting these wells amidst an existing residential development. Operators seeking to show substantial equivalency and protection have a very high bar. It's just not been met here. The shock to oil prices caused by Russia's attack on Ukraine has shown us that our society cannot continue to rely on fossil fuels. Even though the United States has become the #1 producer of oil and gas, we can't prevent oil price fluctuations because of who shares that market with us, despots and autocrats. The oil that these operators are seeking to develop will not affect gas prices 1 iota even after they manage to make it to market in 6, 12, or 18 months. Operators are currently sitting on hundreds of unused permits. During the financial assurances rulemaking, you worked tirelessly hand in hand on a nearly daily basis with the industry to do the best you could to address their concerns. And they told you yesterday that you had blood on your hands. This industry will attack you even if you give them everything that they ask for. So why bend your rules into pretzels so that a 2,000-foot setback gets turned into a 500-foot setback if they add a handful of BMPs? We worked tirelessly for years to get that setback, and I feel like approving this application would just turn that into a joke. Thank you.
Thank you. Kathy Kemper?
Can you guys hear me? I'm on a headset.
Yes, we can hear you.
Okay, all right, great. Hi, thank you for listening to me today. My name is Kathy Kemper. I live in Longmont, Colorado, 450 feet from the Knight well pad with 12 wells in production. My purpose today is to provide a glimpse of what it's like to live that close to a drill site of this small size compared to what's going in Firestone, and why I feel that the commission should vote against granting the application of Kerr-McGee. This site is a swirling, spewing, smelly mess of an operation. My nickname for the site is Frachosaurus Rex, a cross between an ancient dinosaur and a Godzilla. The ground rumbles with every footstep and it randomly spews fire and gases at will in any direction 24 hours per day. You live in constant fear of never knowing when the beast is out. Trucks rumble down our residential street with unknown compounds, thinking they can access the drill site from here. There have been days when the sound is so loud you cannot carry on a conversation outside your home, and nights that produce little sleep. The site has tripped the spod sensors with benzene. The health department mobile lab has been collecting data at the bottom of my driveway. They just released a report concerning elevated emissions. The OGC has collected many hours of sound data. The scale C noise has been so bad that it's enough to rattle the pictures in my house on the walls and knock items off of shelves. My basement slab has moved 1/3 of an inch in the last 90 days. Caulking is cracked in my drywall and trim. I have a bedroom door that no longer closes properly. Even with all these regulations, measurements, and inspections, this industry continues to wield their influence to bend the rules to their liking. Why did we institute stricter guidelines only to allow this to occur? Why do we have this governing agency? Why spend all this dedicated time and energy making sure the industry complies only to allow them to proceed? What is the mission statement of the COGCC? This commission has a duty to regulate the development and production of the natural resources of oil and gas in a manner that protects public health, safety, welfare, the environment, and wildlife resources. Remember your mission, make the right choice, vote no. Thank you.
Thank you, Ms. Kemper. I believe we now have Mike Foote.
Thank you, Mr. Chair, and good afternoon, Commissioners. My name is Mike Foote, and I'm a former legislator from Eastern Boulder County, speaking as a member of the public about the alternative location analysis in this OGDP. As you are well aware, Senate Bill 19-181 added the alternative location analysis requirement to the Oil and Gas Act. It also eliminated the prior statutory prohibition of waste and made it, like everything else in the Act, subservient to the protection of public health, safety, welfare, the environment, and wildlife. For those who were there, as I was, during the introduction and debate of Senate Bill 181, you know the intent of the alternative location analysis requirement was not to settle for the least bad location for a proposed neighborhood drilling project, but that none of the above can be an acceptable answer for an application after an alternative location analysis. An example I often used during the debate was a hypothetical centered around trying to access minerals underneath Mile High Stadium, or whatever it's called these days. If the only way to access those minerals was to put a drill rig at the 50-yard line of the football field, clearly that application would have to be denied, regardless of whether it was the best or only place the operator could get to those minerals given current technology. In some cases, none of the above is the right answer. Kerr-McGee didn't make a none of the above option, but your deliberation should include it. And at the end of that deliberation, it should be clear that none of the above in this case is the only answer consistent with the Commission's mission to protect public health, safety, welfare, the environment, and wildlife. The bottom line is that Kerr-McGee still has not met its burden to prove to you that the Longs Peak alternative location analyses, substantially equivalent protection claims, and the entire OGDP for that matter, complies with the statute. The Oil and Gas Act was amended in 2019 to avoid this very kind of neighborhood drilling, and I ask that you uphold that intent and deny the Longs Peak OGDP. Thank you.
Thank you. Sherry Walker.
Good afternoon. Can you hear me okay?
Uh-huh.
Okay. My name's Sherry Walker. I live in the Falcon Point subdivision. There are approximately 80 homes in this part of the subdivision. First of all, I'd like to say we are not against oil and gas. It's embedded in our life and our lifestyle and our livelihood. You guys have an important decision that will impact many. We have lived in Firestone for 23 years. Our grandchildren were born here, and some of our family members have lived here for 40 years. Just simply speaking, we bought our property in 2020, April of 2020, moved into our home on Thanksgiving Day. We drove by every day watching in great excitement of our new home being built, which we hoped would be our last home as we're in our 70s. Never did we see signs on the proposed drilling site. No one came to our door because we didn't have one yet. No one came, as there were no flyers in our mailbox and nothing laid on our doorstep. We didn't have one yet. It wasn't until we saw the sign put in the backyard of those that are the far west of us, and which came up ironically after the beginning of the construction of the last home on that west side, that we knew what was going on. So we were understanding it was zoned residential, and we feel misled and abandoned by the town of Firestone. How did they let this happen? That this property belonged to, that the property was bought by a home builder and that it could be so close. We trusted our town leaders to protect us. We're a small group in this tiny community, and we ask you to come, we come before you now to protect us. We have health concerns for Joe. He is a Vietnam veteran, and concerns for him as he's in his second round of cancer. I have autoimmune complications, and these are great health concerns to us, and our health is very important to us. So we just thank you very much for listening to us. Please say no to this. There's no way we would have purchased this property had we known this was all going to come to pass. We can't afford to move. We're retired and we are on a fixed income. This is our final home. We hope for it to be a home of a lifetime that we enjoy. Thank you so much. Good luck with your decision.
Thank you. Scott Colvin.
Good afternoon. I'm going to adjust my camera here so you can actually see me. My name is Stephen Colvin, and I live in the Falcon Point at Saddleback Development at 8936 Farmdale Street. And what I'd like to do today is briefly address and provide a little clarity to some of the previous testimony on property owner notifications as pertains specifically to this development. So Falcon Point at Saddleback consists of 3 streets. Ferncrest is farthest east, Farmdale's in the middle, Falcon is furthest west. Some of the homes on Falcon Street are within 2,000 feet of the proposed oil field. My home's about 2,100 feet away. We moved into our home in late June of 2021. When we moved in, Ferncrest was fully developed. We were only the 3rd completed home on our block on Farmdale. And the only completed houses on Falcon were at the entrance to the development. And one of those was actually the sales office. Construction over the summer and fall generally proceeded from east to west. Houses on the north-south segment of Falcon were not completed until October, November, or even into late December. The Kerr-McGee public meeting was on August 25th, long before any homes on Falcon and many on Farmdale were occupied. I didn't receive notification from the company, though I am slightly beyond the 2,000 foot mark. One of the things we did as soon as we learned of the proposal in public meeting was ask our sales representative with D.R. Horton if she was aware of the proposal. She told us she was not aware of the proposal. So that's really what I wanted to get to. And thank you for the opportunity to comment, and best of luck with a very challenging decision you'll have to make.
Thank you, Mr. Colvin. Ms. Larson, from my records, that concludes public comment. Are there more?
There's Ms. Leslie Robinson signed up. She would have been our last individual to speak, but she's not in the meeting at the moment.
Okay. All right. It is 2:31. Let's take the afternoon break and return. Let's return at 2:46. All right, welcome back to my fellow commissioners. Let's take a quick break. It is 2:46. We will start back up, and we have gotten through public comment, and I believe now we will bring the applicant back up to the panel for their presentation.
Thank you, Chair Robbins and Commissioners. If you could just give us one moment while our group is let in. Looks like they're trickling in. It may just be a few more moments. We will be doing a screen share, and I'm just waiting for the Kerr-McGee representative who is going to be running that PowerPoint to be let into the meeting. Looks like we've almost got our whole group here. Perfect. All right. Well, good afternoon, commissioners. I'm going to go ahead and get started here. Kelsey Wasalinki of Jost Energy Law, and with Jamie Jost, we represent Kerr-McGee and the Longs Peak OGDP. We'd like to thank you all, the public and all stakeholders, for your continued engagement in this OGDP. We're here today requesting approval of a 4,240 acre drilling and spacing unit and a 4,240 acre oil and gas development plan for the approval of the McGavin and Columbine pads for the development of 33 horizontal wells within the jurisdiction of the town of Firestone. After the February 16th hearing, Kerr-McGee took a hard look at the feedback received from you all and from stakeholders and is excited to present a commitment to enhanced best management practices, a deeper dive into alternative location analysis, and a design modification on the McGavin pad that will further reduce potential impacts. As you will hear from the Kerr-McGee team, by removing a modular large volume tank, or MLVT, from the McGavin location, in addition to water tanks, Kerr-McGee is able to reduce the working pad surface footprint for this pad and remove approximately 27 residential building units from the 2,000-foot radius of the edge of the working pad surface. In addition, it's important to highlight the fact that the proposed wells, tanks, separation equipment, and compressors proposed on the McGavin location will be located within 2,000 feet of 26 residential building units, and the proposed wells, tanks, separation equipment, and compressors proposed on the Columbine location will be located within 2,000 feet of 2 residential building units. We hope you consider these facts and Kerr-McGee's commitment to stringent BMPs that go above and beyond COGCC rules and provide substantially equivalent protections for public health, safety, welfare, the environment, and wildlife resources as you make your decision. We did e-file the PowerPoint presentation with information on Kerr-McGee's BMPs and ALA on March 3rd. And since that time, Kerr-McGee's made just a few revisions to its BMP commitments, public engagement, and site layout descriptions. These updates are reflected in the presentation today, which we will describe in detail, and I'm happy to e-file this updated presentation after the hearing. We also have a number of subject matter experts from Kerr-McGee with us who are available for after the presentation to answer questions and also to respond to the Earth Justice comments that you heard this morning. So first, I'd like to introduce Carson Muscat, who will be leading the presentation for Kerr-McGee. Mr. Muscat.
Thank you, Kelsey, for the introduction. Good evening, commissioners and Chair Robbins, and thank you for your time. My name is Carson Muscat, and I am the reservoir engineer that is supporting the Longs Peak application. Next slide, please. Today, I, along with our supporting team, hope to provide transparency and answer requests for further information posed during the initial hearing that occurred February 16th for this application. My comments and slides will be focused on 2 main criteria regarding 604B4. I will be opening the presentation with 604B4D, the alternate location analysis. Then I'll pass it off to Chris Honus to overview 604B4B, best management practices, known shortly as BMPs, were the industry-leading practices that we will be adopting. After the presentation, as Kelsey mentioned, we have a group of subject matter experts on the call, and we are happy to answer any questions on these topics or others. Next slide. Let's dive into the alternate location analysis to provide you with a more thorough look inside of the process, the options that we evaluated, and ultimately how we arrived at the proposed application before you. The first step in our process is to identify and evaluate every technically feasible location from a macro perspective by evaluating regulatory criteria and other applicable planning criteria, such as coal mine subsidence risk and building units. To do this, we have mapped each of the 9 ALA criteria laid out in 304B4B. For example, you have residential building units, high occupancy building units, schools, and floodplains. You see each of these 9 criteria mapped on the slide in front of you with the proposed DSU boundary shown in red. We use these maps in our evaluation of each surface location by combining them into a single overall buffer map that you'll see next. The center image here is that overall buffer map. Within it, you will find a few things. First, all ALA criteria per 304B2B minus jurisdictional boundaries are portrayed within the map by various shading and symbols as outlined in the legend. The red outline is the proposed DSU boundary with the current application. The green outline provides general guidance regarding drilling limitations and limitations traversing lands not pooled within the DSU to access the targeted minerals. While I encourage examination of surfaces outside of the green buffer like we did, many of those locations may be technically implausible or unrealistic in developing the proposed minerals like AOLA locations C and F, which we will discuss later. Lastly, you will see 17 flagged surface locations denoted by the stars and boxes, which are symbolic of the potential surface locations that we individually evaluated in the application, the AOLA, and the supplemental. These 17 locations are representative of the locations that, from a 304 B2B perspective alone, look to have the most potential in avoiding and minimizing adverse impacts to receptors and were further examined by our team. Sorry, real back. Thank you, sorry. Keep in mind, commissioners, while this may look daunting from a macro perspective, this is a sizable surface area being visualized. This image alone is a bird's eye view representing over 18 square miles. If you were to run around the DSU boundary, you would be just shy of completing a half marathon. When you zoom into the map and examine it further, the map begins to open up and showcase locations that may be suitable for development. Most of these locations that best minimize impacts are centered around the two enlarged areas of the map, including section blocks 19, 20, 29, and 36, as you see enlarged on the right-hand side of the slide. Even these enlarged areas represent 4 square miles of surface. A 1 mile scale is provided below the blue outlined section 36 on both the centered overall image and also the enlarged view on the right. Next slide, please. Each of those 17 surface location options from the application, the AOLA, and the supplemental went through a thorough holistic surface review to better understand the surrounding surface, receptors, and other potential impacts, as well as a subsurface review to understand the minerals that could be feasibly developed from each location. After understanding the surface and subsurface implications of each location, our team pieced together various development scenarios utilizing these locations. Each location is unique and brings a different potential to the table. Due to the sheer size of the drilling and spacing unit, 4.5 miles north to south and 2 miles west to east, or upwards of 4,200 gross mineral acres, we examined combinations of technically feasible surface locations that would be best options to assess the minerals while avoiding or minimizing potential impacts to human, environmental, and wildlife receptors. The top 4 scenarios of this mineral development we considered are shown on the right, the first of which is our proposed application. We took surface and equipment consolidation into consideration when and where possible, primarily through combining wells to create multi-well pads per Rule 603D, as not only does it limit overall surface disturbance, but also has material and positive impacts on cumulative impacts that you will see on the next slide. As mentioned, here are those cumulative impacts metrics per scenario. They are focused on disturbance area, interim reclamation, and estimated traffic. In addition, we have the RBUs and platted residential lots within 2,000 feet of the working pad surfaces shown in the bottom right-hand corner. This is where you can visually see the benefit of well consolidation on surface disturbance and cumulative impacts. For this reason, if feasible, a 2-pad development scenario was preferred. Now I will go through each top development alternative and provide highlights on the 3 criteria: the holistic surface review, cumulative impacts, and the subsurface. First, alternate C that you see in your bottom right-hand corner. As you notice, this scenario is grayed out and not plotted on the cumulative impact plots. This is because it was deemed unfavorable due to the surface evaluation of AOLA location 1, along with the additional RBUs and other additional receptors that would have been brought into the application with the addition of this 3rd oil and gas location. Next, alternate B, which brings AOLA location 3 into the picture. This scenario was deemed unfavorable for 2 main criteria. First, the surface evaluation of AOLA location 3 would bring in additional RBUs and receptors along with 195 platted residential lots now under construction to the south. In addition to the potential surface impacts, this alternative would have brought additional cumulative impacts as portrayed in the cumulative impact metrics shown to your left. Lastly, alternate A. This alternate was recognized as the second best scenario by our team, but was ultimately deemed unfavorable for 3 criteria used in the review. Alternate location A brings in a 3-pad development, and as a result would have greater surface and cumulative impacts as seen in the plots on the left. In addition, both applications utilize use of the McGavin proposed location denoted by the green star. The difference is the working pad surface size and well count. This results in many RBUs moving slightly beyond 2,000 feet away from the McGavin and dropping off of that plot entirely. This is at the cost of additional RBUs and the other receptors around 2,000 feet of ALA location 5. It is our desire to come up with the best overall development plan for an area, and not only locations that simply checked all the boxes. We believe that the proposed application is that plan. We will be protective whether it's 1 RBU or more. Lastly, from a subsurface perspective, horizontal stress in this region results in north-south lateral well orientation becoming more efficient, enabling us to do more with less and protecting the correlative rights of the mineral owners. From a high level, this is the process that we use to evaluate every technically feasible surface ALA location and how we arrived at the proposed application. The consolidation of McGavin has many benefits to the surface and cumulative impacts, one of which has been our team streamlining the surface design and removing equipment. While you see the RBUs around the permitted working pad surface in the plot on your bottom right, we have already taken significant strides to shrink that working pad surface and have since removed numerous RBUs from that 2,000-foot buffer. In addition, we have planned this location with equipment location and the residential building units in mind. If you look 2,000 feet from permanent equipment, including wells, tanks, separation equipment, the proposed McGavin location has 26 RBUs within 2,000 feet, which makes it effectively equivalent to the development alternative A from an RBU and platted lots perspective. As the benefits of the 2-pad scenario were material and positive, we also evaluated other 2-pad opportunities that you'll see on the next slide. While there are numerous combinations available to create 2-pad alternatives assessing various locations and quantities of previously underdeveloped minerals, you are now seeing 4 alternate 2-pad scenario examples. Each alternative shows their 2 pads via their surface flag, their resultant estimated well count, minerals developed, and minerals stranded due to technical drilling limitations. As noted, only the proposed scenario utilizes a McGavin location. In addition, the shading of the surface flag and the minerals to be developed from that surface flag are color coordinated for ease of visually digesting, including the red hash representing stranded minerals. When compared to the proposed application on the left, each alternative 2-pad development that we evaluated had either 1, unfavorable surface impacts by bringing in additional human, wildlife, and environmental receptors, 2, expansive mineral waste, the extreme example being that of alternate 2D on the far right, using the technically challenged ALA locations C and F, or in many cases, both unfavorable comparable surface impacts and expansive mineral waste. Next slide, please. To summarize our analysis, we feel strongly that the proposed Longs Peak application is the best scenario to capture the 4,240 mineral acres. It is the best overall application for the area that honors holistically the surface, the subsurface, and the cumulative impacts. We focused our development plan on consolidating and minimizing disturbance as much as feasible. The current plan will allow us to expedite operations, to reduce impacts to future residential building units and commercial building units, as well as prioritize 39 P&As and 10 facility removals of existing infrastructure in this area. Overall, with the strides that we have taken in designing the surface location in such a way to avoid and minimize potential adverse impacts, we estimate 26 RBUs to be within 2,000 feet of any piece of permanent equipment on McGavin and 2 RBUs within permanent equipment on Columbine. We recognize and hear the community, and as a result, we are adopting industry-leading BMPs that go above and beyond to avoid, minimize, and mitigate potential impacts. At this time, I'll hand it over to Chris Honus, who will touch on those in more detail.
Hi, everyone. My name is Chris Honus. I'm the drilling manager for KMOG. I cover our Rockies region. I've been in the industry focused on drilling for 15 years and had the privilege for the last 8 years now of focusing on the DJ Basin with KMOG. I want to talk through some of our best management practices that we've adopted and also walk through how those best management practices align with the CDPHE's recommendations for the McGavin pad provided on January 7th of this year. As I walk through this list, I'm going to start out with number 1, and the numbers align with the CDPHE's recommendations for BMPs. So the first one is the fact that we are going to commit to an electric drilling rig on the McGavin pad. We've worked with the utility company in the area, and they've confirmed that that won't be an issue to be able to run a rig on electric power with the power supply needs for the area. Number 2, we've decided to enhance our tankless design by agreeing to use water pipelines for produced water. This BMP is contingent upon getting our easements that we need and licenses, but we have extremely high confidence that that's going to happen. We only put this in there because we don't have them today, but we're going to get them. Number 3, vapor recovery units. Because of our tankless design, vapor recovery units become unnecessary in that design, and so they are essentially not applicable. So with the tankless design, you just don't need vapor recovery units. So that one's non-applicable. Moving down to number 4, KMOG agrees that minimizing flaring is extremely important, and we are committed to adopting the BMP of shutting in the facility if the pipeline ever becomes unavailable, minimizing any potential flaring needed on the site. Enhanced notifications are part of KMOG's absolute standard practice. We have decided to make that more official by writing it into the application as a BMP. Air quality monitoring was requested by the CDPHE through using their CAMEL unit on location. We are committed to working with the CDPHE to make sure that their CAMEL, as requested, is located near the site, and we'll work with them to find a way to make sure that has power as well. Moving on to the next 4 items, they're related to odor, and specifically with the drilling mud. KMOG has committed to using a Group 3 drilling fluid. Group 3 drilling fluids are associated with no odor, so they combat odor, but even more importantly, and probably what hits home more, is that this is a 0 VOC fluid, which will eliminate any risk of VOCs during the drilling operation from the drilling fluid. To go in combination with that, we're also going to use chillers, which would reduce any potential chance of VOC and reduce odor. Cuttings transport has been a complaint in many years past for some operators. We're going to agree to cover truckloads of cuttings during transport. In addition to that, we're agreeing to use, we're committed to using centrifugal dryers on location, running those cuttings through the centrifugal dryers to ensure that any remnant drilling fluid is pulled off of those cuttings before they're transferred. And anything that could be left is that Group 3 fluid that doesn't have odor associated with it. The one item that we are unable to agree to, and which we have met with the CDPHE since our last meeting and discussed, and I believe come into alignment with, is that enclosing the shale shakers on the drilling rig poses a safety risk. This is a Class 1 Div 1 area, which means there's risk of potential gas in that area, and enclosing that area would not be safe. So the CDPHE, I believe, will be able to speak to that, but they're in agreement that this one is not one that we want to adopt on the drilling rig. The ozone mitigation measures, we are voluntarily adopting that and committed to agreeing to the ozone action mitigation days. We do not use PFAS in our operations, so KMOG has made that official by putting it in as a BMP. Backup alarms is one that we met with the CDPHE and discussed. OSHA has basically regulations that say if equipment that comes with a safety device when it's originally manufactured, that you can't remove those. And so it's an OSHA violation for us to try to remove backup alarms from our equipment. And in addition, it just wouldn't be safe practice anyways. Our third parties that operate that equipment wouldn't agree to it, and we don't think it's a good idea. We've talked to the CDPHE on this, and we agree that this is one that we don't want to adopt for safety concerns. But to highlight, number 13, all noise emitting equipment will be confined behind the sound walls, and we have adopted that as a BMP, and that would include those backup alarms on the loaders. I don't know if I said it at the beginning, but again, you see it at the top. These are the BMPs specific to the McGavin pad. If we can jump to the next slide, I'll go into the BMPs specific to the Columbine pad. They are almost exactly the same. I'm just going to highlight a couple of very minor differences. On the Columbine pad, we are committed to adopting the BMP of using an electric drilling rig on this pad as well. There is a small caveat to that. Our base plan is going to be to use an electric drilling rig. Because the Columbine pad can't supply the amount of electricity needed today, we need to work with the utility company to upgrade the electric grid in that area to be able to use an electric drilling rig. That is what we plan to do. However, the timing on that is going to push the spud of the pad out into 2023. We're still working with the utility company to understand that exact date. But our base plan is to use an electric drilling rig. If for any reason we thought that by delaying that pad, that posed adverse safety issues or risk to anyone's welfare, we would then agree to use a natural gas drilling rig. But our base plan and our BMP will be an electric rig on this pad. The only other difference here is that the CDPHE has not requested to place their camel unit on the Columbine pad. So we haven't put this in as a BMP, but we would absolutely commit to working with the CDPHE to put their camel on the location if they requested. The rest of the Columbine pad would have the exact same BMPs as the McGavin. We can jump to the last slide here. So the last point that I wanted to make before we move away from our best management practices and how those align with the CDPHE, I just wanted to highlight the graph on the right that shows where KMOG ranks in comparison to our representative peers in Colorado as it relates to greenhouse gas intensity. KMOG is very proud of the progress that we have made over years to be the leader in the industry for minimizing greenhouse gas emissions. We do that through a number of different methods, but the three highlighted on the right are our IOC, or Integrated Operations Center, which provides 24-hour real-time monitoring of all of our operations in the field. We also use water on demand, which allows us to pipe water to location and avoids many truck trips back and forth. We also have our tankless facility design, which eliminates tanks on location, which gets rid of that potential for venting. If there's any other questions, I can answer them, and I will pass it on to Julie for maybe a quick closing remark here.
Thank you, Mr. Honus. Good afternoon, commissioners. My name is Julie Coleman, and I'm the Stakeholder Relations Manager. We appreciate the 8 nearby residents who spoke at the hearing on February 16th, shown here on the map in blue. Since the hearing last month, we have had 16 contacts or invitations to connect with those who spoke, along with several conversations with other stakeholders. Removing the water tanks on the west side to reduce the residential building unit count by 27 demonstrates that our teams continually evaluate opportunities to position our operations as far from homes as technically possible. The wells, tanks, separation equipment, and compressors at McGavin are more than 2,000 feet away from all but 26 residential building units. We will continue to build trust with those who spoke today and with the greater community by keeping our website up to date with project updates and air monitoring summaries, offering email update subscriptions, holding a community meeting before construction, and sending all required notices. We are always willing to meet with and listen to our neighbors and invite our neighbors to connect with us in person or by phone, email, or website. Thank you for your time.
Thank you, Ms. Coleman. Well, this concludes our presentation today. Again, we ask for approval of the 4,240 acre oil and gas development plan and corresponding drilling and spacing unit, the approval of the McGavin and Columbine pads for a total development of 33 horizontal wells. And with that, I'm going to open it up to our group of subject matter experts. They're able to answer questions on today's presentation, also on the proposals that were relayed by Mr. Freeman earlier this morning. And we're happy to keep the maps up in our presentation if that would be helpful.
Thank you. I think probably keeping the maps up is a good idea. So let's keep the screen share up. Do commissioners have questions? I'm sure we all do. Who wants to start? Commissioner Gonzalez, I think beat you by like just a hair, Commissioner McGowan.
Thanks, Chair. And it's not going to be, it's not a race and we'll all have our time. I just have one question to kick us off because I want some clarity as I think through this. With regard to the McGavin redesign, and the way I understand it is there's going to be a water tank removed from the west side of the pad. And I wasn't quite sure if I understood what you said, Ms. Wazelenke, and I guess also what Mr. Honus said. Are we talking about reducing the number of RBUs by 27 or reducing the number of RBUs to 27?
Thank you, Commissioner Gonzalez. It's a nice point to clarify. By removing the modular large volume tank, which is also called an MLVT, in addition to the water tanks, we are able to reduce the working pad surface footprint and remove 27 residential building units.
Thank you for that, Ms. Wazelenke. That's helpful. I'm going to put my notes together as to kind of walk through this on the information that was presented, so I'll pass it to my other commissioners.
Ms. Wazelenke, what does that, I mean, run the math for me. What's McGavin at now at 2,000 feet or less?
I'm going to probably defer to the Kerr-McGee team to get the exact number. I did give you some figures at the outset here, measuring to the tanks, wells, separation equipment. That's 26 on the McGavin pad within 2,000 feet and 2 on the Columbine pad. I want to make sure I don't misspeak. So if you could just give us a moment, we'll get you the numbers measuring from the working pad surface.
Yeah, I can take that question. Thank you, Commissioner, for the question. My name is Shay Marshall. I'm a regulatory advisor with OXC. So with the removal of the MLVT, the residential building unit count drops from 89 to 62 total from the working pad surface.
Okay, thank you. Commissioner McGowan.
Thank you, Mr. Chair, and thank you for the follow-up information. I'll start off with probably some very basic questions I'm hoping you can answer. Can you go back to the picture of the McGavin and the Columbine pads? And I'm wondering if someone could explain to me why the Columbine is so small, the minerals that it is extracting compared to the McGavin, and why the Columbine pad couldn't be expanded to collect more minerals. If I'm reading the map right, the Columbine is the blue,
Yeah.
and the McGavin is the green.
I can take this one from a drilling feasibility standpoint. The Columbine, as you can see, it's a little bit more than halfway up the section from the southern border. Those back builds that you have to do on those wells to be able to drill backwards, turn the well around, and then head back to the north, it's very difficult to do that. And so the amount of step out to the west that you're able to do is limited in compared to the McGavin pad, where you're not doing quite as big of back builds or as long of wells. That Columbine pad is basically reaching the limit of what we can do on those back builds and step outs for that far western well.
Okay, thank you. Can you please also expand on a comment I saw in the PowerPoint and in your written comments that it is more difficult to drill in an east-west direction? And I'm not quite sure I understand why, and if that means it's infeasible or it's just more difficult.
From a feasibility standpoint, the drilling isn't more difficult to go east-west. The drilling would be the same. It's when you complete the well, when you're going in the east-west direction, the minimum versus the maximum stresses cause the fracture growth to not go in the direction that you want to be able to move away from the wellbore. It ends up moving more parallel with the wellbore, and you don't stimulate the reservoir effectively. And that isn't my expertise. We could have Corey Altenberg jump on and give more detail if you need it, or if that answers your question well enough.
I can jump in and provide.
Okay, yeah, maybe you want to expand, because it seems like one of the solutions would be to go east-west and be able to cover a large amount of acreage.
Yes,
And
Rachel.
it would
could you
also,
go to
well, let
slide
me
number
just jump in. It would also be helpful to not just say it's less, but like talk to us about numbers.
Yep. Rachel, can you please go to slide number 6? That is the comment they are addressing. Yep. So right at the bottom of this, we have the comment next to ALA or alternate development scenario A. That ALA or alternate development A requires east-west drilling, which counters subsurface geologic stresses present in the region. So from a geologic perspective, we have numerous stresses and pressures that we are dealing with, the most common of which is a overburden pressure or a pressure in kind of that Z plane due to overburden rock. However, we also witness something that we call a horizontal stress, and that is a pressure, a geologic pressure that is applied in that horizontal axis. That commonly has directionality associated with it, and we refer to that as a zone or a direction of maximum horizontal stress. And that horizontal stress, in short, acts as a natural resistor to our drilling completion style, and thus favors north-south development over east-west development. It is possible and plausible to drill east-west, and in that situation, we do have that alternate development A being the second best option that we evaluated, which utilizes that east-west development. In order to quantify it, really what it comes down to is inefficiency associated with primarily the completion process. And to put it in terms of numbers, that inefficiency, if we were really trying to develop the minerals in the same overall efficient manner, would require us to add wells onto those eastern locations, locations 5 and C that you see in that alternate A. That would really bring the overall well count to that alternate A situation, where like development and like mineral development to more of a 37 or 38 total well count, as opposed to our current application, which develops the same minerals with 33 wells. So when I say it is inefficient, I am not purely speaking to an economic perspective, but also from cumulative impacts and also material waste associated with drilling additional wells that wouldn't be necessary with lateral orientation in a north to south direction. And my easiest way to describe it is if you look at those maps, those are screenshots from the COGCC site. The purple wells are existing lateral wells. And as you noticed, every analogous development around us are in the north-south orientation for this very reason.
Thank you. Before I ask another question, do the commissioners want to ask anything else about that?
Can I ask a quick question? Because it has to do with this alternate. So when I went back and looked at the application materials, and I'm not a petroleum engineer, but I looked at the maps that you supplied in your application, and it appeared to me quite distinctly that Columbine is not where you guys have it located in this map. In fact, Columbine was much closer to that section line, so it was up. Can you help me with that? I also spoke with our permitting engineer and they agreed. So I'm confused.
Can you please refer to which document that was supported in, and I can look that up real quick?
Oh, I don't remember exactly which documents, but I talked with our team and they agreed that in looking at the permit applications Columbine was much closer to the section line than has been represented in these documents here. And that might make a difference in terms of how many minerals you're able to get.
Mhm. So I will say that Columbine is situated directly adjacent to the directional pad that you see with some of those directional wells directly to the southwest of the Columbine pad. So the star on these maps that you are seeing currently in relation to that directional pad currently existing and in production, I'm fairly accurate or positive that this Columbine location is accurate, but I can look up for a little bit additional information.
Okay, and I'll try to find my notes. Thank you. Commissioner McGowan, you can proceed.
Thank you, Mr. Chair. I'm wondering if you all could respond to the comments we heard from Mr. Freeman this morning about the ability to do longer laterals, which might provide an opportunity to move the well to the pad site to a different location. And then in addition to that, thoughts about, and I realize that they don't have the information that you do, but they came up with lots of other suggestions for sites. And wondering if you have any thoughts about those comments as well.
Yes, so I can touch a little bit on Mr. Freeman's comments, and on behalf of COGCC, I thoroughly appreciate and want open dialogue with regards to the alternate location analysis. And in part, that is, we hope to have that established connection with the pre-app meeting, a meeting with local governments all the way through this phase. So more than happy to provide my thoughts and our thoughts on those comments. So with Mr. Freeman and COGCC's analysis, they were primarily looking at alternate locations to the south and to the north that would have enabled us to reach the minerals with longer laterals. And we did evaluate other locations that you do not see. And Rachel, I'm going to have you go to slide 5 real quick for a visual. Yeah, perfect. So we did look at other locations than what you see flagged within these 17 service flags. We utilize these AOLA maps and the different layers that you the 10 different layers that you see on the previous slide as our fundamental starting point. But we also go much deeper than that. We drive these locations, we get boots on the ground, we visually go and look at them and go through very thorough field reviews and surveys of these parcels before we even consider putting oil and gas locations on them. So in regards to a few locations that he was looking at, I believe they were denoted as location I and J, which are on the southern end of our map. And I will make, I guess, the belief that they are in, as they made the claim, in more white spaces. But really what you are seeing is just because those white spaces exist does not mean they are suitable from a surface perspective. Again, I will go back to some previous comments regarding that dashed green buffer, which we utilize as a general guideline for not only our drilling limitations, but also our limitations traversing lands not pooled within our application. At that green buffer, you stop, or we stop, or I guess these maps stop showing the exact residential building units. And that is primarily seen on the southern end. So at the very southern end of this map, in that red dashed section, right at the bottom centered to the left of the legend, yeah, right there. So that is actually the AOLA layer for a DI community, a disproportionately impacted community. That red layer in its entirety is a residential development. There are hundreds of residential building units down there, just south of County Road 52 right there. So in fact, AOLA locations I and J would have been directly adjacent to additional residential building unit receptors. And on top of that, it would have been adjacent to that of a DI community. And that is the reason why it is not favorable from our perspective, not because we didn't look at it. We did evaluate additional locations. Likewise, on the north, we do have maps in-house that extend beyond what you are seeing here today. Locations F and I think they utilized locations G are really challenged from a drilling technical capability. And they really have about a 7,000 foot step out for a 2-mile lateral, which we do not have any, I guess, confidence that we can make that work from a technical drilling feasibility perspective. In addition, that location G appears to be within an open gravel pit mine location. It is within additional residential building units, within 2,000 feet of additional residential building units to the south that you see on the edge of the map. And it's on top of that within a floodplain. So while I appreciate and acknowledge that there are other potential surface locations that you don't see flagged, we did evaluate potentially longer laterals to assess these minerals. And do you have any follow-up with that? I know that was a very long-worded response.
I have more questions, but it's a different question. So I just wanted to see if any other commissioners had some questions about these alternative locations.
Mr. Mester?
Thank you, Mr. Chair. So, Mr. Muscat, I wonder, I got a little bit of information that kind of talked about some of the other things that were considered, but where in the alternative location analysis or the narrative or the information that you provided is this information that indicates that these other sites were analyzed and not considered?
Yes, so basically how we do that is, again, and Rachel, I'm going to have you go back one additional slide. Sorry, to slide number, yep, right there. So within our review of the location, this is really our starting point and our ability to evaluate every technically feasible locations, or at least to the best of our ability. So we look at Rule 304 B2B and map every AOLA criteria within that and take a really close look to residential building units, high occupancy building units, and schools, along with the other criteria that you see within here. So whenever we flagged our 17 service locations, that is from a high level, a macro perspective, the 17 service locations that best avoided and minimized those potential surface implications. So everything else, again, we review it from a macro perspective. We didn't necessarily look at just that location I, for example, but we did note that there is a DI community and residential building units just to the south of that location, and we ruled it out of the process, and thus you do not see it within 17 individual locations that we really dive into deeper to better understand not only those parcels limitations, but truly what a working pad surface and what equipment would look like on each and every location.
Thank you for that response. Now, understanding that, I think what you're seeing here and what I read in the alternative location analysis seems to indicate that, one of the criteria that you utilize as far as developing feasibility is whether or not you've pooled those areas and whether or not there's surface use agreements in place or there's the potential for surface use agreements in place. Also, it seems like one of the criteria utilized is that 2-mile laterals need to be the maximum that have to be considered. So was there a consideration for longer laterals? Was there a consideration for lands that were not pooled or did not have existing surface agreements? And did you do the analysis of different locations prior to securing surface use agreements that may minimize some of the options that you may consider?
I think I was, Commissioner Rader, do you want to start real quick?
Anthony, you can jump in. Just real quick, I might be able to answer some of Commissioner Messner's questions. The locations that were shown this morning, a lot of those are so far outside of our drilling feasibility window that they really weren't even considered because we just couldn't feasibly drill from those locations, particularly the ones up in the north, location F and I believe it was G up to the north. Those two locations would require step outs of over 7,000 feet to capture all the acreage from up there. Currently to date, KMOG's biggest step out is just under 4,000 feet at 3,900 feet. We have permitted wells to push that limit significantly, and we currently have permits in hand where we're going to go drill wells with 5,000 foot step outs. But to try to jump all the way to 7,000 feet, our modeling indicates that it just isn't technically feasible. And so those locations got ruled out fairly quickly.
Let me ask a question on that one before you go to someone else, but seem to Well, testimony seemed to indicate that an operator like Great Western was utilizing longer step outs. So is the technical feasibility on Kerr McGee's ability or technical feasibility of operations in general?
So speaking for KMOG specifically, we are easing into longer and longer step outs and pushing that limit. I have not heard of anyone in our industry that's done 7,000 foot step outs in the basin. It may be possible that somebody's out there trying to give it a shot, but from all of our modeling, all of our available equipment, all the technology that we have, 7,000 foot wouldn't be possible. So we don't feel like we can go there. I don't believe anybody stepped out that far. And my guess is they're measuring a little bit differently than factoring in the back build and the curve and the extra 1,000 feet that adds into the step out distance. I do know that one operator has done a forward build, straight forward build of about 6,000 feet, but 7,000 feet is just pushing it. And especially with step out to the side plus forward build, that makes it more complicated. Hopefully that answers what you want. I can go into more detail. I can talk to you about the modeling and the programs that we use. I don't know if you want me to go down that path or not.
I mean, I think if someone could address the 3 mile versus the 2 mile, that would be helpful. And anytime an application comes in, if there is modeling that has been done or analysis that has been done, then that's really helpful information to include in an application, rather than having to do this kind of question hand-holding process of trying to, drill up this information. So just a FYI on that.
Thank you, Commissioner Messner.
Yeah, I understand, John.
I can answer and expand upon this a little bit. Rachel, can you go to slide number 8, please? Thank you. So to answer your question as quickly and easily as I possibly can is yes, we did consider up to 3 mile laterals in order to develop these minerals. So that was our limit on what we were evaluating. We did evaluate 3 mile laterals, but with that, we do have step out limitations associated with it. So the easiest way to describe it is we can step out further and kind of have further reach for a 1 mile lateral than a 3 mile lateral. So we have more limitations due to our technical ability the longer the lateral gets. So a 3 mile lateral is about as far as we feel comfortable, and we did utilize that in the planning process. So the reason why I wanted to bring up this slide is if you look at alternate 2D, the far right one, you see what we could technically drill from both locations F and C. The main reasons why you only see about a 2 to a 3 well development kind of in that northeastern shaded orange region is the fact that you have roughly a 5,000 foot step out or a 1 mile step out. And from there, you can drill a 2 mile lateral. We do not have the technical ability to drill a 3 mile lateral with that amount of a step out. Likewise, for location C, albeit it is farther from residential building units, due to the existing horizontal wells that you see under that location, kind of in the shaded purple lines north to south, we have massive anti-collision concerns. We did model that location C, and we determined that it was technically not feasible to drill any of the minerals from that location C due to the existing horizontal well infrastructure that we would have to drill above and through to make that happen.
Okay. I think that's the questions that I have on the alternative location analysis. So I'll hold off with some of my other questions until we move on from this.
Commissioners, do we want to keep in track of questions on the ALA and kind of exhaust that first before we move on? Okay, Commissioner Najapa.
Thank you, Mr. Chair, and thank you for the responses so far. I think the first thing that struck me, and I understand that in the slide that you have up right now, that you were really trying to focus on a 2 pad scenario. But when I looked at this, I thought, why not E5 and the Columbine pad? I wondered if you could talk about that a little bit in terms of being able to get the minerals that you could. The other thing that I wanted to just know, because this, as far as I could see, was not in the information provided, was what were the residential building units around these different alternative locations that you were looking at?
Yes, I can answer that in a little bit, and I might need you to restate the second question after I answer the first, just so I can make sure I answer it fully. But the first question, as I understand it, and you are absolutely correct, and I appreciate your understanding of this, Commissioner, is that there are other alternatives and various combinations in order to assess these minerals. One of those alternatives would have been a combination of E5 and Columbine, which is basically a combination of alternates 2B and 2C that you see on the screen in front of you, or a 3-pad development scenario that would effectively be developing the exact same minerals that our current McGavin Columbine application is developing. So from our analysis, the main reason why that was not one of our top 4 different scenarios that we listed on the prior slide is due to the alternate location analysis of location E. So alternate location analysis of location E, and let me pull up the numbers real quick so I can make sure I get them correct. But in short, alternate location E has more residential building units, more human, wildlife, and environmental receptors in that location than the McGavin location. So from a ALA location E perspective, we would have 232 residential building units within 2,000 feet of that working pad surface, and was therefore deemed unfavorable to the current application due to the additional residential building units.
Okay,
and
so
then,
I'm sorry.
Sorry,
Just
can
a
you
quick
please-
clarifying question. You said over 232 just for pad E, or that was in total including?
that would be just pad E, but pad E would be primarily the pad with the most residential building units within 2,000 feet.
Okay, thank you. Sorry, continue.
No, I was just going to ask you, thank you, ask you to restate the second question just so I can make sure I answer that one fully.
I think you just answered it. I mean, I think in general, what was difficult for me in looking at what you provided was that there was no information about those other sites, at least that I found. And if I missed it, please point me to it. But there was nothing about how many houses were near E specifically. I know there was some information in the in a couple of different places that, kind of had, different sites that were located, but it wasn't clear to me, which one corresponded to which in the diagrams here. And so that made it a little bit more difficult to analyze for me. But I think you answered it with respect to E, but if that information is in another file that I just am not recalling, then that would be good to know as well.
Yes, and I can answer that super quickly for you. So, and sorry, Rachel, I'm having you jump around way too much, but can you please go to ALA or slide 5, please? So on the slide 5, it's more or less broken out in the different criteria that we have with the surface location flags. So both the stars and the darker blue numeric locations were provided in the original alternate location analysis provided with the Form 2A. And we do have the residential building units within 2,000 feet provided with that application. And then for the teal alphabet locations A through F, those residential building unit counts, along with other human, wildlife, and environmental receptors within 2,000 feet, were provided within the written narrative that was provided on Monday.
I can follow up on this line, Commissioner Nanjapa, unless you have others. Okay, so first, I guess I have to express some frustration from at least this commissioner's perspective. And I realize that we're all learning this process, but this information and the way that it was delivered in the original ALA and then this new ALA and then a narrative on Monday that's 15 pages long or whatever it was, it's just hard to get your head around what's doable, what's not doable, how many RBUs are nearby, how many are not, what potential set of locations if you do more than one, and how many minerals are being developed or how many minerals are stranded. I mean, I can show you, this is, it doesn't really do well. I took your page 5 and then I went through all the other materials. And so I actually have RBU units on each one. I had to create that myself because you didn't have a document that did that. And that's very frustrating. And I still don't really have any real sense of, for each of the locations, how many minerals are being developed or not developed. And that's frustrating too. And because if you don't have that, then it's hard to, and I also don't want to be doing the ALA. I want you guys to do it. And, but I still feel that we're missing a thorough analysis that tracks the bet, you know, as we heard today, the ALA ought to establish, number one, whether there is a better location or not. And I'm still not thinking we're there. Like, here's an example, Mr. Muscat, location B. Do you see that? It's below McGavin. From my analysis, it seems like that would develop a lot of the minerals, and it only had 33 RBU units within 2,000 feet, not 82 or not 67. But I didn't see any analysis of that in your documents. But I was wondering if you did B and 3 and 5, that's 33, that's 43 RBU units total within 2,000 feet. And it seems like that would be something that ought to have been analyzed, but it wasn't. So I don't know, I'm sorry if I'm expressing frustration, but, and I realize that we're all, you know, learning this as we go forward. But it seems like we could have gotten, with the request that we made a month ago, kind of a redo, looking at this from the perspective of trying to move away from people, trying to develop up as much minerals, but also understanding that perhaps there is going to be some stranding. And I'll be honest with you, Attorney Weselinski, I was disappointed in the narrative at the end where there's a lot of reference to correlative rights and you need to, you know, develop all of the minerals. And there was not a recognition of the fact that waste, and the definition of waste is now that it's okay at times to strand if necessary to be protective. And I think that needed to be a part of your equation. It needed to be a part of your analysis. And I was really disappointed that it was not. I don't know if there's a question mark behind all that. There's definitely some frustration.
Chair Robbins, I'm happy to address that. And I'd just like to take a moment to acknowledge your frustration. I don't want to discount it, neither does the team here. This is a lot of information. And after the last hearing, we were given a directive to take another hard look at ALA, in addition to enhanced best management practices. And so I think the team, you know, really did that. They put a lot of hours and a lot of work into the product before you today. That was intended to be relayed in this PowerPoint, which would be coupled with a presentation. After further discussions with staff, we just realized, you know, the Friday after we submitted this original PowerPoint, that a narrative would be helpful for you all. And so we do apologize for the delay in that getting into your portfolio, but the intent of the narrative really was to walk through this PowerPoint and the information here and provide that level of detail. We did do the ALA tables within that narrative, which did have RBUs from each one of these new locations, A through F. So I do just want to note that we did put a lot of that information from the ALA rule 304 into the narrative. And you know, we're here today to answer these questions. I think our team is fully prepared to address multiple scenarios and has answers to, you know, every alternative that you would like to discuss. I'd just like to reiterate that this is a large development area and there are a lot of alternatives. Rule 304 does limit alternative location analysis to locations from which the targeted minerals can be accessed. And so there's surface consideration, there's sensitive receptor considerations, there's technical considerations. And I think the intent of this group is certainly to relay that and answer your questions, recognizing that we are throwing quite a lot of information at you. I appreciate your comment on the statutory citations. I think it's important to recognize that protection of correlative rights, efficient development are still in the statute, and 100% recognize the changed definition of waste. And I think, based on the totality of circumstances, the proposed locations before you are protective and do meet substantial equivalence. And therefore stranding any minerals could be considered waste. So I would just like to make those points and offer this team before you to answer questions and have this dialogue. And hopefully we can answer your questions by the afternoon.
Thank you. Commissioner Najapa.
Thank you, Mr. Chair. And I want to thank you specifically, Chair Robbins, for expressing that frustration, because I was getting there. I hadn't quite gotten there yet, but this was frustrating. I mean, the fact that, so thank you for pointing out where the information was that I was just asking about in that narrative. That was the piece that was missing from the PowerPoint. Obviously, the narrative we just got late on Monday night, and we had other things that were going on in the last couple of days. And that's on me for missing it, but it really does speak to the time that's needed, to be able to look at all this information. And that was frustrating. I think the other thing you just mentioned is that, you talked about the limitations of the 304B, the alternate location analysis to targeted minerals. But I know specifically that I mentioned in the last hearing that I would like to look at other locations beyond what you specifically were trying to target here. The other point of frustration is that the majority of our comments that we received, the public comments on the day of that hearing, were in relation to the McGavin pad, and yet almost none of your alternate locations have a different proposal that does not include the McGavin pad. So I just want to express frustrations. I feel like we asked some very specific things, and those I don't feel were addressed.
Commissioner Messner.
Thank you, Mr. Chair. But I think it's important for us to remember that it's not this commission's responsibility to hold the hand of an applicant in determining what there needs to be in an alternative location analysis or needs to be in an application, but rather analyze and respond to what's being proposed by the applicant. And so while I think there's been attempts to encourage certain considerations by the applicant, they can make the decision to make those considerations or not, and we can utilize what's presented to us to make a decision on this particular application. And so, I continue to see this commission trying to help the operator help itself in a lot of situations, and that's not our responsibility as a commission. So I think, at least from this commissioner's standpoint, that's what I would remind ourselves.
Commissioner McGowan, then Commissioner Gonzalez.
Thank you, Mr. Chair. I want to move on to a different subject. So if Commissioner Gonzalez wants to express frustrations, I will open that door if he wants to go there next.
Commissioner Gonzalez.
Thanks, Chair. I'm not looking to express any frustrations. I think those have been made pretty clear by the other commissioners. And I've been through this process before. I know what it's like to endeavor into such an analysis from the operator side, and there's a lot of inputs there. And I guess one of the things that I was thinking about in reading through these materials is these are not, as I see it, a menu of options for us to choose from, right? This is a demonstration of the process that the applicant went through in order to arrive at the locations that have been proposed to us. And that's the proposal that's before us, right? It's not option E or number 5 or what have you. It is McGavin and Columbine, and we're going to have to make a decision on that. So I'm not interested in as one commissioner, playing armchair quarterback on where these are going to go, where they should go, or any myriad of iterations that could come out of these alternative locations, any alternative locations that weren't included, any combination thereof. And so really, what it comes down to me is we've got these two proposals ahead of us. And I'm curious, in your alternative location analysis, are any of these other locations executable in an executable state? Or are they just ideas?
Thank you, Commissioner Gonzalez, and all the commissioners preceding that. I know there may have not been a lot of question marks in some of those comments, but I do want to take an opportunity to address some of the comments. So first, Commissioner Gonzalez, I'll answer your question of, you are correct. Every other alternate location that you are seeing are simply, I guess, ideas and potential executions. They are not ready to be executed on. We do not have the correct legal rights in place to pivot to these plans before you. In addition, the current application is for the proposed McGavin and Columbine location. So you are correct in those claims, but I will try to address a few points from primarily Chair Robbins, but if there's anything else, feel free to ask and clarify. But our goal with the alternate location analysis and then the supplemental that we provided was to showcase the process that we utilize. The 17 surface locations that you are seeing on the slide in front of you currently went through a very thorough surface and subsurface evaluation by our team, and we are prepared to speak to each and every one of these locations. We did not want to come to the commissioners today and provide a list of potential options. We wanted to showcase the process and then have an open dialogue and conversation on how those could potentially be pieced together, and ultimately why we felt the proposed application was superior. We provided the top alternatives from our opinion, and those are primarily seen in slide 6 and 7 in a high-level analysis. But if there are any other questions regarding individual surface locations, we are prepared to talk to those. And I guess with that, would it be beneficial for us to introduce slides showcasing that we have reviewed each surface location and how each surface location affects the surface and the minerals that it could be, I guess the minerals that could technically be feasibly developed from that surface? If you would like to see those slides, we do have them prepared and we are ready to show them to you if you would like. And just for an example, Rachel, can you please go into, it's within the backup slide, but slide 24, it is the in-depth review of AOLA location number 1, for example. Rachel, are you sharing your screen?
Yeah, if you can give us just 1 minute, we have somebody else share their screen, and I think he's working on getting those backup up. So just 1 moment, please.
Thank you, Shay. So yes, if there are any questions regarding any of those 17 surface locations, we are prepared to talk through each and every one of those and what implications they have in the receptors from a surface and subsurface perspective. So our goal with the AOLA and the narrative was to provide you with how we make that happen and to not bog you down with a 3-hour slide deck of all the potential combinations of locations. And again, this is 4,240 gross mineral acres. So there's really an infinite number of potential AOLA locations that we could feasibly look at. So we're trying to narrow it down to a perspective of reality. And then again, sorry, Commissioner McGowan.
So thank you. From this commissioner's perspective, unless you want us to consider another scenario in this hearing today, I don't need to go through the other scenarios. I understand that you've gone through your iterations and these are the 2 best places that you feel that you want to present to the commission as your OGDP. And I personally, I don't feel the need to go through all the other iterations since that's what is before the commission for deliberation.
I agree with Commissioner McGowan, and I think that echoes off of the statements of Commissioner Messner that, you know, we're not here to, you know, we're here to determine whether there are substantial equivalent protections for McGavin and Columbine and whether that those two are approvable. And you're right. You know, we asked for some additional information. We got some additional information that I think ultimately we should just focus our inquiry on that point. Commissioner McGowan and Commissioner Messmer.
So for me, that's a great segue. I would like for us to discuss just substantial equivalency. And again, I think that you heard Mr. Freeman and Logic talk about some ideas regarding substantial equivalency and how it might be better fleshed out. And so I guess I'll just open it up and see what your response might be to that. I think it is difficult. We did not spell out what substantial equivalency has to be. We gave some suggestions and ideas and things that you could do. At the same time, it is difficult to establish substantial equivalency based on narratives about BMPs. And even though they might be the gold standard right now, or maybe there's even better things out there that we haven't even discussed yet, I'm not sure as a commissioner how I'm supposed to decide if that is substantial equivalency. So I would love to hear some thoughts about that.
Thank you, Commissioner McGowan. I'm happy to start that discussion. I think it's important when we think about substantial equivalence, we have rule language and we have language in the statement of basis and purpose. And within that statement of basis and purpose, it recognizes under 604B4 that meeting that substantial equivalence protection can be done in a variety of ways. And some of those ways are alternative location analysis. So you know, we have described that to you today. We've got you know, our slides and our analysis and our narrative that shows a substantial alternative location analysis and why these two locations are before you today. It also considers facility design, and I think that's a really important component. You know, just after the February 16th hearing, this team went back and made some changes to facility design to further reduce impacts. Adherence to best management practices is another factor. You know, you've heard from the team that they've met, you know, nearly all of the CDPHE recommendations. And I believe, you know, on those that aren't being met, they've got consensus from CDPHE on why they're not being met. Control technologies are another one, and permit conditions of approval. That's coming straight out of the statement of basis and purpose. And I think it's important when we talk about how you show substantial equivalence is that the statement of basis and purpose also makes it clear that the commission did not intend to set a standard that requires the commission to compare potential impacts of a proposed oil and gas location to an identical oil and gas location 2,000 feet away from all residential building units. So I think there's some discussion by Mr. Freeman this morning about, you know, doing some modeling or comparison analysis. And, you know, the commission's own statement of basis and purpose says that that standard may be unachievable, and it would elevate distance as the sole or predominant regulatory tool to protect and minimize adverse impacts. And so I think by looking at substantial equivalence with a large lens is the right approach. And I think Per-McGee has put together a very substantial permit package before you that meets all of those elements to determine substantial equivalence. And so I wanted to start with that, and happy if you've got kind of specific questions on facility design, best management practices, control technologies, you know, and any additional on ALA, we're happy to answer those.
But I thank you. I'm trying to figure out how I would know as a commissioner that everything that you've put forth in your proposal is substantially equivalent to something that would have been placed 2,000 feet away, and without exactly comparing it to something that's 2,000 feet away, and only working off of these are best management practices. And so therefore that is substantially equivalent. I'm having trouble making the leap from A to B to C personally. So And
Can I
with
maybe jump in and try that one? So from the drilling and completions and then the production standpoint, we would feel more than comfortable and know that we were substantially equivalent in the protections we're offering, even if an RBU was located within 350 feet of our location. We set up all of our monitoring programs for sound VOC monitoring at 350-foot distances. We set up our carbon sorbent tubes at 165 feet from our location. And all of that data comes back showing that from a health and safety standpoint, we're not causing any adverse effects to anyone that would be within that distance. So within 350 feet, anything from there out, you would have substantially equivalent safety for anybody, any RBU located within that distance. And I'm not sure if there's anyone on the team that would want to follow up on any of that.
Thank you, Mr. Honus. Just a couple other points. You know, when you look at the rule language, the fact that we've got relevant local government approval is certainly a factor in here. And also the CDPHE recommendation, as we've discussed. You know, Kerr-McGee has spent a lot of effort and good discussion to meet all of those recommendation criteria, recognizing the few that are not being met for safety reasons. So I think those are two other really important criteria when you evaluate this.
Messner and then Commissioner Gonzalez.
Thank you, Mr. Chair. So a couple of things, Mr. Muscat, you had asked at some point if that would be helpful to show your work essentially. Yes, that needs to be in the application. Yes, this is important information. Yes, this is important for me to determine whether the applicability of CO 604, B4 is met. These are important things to include in an application so that I can analyze it and determine substantial equivalency. So that's just an FYI. I don't need it right now because it needed to be in the application. But and I think that goes along also. And I'm not trying to be curt here by any means, but I am trying because a lot of people are going through applications for the first or second time. We're trying to understand, how to meet certain standards within that, within our rules. And so this is why I bring these things up. And I have in most OGDPs that have been reviewed up to this point, because the idea of an application in a performance-based, application process is for that application to tell a story and to really help these commissioners understand exactly what the proposal is, what the process has been to get to this point, what information has been provided, and how the applicant meets the burden of proof, for the rules associated with whatever OGDP is being submitted. And Mr. Honus, that information as far as how you're determining whether or not there's an emissions issue at 350 feet away. When you submit an application that says we'll put air monitoring in place, that's a reactive process. And I'm not saying it's a bad thing, it's a good thing, but it's a reactive process. Whereas, analysis, report, studies, and modeling associated with emissions to show that it won't hit whatever receptors may be in there, that's proactive, and that's the information necessary in order to make a determination. And having that information, in a conversation in an application process isn't adequate, right? It has to be understood so that I can make a determination on substantial equivalency. And so just stating a BMP, and I will point out, and I'm not trying to poke here, but I can't consider that BMP met unless there is a guarantee that it's going to happen. And so while you're indicating that there may be less receptors, less residential building units associated with this application if we are able to move these tanks off there and provide a produced water facility offsite, that is not what is happening today. And so I can't consider that as a BMP until it's a guarantee. And I think of the same thing when I look at the term as feasible. So if we're looking at doing certain things during ozone non-attainment days, we either do those things or we don't do those things. And if they're not operationally feasible, then say there are certain things that aren't operationally feasible for us to do. And so we're not going to do these things that day, and we are going to do these things this day. And so that to me allows that to be a BMP. The only other way that I can assure that that's going to happen is that if I require it as a condition of approval. But then that's a you shall versus a proposal by the operator in order to be able to, meet certain requirements. And so that's just something that's important for me to just share, and so that you understand how I'm reviewing these applications and how I'm applying 604B4, which is really important conversation here in determining whether or not this application meets the standards and whether the applicant has met the burden of proof. So kind of a narrative there, but I think it's important that it's understood how I'm looking at this.
Commissioner Messner, this is Chaz Buckmeyer. Just a little bit more on kind of Chris's point on the monitoring it, whether that's a reactive or a proactive approach. We've done at over 20 sites and have over 3,000 benzene samples from our operations of similar emissions and things like that. So our position, we feel that our approved program and all the monitoring data we've collected there, and majority of our benzene samples have been at 165 feet away from the wall. We do monitoring out to 300 feet, but we do our basic continuous benzene monitoring is mainly done close to the wall. So as you move further out, you're definitely going to get less impact from there. And so we look back at all the data we've gathered to date, and from our perspective, we think that provides lots better information than any model will, as far as what are the projected impacts from a facility like McGavin and Columbine. So I think looking at our monitoring is proactive, is in consideration for how you would address it, looking at impacts from a similar type pad operation. And we're going to do things here that are going to further reduce emissions that should result in less impact.
Was Linky, did you want to answer as well?
Thank you, Chair Robbins and Commissioner Messner. I do appreciate your comments. I just wanted to take a moment to address the totality of the application and completeness. And while I understand that there have been a handful of OGDPs before us and we're all still learning this process, between the time of filing the OGDP in July and the director determining completeness in October, there was substantial engagement between COGCC and the commission's technical staff and the director, which resulted in the recommendation that concluded that the application was complete, that met the requirements of the rules and the regulations, and ultimately left the decision for approval up to the commission. But I do want to, certainly appreciate the dialogue on what would be helpful for you to see. I also just wanted to make the point that COGCC did work with staff and those technical experts at the staff level to ensure that every aspect of the application was meeting the rule requirements, which the director agreed to. I also just want to take a moment to address the concept of best management practices, and COGCC is committing to these. These are firm commitments. Since the February 16th hearing, COGCC did take a hard look at the BMPs originally proposed and is proposing to revise those. One of those will include a tank design on removing that MLVT. So how we can memorialize those into commitments, COGCC is definitely committed to that. I also believe some of the feasibility language was in the CDPHE recommendation. And so I just want to make sure, we're all aligned in that language and COGCC's commitments before you today. So, if there's any other questions on this aspect of it, I'm sure the group can jump in.
Gonzalez?
Thanks, Chair. And we're all working through this process, right? Trying to understand what this looks like under 604B4. The determination of substantially equivalence is not a staff determination; it's a determination for this commission. I do want to honor the work that the staff has done and the engagement between applicants and the staff that does occur behind the scenes. I think that's a really important point, and there should be some, reliance and honoring the technical engagement that occurs in that regard. And that's nice and all, and I think that usually results in a pretty clear director recommendation. Now, in this case, we don't have that clarity because it stops when it gets to substantially equivalence and leaves that to us. So there's a couple gaps that we need to fill in this forum, and I think that's important for this applicant and for any future applicants to understand. And we're trying to build to the right spot, and perhaps that's coming through in criticism of this application, which may not be I'm hoping it's helpful, and I'm hoping it leads to better applications in the future. So I'm gonna keep on making a couple more comments, and I got a question. With regard to BMPs, when I think about evaluating these under substantial equivalence, one thing I want to know is what's required, what's the proposal, and how do we quantify that delta, right? How do we understand that difference between something that's done in the normal course and something that's above and beyond to really understand that, right? And it doesn't have to necessarily be a comparison to footage or distance, because we made that clear in the SPP that is not the sole determining factor of protections. And I think we've established that here. So that being said, I'd like to follow up on a comment from Mr. Honus in regards to essentially what I'm taking away is that the operations that the applicant are putting forth are based on information that they've monitored, that they've tested, they've accumulated at a 350-foot distance, being equivalent to the same protections that would exist at a 2,000-foot distance. And I'm curious if there's some specifics that you can walk us through, Mr. Honus, in terms of some of the concerns that were brought up in terms of, whether it's emissions, light, noise, traffic, what are we talking about here in how that 350-foot work and analyses and data from the applicant has led to the statement that we are essentially protected 350 feet and beyond.
Yeah, you bet. I'll kind of get started, and then I may kick it over to Chad Schlittmeyer to discuss on the emissions side. But we've done countless pads now at this point where we've had people within much closer than the 2,000-foot limit. And so the BMPs that we've implemented over the years were designed to protect those people to essentially the fullest extent that we could, all the way up to being very close to the pad. The pad that our rig just moved off of, the SBJ pad, we had an RBU. I may be off a little bit on the distance, but they were about 350 to 400 feet away. And from a lighting standpoint, we put up sound walls to block the light from that close. From a traffic standpoint, the traffic is going to have to go by wherever their house is, whether it's off the road, down the county road, a half a mile, or if they're close to the pad. When they are close to the pad, we'll align the sound walls so that they block light, they block traffic along the lease road so that lights aren't shining into their house as we go by. And then from a noise standpoint, the COGCC regulations on noise, we put our monitors close enough to ensure that we're below those noise levels at that distance. I will add that on the McGavin and the Columbine pad, we've done ambient noise studies in the area to show that from a noise standpoint, the rig will have negligible impact compared to what the ambient noise in the area has. So from a noise standpoint, whether you're close or you're far away, it's not going to make a difference on the noise that you hear in the area. Chad, if you want to jump in and maybe add a little bit on the emission side, I'll let you take that.
Sure, thanks, Chris. Yeah, Chad Schlittmeyer once again. Our air mounting program that's been approved for both of these locations, kind of two objectives. One being protective of public health, and the two, to monitor the performance of our facilities. We've kind of followed some EPA methods for continuous benzene monitoring. EPA method 325 that they basically require all the refineries to put around there is continuous benzene monitoring. And one thing that we get from that, it gives us good 24/7 performance of our facilities. We don't just look at the 9 ppb health guidance value that CDPHE has established. We have a a 2 ppb threshold that we consider to be an investigation level. If we have a carbon tube that goes over that level, we basically go back and say, oh, what happened during the last 14 days? Is there something we need to do? So we're just not saying, as long as we're below 9 ppb, we're good. We also, to complement that, we have continuous VOC analyzers. These are set at typically about 300 feet away from the wall, and we try to place these between our operations and RVUs in the area. And we have investigation levels for those. Our investigation levels are set based on historical data and which are protective of public health. And we have 3 levels. And if we trigger one of those, we do an investigation into, okay, what was the cause, and then any corrective action that come out of it. So our monitoring program has gathered a lot of great information. We've made improvements in our operations as a result of it. But when you look at, the public impact, that monitoring close into the facility there, and basically using similar type operations, as we move out further out the distance of the people with RVUs there, we're going to be below any health guidance values, that are basically established by, the guidelines, the CDPHE guidelines.
Follow-up, Chair?
Go ahead.
Yeah, and I'm going to direct this to you, Mr. Schlichtenmeyer, in regards to kind of this ongoing monitoring. What happens when you have an exceedance? What do you do then?
We have levels set up, and basically for I'll talk about the carbon tubes, that if we have a level that goes over 2 ppb, that would be considered a level 2. And what we would do with level 2, that basically it would go through our integrated operations system. One thing that we have all of our air monitoring set up through is to go through our integrated operations center. So if we have an alert that's in the middle of the night, it's not, depending on whether I wake up and see the email or somebody else that goes there, and we basically address it immediately. And so what we would do is dispatch people to the location with the IR cameras and say, okay, what's going on? And if there's something out there that we need to address, we'll take care of it. If we have a carbon tube that goes over a 9 ppb level, that we will call that a level 3, we would contact the COGCC, the CDPHE, and the local governments within 2,000 feet, and we would shut down operations at that point in time until we figured out what the cause of it is and any corrective actions that need to be done. On the VOC side, we have a level 1, a level 2, and a level 3 there. Level 1, level 2 would be investigations on site that we would do at the point in time. If we get a level 3 with the VOC analyzers, the same answer would be we would shut down operations until we figured out. But once again, I just want to reiterate that the levels, investigation levels that we've established are based on historical data and are protective of public health. And so these are proactive levels that we've established. So we make sure that, yes, a change in operations that we need to look at them, but it's not something that we've seen based on historical data that's not going to still protect public health.
So I want to follow up, kind of pivot from there. We talk about if we get to this level 3 level from your carbon tubes or the continuous VOC analyzers, that essentially will cease operations. Everyone, from the applicant side is familiar, with the idea of stop work. And I'm curious at, for other nuisance factors, for other impacts in general, what would trigger a stop work from the applicant?
Chris, you want to jump in there?
Can I jump in and maybe clarify too something? We've never had a level that exceeded any of the CDPHE guidance on health levels. We have had small blips significantly under on the real-time VOC levels. And when those real-time VOC levels have those small blips, that triggers the email and the IOC and the immediate calls to someone like myself in operations, where I'll call the guys on location. We'll immediately check to see if operations have changed, and then we'll begin real live time monitoring those VOC levels from the monitor and see if they continue to go up to where it could become a health concern, which they never have, but we watch them closely, we monitor our ops, we make sure that we have no leaks in our flare line, that our mud gas separator is working correctly, that everything on location is operating as it should, and then those levels have always come back down. And maybe a little bit in response to Commissioner Messner's comment earlier, it's not completely reactive because we've been doing this for 2 years and we know that we've never exceeded those health guidelines. Those numbers are public record and we can go back and look at them. And when we say that up to 350 feet, we know we're safe, it's because we have 2 years worth of data to be able to kind of look and say, yes, we know that we're not exceeding any of these health guidelines. So, and Bill, to continue on with some of your comments there, if we ever had any reason whatsoever to think that we were, whether it's through emissions or any other reason, going to have an adverse effect on health, we would immediately stop operations and we would figure out what is going on and we would fix it before we would ever consider continuing.
And just a reminder, Mr. Honus, who has that authority within your company?
Everyone has that authority. We do have our representatives on location who would probably be the ones who would make that call, but even a floor hand working on the rig at an hourly rate can stop our job at any time if there's ever any safety risk or health concern on location.
Thank you.
I can chime in from a production operations perspective. This is Beth Bosworth. I'm the asset director for the Rockies. Like Chris said, absolutely anybody can use stop work authority. Even somebody driving by a site that from my team, they're driving by a site that they see something that's off, they'll even stop. Even if it's not our site, we will still call it into our integrated operations center. We see that all the time. Not all the time that things are happening, but if you see something, you say something, you stop the job. I mean, even if we're on site and we see something that looks off, we will stop what we were doing and relook at the situation. That's part of our normal operations, as part of our culture. If you see something on a site that's not working right, you shut the site in and you figure out what's going on. That is always your first step. Stop the job and figure out what's going on. And every single person has that authority.
Chair, I thought of one more thing I'd like to ask. When we think about this 350-foot kind of buffer, right, from analysis, from impacts, I want to expand that a little bit further, not the distance, but just my question. What impacts do you guys see that go beyond 350 feet?
I'm racking my brain, and before I continue, Commissioner Gonzalez, I think I used your first name earlier. Sorry about that. My apologies. But as I think about anything that could go beyond 350 feet, the one item that does come into play is possibly traffic. And that's the one where if you're close or far away, it affects you sort of the same way. That's why our traffic pattern plans are so critical, and we ensure that all of our traffic coming from and to location follow those plans that are well thought out and try to minimize the impact on the most people that we can.
Thank you.
From a production operations standpoint, one of the complaints we used to get beyond 300 feet was from VRUs, which is why we eliminated them. This was by far our biggest noise complaint. It was very disruptive to people around us. And that was one of our biggest complaints, which is why we designed it out of the design. So that's a huge win. There will not be VRUs on the production facilities for these pads.
Other questions? All right, seeing no further questions, probably would want the panel to stick around as we move into sort of deliberations in case questions come up. Do we want to take a short break before we dive into this any further? Does that sound fair? Let's return at 4:38. Give ourselves 10 minutes, walk around the block, etc. Right, we are coming back together. There we go. We have all five or all six commissioners with us. In looking back through my notes, Ms. Wesselinki, I did have one question. I had asked a clarifying question of the proposed changes. What were the numbers of RBUs left at McGavin? And the number I got was 62. I wanted to have a similar follow-up question on Columbine.
Yes, good question. I, again, am going to need the final number from the team on Columbine. I don't believe there was contemplated to be the removal of the MLVT. I do want to confirm with the team there. It was the design improvement on the McGavin pad that took those residential building units out of 2,000 feet. Perhaps Ms. Marshall has that number.
Yes, Kelsey, thank you. So there was no MLVT on the Columbine location. There was just one on the McGavin.
So the Columbine numbers remain the same?
That is correct. So we will be removing some produced water tanks, which is different than an MLVT, which maybe Mr. Muscat has the numbers on those, on the reduction, what those might be, and taking the residential building units out, but those will not be because of the MLVT, if that makes sense.
Mr. Muscat?
The Columbine location will be effectively unchanged from an RVU perspective.
Okay. Okay. Did anybody else have questions arise as you look through notes, et cetera, during the break? Okay, not seeing any further. Thank you all. You can remain as is, and then we can move into deliberations by commissioners on this matter. Anybody want to start? We're all going to be heard. Commissioner Najapa?
Thank you, Mr. Chair. I'm going to make some comments and then just share some additional thoughts and stuff. And so, first and foremost, I just want to say that, I know I expressed some frustration before. It's not specific to Oxy or Kerr-McGee. It is just frustration with this specific particular application and some of the things that we were had discussed in the last hearing, and what I was hoping to see, and truly was hoping to get some additional information from you all. So let me just say that. I also want to thank all the public commenters. We had a lot of them today. Appreciate their time and effort to come forward. I was also a little bit frustrated with some of the public comments, though, that were coming from folks that were not directly impacted by this specific decision, and that were talking about things, much further beyond us. I think, one thing that is important to note is that the rules that we created were not a ban on development less than 2,000 feet, but rather provides options for us to consider, so that we can assess that substantial equivalence when those types of proposals come before us, and that's where we are now. I also just want to note for those folks listening that we've seen, I've lost count, I think maybe 9 OGDPs so far in total, and we've approved them all. Some of them had multiple wells, and several of them were within 2,000 feet. So we are assessing each and every one independently. I'll speak for myself. That's the way I'm approaching these. But it is, there was a lot of misinformation, I think, that perhaps was communicated to some of those folks that were commenting, and therefore their comments, in the first place, because they were not directly relevant to this location, were not very influential, at least for this commissioner. So I think, I think that the decision on completeness is one thing, and I appreciate the comments from Commissioner Gonzalez on this, that, you know, that's a technical perspective from the staff, and that's really important, and, you know, always appreciate the amazing work of the staff on assessing that and ensuring that. You know, the burden of proof is on the operator, as several commissioners have been noted. You know, one thing I will say that I appreciate is I saw that the application only had to go back once to you all. We've seen several other applications that have had to go back several times for multiple issues. And so I appreciate that you all, you know, worked on getting the specific pieces of the application together and were able to get that completeness relatively quickly. But that said, as Commissioner Gonzalez pointed out, you know, the decision when it comes to this, to a location that's within 2,000 feet comes to us at the commission. And what I just continue to be struggling with is that we had this conversation at the first hearing. We expressed a lot of concerns and had a lot of questions and asked for additional information. And what you provided, at least for me, was not the type of information that I needed to evaluate certain aspects of this application. And but I'm left with what you gave me. You know, the burden of proof is on you, and so I am going to do my best to assess what's there. One of the things I think that was an important point that Commissioner Gonzalez also raised was that the other locations that you presented to us in the alternate location analysis were not executable. They were more ideas, and that you were, you know, more going down a path to demonstrate to us why these two locations, as initially proposed, were the best. That said, I appreciate that there was consideration of the redesign and a smaller pad, movement of tanks, et cetera, to reduce the number of RVUs that are impacted. But that, I think, correct me if I'm wrong, that was not in any of the materials we received a week ago or even in the ALA on Monday. So this is, as of today, we're learning about this new bit of information. That was not in the application. So that makes it really difficult to evaluate that bit of information. I'm going to stop there for right now, but I'm struggling with this still, because I think there's a lot of issues that we raised, and like I said, speaking for myself, I hoped would be addressed in this continued hearing. But I'm struggling with figuring out how to come to a decision on this issue of substantial equivalence. And I'm going to leave it there for now to let my fellow commissioners provide additional information. But I think that given pieces of new information that are just emerging today, given what was provided to us in the revised information, given some uncertainties on some of the BNPs, this one's a difficult one for me. And again, it's not personal, and it's specific to this very specific application. I want to also acknowledge that, you know, I've been out on sites on Kerr-McGee and Oxy sites and have appreciated, you know, the folks there taking me out, Ms. Coleman in particular. So this is not a personal attack on anybody, and it's just remarks on this particular application.
Sorry, I was muted. Commissioner McGowan?
Thank you, Mr. Chair, and I'm appreciative of what Commissioner Nanjapa has laid out. For me, I'm also working my way up even further upstream, and so I want to say that I'm so appreciative of everything that the operator has done, and I'm sure that you all saw my frustration a few weeks ago when the conditions of approval that were put forth by CDPHE, I think you all moved and said, we will do those. And I'm so appreciative that you did that, because I do think that BMPs are part of substantial equivalency. That being said, I think the first point that we're supposed to be considering is avoidance. And we started off with the McGavin site, I think, where there were 86 residential units, 86, 87, sorry, within that 2,000 foot. Then when we kind of pushed back and said, this doesn't seem quite right, this doesn't, can you do better? You made changes to the McGavin pad, but I don't feel like you heard, at least me, when I said, is there a place you can move further away and leave some of your minerals stranded? That's a viable option. And you didn't bring that forth. And so, I mean, I will get from that you don't think that that's a viable option. I guess I think that 62 people within 2,000 feet is not enough for me to show that you're avoiding first, and then working your way into mitigation and minimization. And so I really would have preferred to see something that shrunk the number of RBUs significantly. Although I'm very appreciative that you made all these changes, but I also wish that would have been in the application in the first place, because I think all these things are doable by you. That being said, to the folks who all testified, I think the things that this operator has put forward, as far as all the conditions of approval that CDPHE put forth, those are best practices. And you might still get complaints from some of those best practices. They are best practices, and they are forward thinking. And I think that some of the things that we are contemplating here get at the heart of many goals that we're trying to achieve, as far as reducing emissions and reducing risk to public health. But I feel that more can be done at the much more upstream, which is the point of avoidance. I guess I have a little less heartburn about the Columbine site now that you've put all those conditions of approval in. I think it's 7 RBUs that are affected, but you're trying to get it built before a residential area would get built out, and then folks can make a choice if they want to move there and know that this is a mixed development that Frederick allows and supports in their town development plan. And so that's kind of where I am right now.
Thank you, Mr. Chair. So I'm going to ramble here a little bit, so I apologize in advance. But I think it's important that I get my thoughts out and that folks can understand how I made my opinions and decisions. So I'll start my thoughts with stating that the commission's rules are intended to regulate, to protect and minimize adverse impacts to public health, safety, welfare, the environment, and wildlife resources, as stated in Colorado Revised Statute 3460-106 2.5a. Under the commission's rules, the applicant also has the burden of proof to show that the application is protective. The commission's rules are intended to avoid, minimize, and mitigate potential adverse impacts, as stated through the statement of basis and purpose and our rules. Stated another way, and quoted both in the statement of basis and purpose, as well as the rules, is that the concept is to first avoid, and if it cannot be avoided, then to minimize, and where it cannot be minimized, then mitigated to a level to protect from adverse impacts. So as stated and quoted in the statement of basis and purpose under Rule 604B4, the commission will use the categories of information set forth in Rule 604B4 A through G, as well as other relevant information appropriate to the proposed location to determine substantial equivalency. This information is to be provided by the applicant as part of their burden of proof. That's my words, not quoted. Quoted again, Rule 604B4A through G requires the commission to consider information, and then my words again provided by the applicant, that reflects whether the alternative methods of achieving production are equal to or more effective to satisfy the relevant criteria when considering the specific characteristics of a proposed location. Throughout Rule 604B4, the commission's intent is to reflect that distance is only one way to protect public health, safety, welfare, environment, and wildlife resources. The commission's rules achieve the required protection in a variety of ways, including but not limited to alternative location analysis, considerations of facility design, adherence to best management practice, requiring use of specific control technologies, and permit conditions of approval. So I reemphasize here that while the rule requires the commission to consider the above information in their decision-making process, the commission is limited in its review to the information provided by the applicant, who has the burden of proof to provide the necessary information and analysis to prove they meet the burden of substantial equivalency laid out in Rule 604B4. In doing this, an applicant must show not only what it will do, but how what is being proposed meets this burden. How being a really important term there. So going back to the statement of basis and purpose quotes, the alternative location analysis process in Rule 304B2 will aid the commission in determining what constraints or opportunities exist in the siting process. As distance is an effective tool in avoiding, minimizing, and mitigating adverse impacts, the commission adopted Rule 604B4D to consider alternatives to the proposed location as part of the Rule 604B4 analysis. That's the quote in my words. In this OGDP, the applicant has provided a proposed locations that are within 2,000 feet of over 90 known residential building units with another 40 or so residential building unit lots that more likely than not will contain residential building units on them in the near future. Some sites that were considered by the applicant in their process had more potential residential building unit receptors, some had less. Some sites allowed for more mineral development and some had less. In the analysis, it appeared that some of the predominant factors in determining location was the desire to utilize approximately 2-mile lateral development in a general north-south pattern and to be able to access to the greatest extent possible the minerals available in the drilling and spacing unit. It appears there were efforts to pick a location that had less potential receptors, but only if the above initial criteria were met. There was some verbal testimony that was given today that some additional sites were considered that weren't shared in the application, but without having that information in the application, I can't consider that. In my analysis of potential locations, I must base my decision or whether or not a location is protective and then apply the criteria of avoid first, then minimize, and when necessary to mitigate. I expect in an ALA that an analysis is done utilizing all possible technology and siting considerations in order to avoid first. It is possible that there are locations, in the state where siting away from receptors is not possible. Our rules do not preclude an applicant for proposing a location that does not fully avoid receptors. But the analysis must include considerations of locations that avoid, even if it means utilization of technology that is not preferred, or locations in which surface leases are not in place, or minerals are not able to be fully recovered. Just because it is the preferred location does not mean it is not, just because it is not the preferred location does not mean that it is not technically feasible. So jumping back to the statement of basis and purpose, the commission recognizes that a variety of factors may affect the extent and severity of potential impacts from oil and gas development. Rule 604B4B reflects the commission's intent to consider those factors to determine the extent that the proposed oil and gas development plan avoids, minimizes, and mitigates adverse impacts. Physical characteristics above and below the surface may alter the potential for impacts as well as the severity of potential impacts. Different technologies may also be available to avoid, minimize, and mitigate impacts depending on the local physical characteristics, the type of drilling, and the size of a proposed oil and gas location. The commission adopted Rule 604B4BI to consider these factors. Distance to human and wildlife receptors will also affect the extent and severity of potential impacts, as well as the location of those receptors in relation to topographical features or other aspects like prevailing winds. The commission adopted Rule 604B4BII to consider the distance to and location of the receptors. Finally, oil and gas development may vary widely in size of surface facilities, well, direction and depth, drilling and completion techniques, and activity on or near the location. Commission adopted Rule 604B4BII to consider these factors and the effect they may have on the extent or severity of potential impacts and opportunities to avoid, minimize, or mitigate those impacts. In addition, operators may be able to design an oil and gas location to avoid, minimize, or mitigate potential impacts to nearby building units. The commission adopted Rule 604B4F to consider a location's design. So I state the basis and purpose, the statement of basis and purpose there so that there's clarity on some of the information I'm utilizing to make a decision on this particular application and the different factors that are required as part of 604B4. The applicant in this application has proposed a location that has up to 90 receptors, i.e. residential building units, not including the unbuilt lots within 2,000 feet of the working pad surface. Some of these receptors are inside the 500 to 1,000 foot buffer, and some are within the 1,000 to 2,000 foot buffer. Important to my consideration of this application is the data, studies, and testimony that this commission utilized in developing Rule 604 during the mission change rulemaking and the rules themselves. This information included potential impacts from noise, odor, emissions, traffic, lighting, as it affects health and welfare. As part of this applicant's burden of proof, an applicant must show substantially equivalent protections for these and other potential impacts. One of the reports in particular that was important consideration for me in this application was the CDPHE report on human health risk assessment for oil and gas operations in Colorado. The study found that the risk of negative short-term health impacts could occur at all distances modeled in the study, which was out to 2,000 feet. Understanding that, it is possible that an applicant could provide best management practices, employ technologies, and develop modeling or analysis to show that by utilizing proposed measures, that an operation could mitigate the impacts to the extent that it would create substantially equivalent protections and meet the standards set forth in the Act to protect and minimize adverse impacts to public health, welfare, the environment, and wildlife resources. The burden of proof is on the applicant to show this. And in this commissioner's opinion, this applicant did not meet the burden in particular to the protection of public health within their application. While as indicated above, the applicant did provide an ALA that considered a number of sites. My analysis has to be done on the preferred site and the sites they are proposing in the application. Also, as indicated above, the proposed sites are within 2,000 feet and in some places closer to 700 feet of over 90 residential building units. The initial application proposed best management practices and operational standards that propose to mitigate potential, proposed BMPs and operational standards that propose to mitigate potential adverse impacts. And while these BMPs and operational standards are commonplace within modern oil and gas development, there was not adequate analysis, reports, or modeling done within the application to make a showing that these would be substantially equivalent protections. While I appreciate in testimony, particularly today, that there was some verbal indication of historical KMOG air monitoring data and experiences, this was not distilled into an analysis or modeling that would make a showing and be available in the application for review and comment by the public or the commission prior to the hearing. In many cases, the best management practices and operational standards in the initial application were less protective than what another operator in Broomfield had proposed and was considered at the time, which I believe was 2017, was the gold standard. This was before the implementation of SB 19-181 and the mission change rulemaking. And even with these, as presented by city councilors from Broomfield, there have been hundreds of nuisance and health complaints and challenges within the operations. When presented with a consultation from CDPHE to at a minimum meet the standards being provided by the operations in Broomfield, it was not until the initial hearing on this OGDP that the operator chose to propose additional protective BMPs and operational standards. But what is missing from the new proposal is a full analysis and or modeling of not what the BMPs are, but an analysis and showing of how they will be protective, how they will mitigate the potential health impacts highlighted by the CDPHE study, how they will meet the burden of proof to show substantially equivalent protections as required by 604(b)(4). Based on 604(b)(4) requirements, the analysis must not only state what is being proposed, but how it will function and coordinate in coordination with the full slate of mitigation measures, and taking into consideration the extraneous factors that could affect those mitigation measures, including weather, timing, geology, topography, size, intensity, and distance. This analysis needs to happen proactively, potentially including modeling or studies rather than reactively after potential impacts occur. This analysis needs to tell the story of how and not a description of what. Another consideration I considered in the review of this application is the land use determination of the local government. While it is important to acknowledge that local governments and the state have dual regulatory authority and an applicant must get approval from both, as a former local government elected official, I take local government decisions very seriously. Again, as a former local government elected official and longtime planning commission member, I'm also very familiar with local land use regulations and the different models and effectiveness of them. A good example of a thorough and effective process for oil and gas review would be Weld County and their WOGLA process, while Firestone has a land use process for oil and gas development. It is predicated on the philosophy that it is appropriate that oil and gas development is appropriate in all land use designations. Other land use codes could call this a use by right or similar terms to it. This type is a very low level of review. While there are some findings that have to be determined in order to develop compatibility with existing uses in Firestone's land use review, it's not clear to this commissioner what those findings entailed. In addition, the rejection of the Planning Commission's recommendation of denial for at least a portion of the application is unusual, although certainly not unheard of. Taking into consideration the aforementioned processes and the inclusion of almost an 80-acre tract of land to be donated to the town, as long as the elected officials do not oppose any element of this application, causes this commissioner to not give significant weight to the local government review process. It is certainly possible that this location could be developed in a way that meets the requirements associated with the act and our rules, particularly 604(b)(4). But this commissioner must review and render a decision on the location and information provided by the applicant. I do not believe that the information provided meets the burden of proof to show substantially equivalent protections as required by 604(b)(4), as it is being proposed within 2,000 feet of over 90 residential building units. In addition, the application seems to be a moving target. As commissioners ask questions, the application and BMPs change. Many of the changes are verbal in testimony and do not give due process to the public or commissioners in determining whether or not they meet the standards and requirements within the rules. This practice of moving parts is not appropriate without resubmitting an application with time for review. In most of, if not all, local government land use review processes, this type of on-the-fly adjustments are not only discouraged, but are precluded in a land use review application. So certainly, I believe should not be entertained within this review process. Again, I'll reiterate that it could be possible that this unit could be developed in some part, particularly in consideration of the Columbine pad. However, that is not the proposal before us within this application. And so therefore, based on the aforementioned reasons, I will have a hard time voting to support this application and would support the denial of the application as presented.
Thank you, Commissioner Messner. Commissioner Gonzalez.
Thank you, Chair. I don't know that I have as eloquent and well thought out delivery as Commissioner Messner, but I'm gonna do my best to kind of fumble through my thoughts here. So again, you know, we're continuing to work our way and learn through these analyses from both our ends, from the applicant end, from our end as here on the commission, as well as, you know, the work that staff's doing before it gets to us. I think this application could have done a much better job detailing the application's assertion of substantial equivalency. You know, I think that was missing in the application. I think that there was plenty of opportunity to have what was discussed today in that application in writing, give us a little more time to think about it, right? And so that's really important. I hope the next one is better. I hope the next applicant that comes before us has a more thorough application, that we continue to learn, we continue to do better with every one of these iterations. Now, I've been wrestling with this application, and I'm sure my fellow commissioners are, you know, given the potential impacts for the residents, of which there are many within 2,000 feet, right? That's a big deal for me as I was thinking about this, as I was working my way through the materials. And just given the application and the written materials alone, I'm not quite sure I would land in the same spot that maybe I would after the conversation we've had today. I think the dialogue that we've had today closed a lot of gaps for me, and that's important, right? It's important that we have these dialogues, and I view these dialogues as part of the application, right? This is part of our decision-making, it's part of the record, it's part of what we're going to consider when we do reach our decisions, or at least I will as one commissioner. You know, one of the really important things that came across, and I think it really distilled down to this substantial equivalency when it came to some level of quantification. And that was, you know, this 350 foot, I don't know what it's called, I'm going to call it an impact buffer. That's based on data the applicant has collected, right? You know, we haven't seen that data. We haven't seen, you know, we haven't seen reports on it. We haven't seen any analysis on it. We've heard testimony from it. Now, I'm not saying that testimony is incorrect. And in fact, you know, I put some credibility on the testimony we've had today. And it is based on 2 years of analyses, right? And it's based on actual data. And while it's not, certainly not an independent analysis, it does provide some feedback on impacts from current operational designs, which I think is important. When we put our rules together, we were working off information that was based on a little bit different operational techniques isn't the right word, but really, you know, operational practices, right? A lot has evolved since then, and since that last study of which we relied on to create the rules and mission change that are in place now. And so basically what I heard today was that from the operator's perspective, that the protections that they put in place with their operations are designed to create that substantial equivalency from 350 feet and beyond. And that's for all impacts with the exception of traffic. In fact, I went so far as to ask the applicant, when are impacts seen, experienced beyond 350 feet? The applicant couldn't think of one. Now, I don't know if there isn't one. Perhaps that's just you know, a response to the question in short order. But again, I found that credible. I do think that the new technologies that are being employed, the use of the BMPs that are being considered here and being offered up by the applicant. And when I say offered up, I do want to recognize that there was a lot of back and forth, a lot of asks to get to this point. And I'm not saying that these should have been volunteered, but at the same time, we're asking for a substantially equivalent determination based on our rules and based on, you know, the substantial equivalence to protection at 2,000 feet. And so I think it's important that we continue to receive that information beyond just the assertions that we have today. But I find the information today that it was presented credible, influential. I think the applicant has accepted almost every request and requirement put forth by this agency, by CDPHE. This application seems to have been in the works for several years. There's been substantial engagement with the town of Firestone and with stakeholders. I took a lot from the public comments, right? You know, we heard a lot of public comments from folks all over the state, and we heard it on a variety of topics, some global and some more to the point of what we're talking about today. And from what I recall from public comment, and I took some pretty good notes, is that it was probably a 50-50 mix in terms of folks who were within 2,000 feet and folks who were in favor and who were against this, right? And so one of the things that I did hear from public comment was at least two folks who spoke to us, who recognized the engagement that they had with the applicant. Going back as far as 2019, understanding concerns, opportunities to visit sites, opportunities to engage, to ask questions, to have those questions answered. And I think that that's an important part of this whole process. We did hear, you know, obviously from the proposed petitioner that there were applicants who did not receive what seems like any communication. And that's a problem. I think that you've got to track those folks down, get to them, and I understand there's limitations there, but I'd like to see. I would like to not see petitions come forward with regard to OGDPs that basically say we never received anything, and now we're bringing this before you, the commission. So as I've kind of worked through all that, and I think about the burden of proof here, it is beyond just the application, the written materials. It is part of this dialogue. I found what I've heard here today to be thorough, to be influential. And I do think that when we think of the burden as more likely than not, I think that it is more likely than not that the BMPs employed, the operational efforts employed, and plans employed by the applicant, I think that they will be substantially equivalent to a 2,000-foot pure distance, perhaps without or with a different type of operation. I'm also not interested in having a ton more pads. I think that the consideration of the alternatives as presented would require more than 2 pads. I think that less pads is better, right? I think necessarily if there's greater impacts, those impacts have multiples when applied to more pads. And so, you know, in looking at those alternatives, and again, I'm not here to play armchair quarterback. I'm only looking at the proposed locations that are before us. You know, I don't want to see applications that have 3 pads when it can be done with 2. I really think that this is the best location given the analyses and that the alternative location analysis was thorough. And I understand the difficulty in capturing all the nuance and all the iterations that were possible permutations of your alternative location analysis that may not have made it into the writing or into the testimony today. But again, I think I'm at the point of rambling now. So I'm going to bottom line this to say that I do think that through the testimony today, what I've read in the pre-filing, in the information through the written materials, I believe that we've reached a substantial equivalency here for this project, and that's kind of where I sit right now. I look forward to hearing from the rest of the commission.
Thank you, Commissioner Gonzalez. I guess it's my turn. I appreciate hearing from all the commissioners with regard to their positions. And I don't know that I need to go into as much depth. You know, I appreciated all the information we received. I appreciated the application. I appreciated the information from the local government. I look at our substantial equivalent rule, and I read the SBP, and I'm kind of looking at it a little bit different than you, Commissioner Messner, and maybe a little bit like the way you were thinking about it, Commissioner McGowan. I think substantial equivalence has been met with regard to Columbine. There are much fewer receptors. The BMPs that are in place are the best. So as I look through the various approaches to that, I'm comfortable with Columbine. I think that this operator can operate that location. The sheer number of receptors there at 8 versus 67 or versus 87, that's a distinction with a difference in my mind. And I think that this operator, who is a good operator, will be able to operate in a manner in which there are substantial equivalent protections. With regard to McGavin, I'm not as convinced. If I go through the analysis, I agree with Commissioner Messner. I don't think the avoid component of avoid, minimize, and mitigate was met, or perhaps was what's been presented to us did not establish that for me. And, you know, I expressed some frustration about the alternative location analysis. Again, you're right, nothing personal to anybody. We're all working through this. But I felt like there could have been other locations, either as part of the application or as part of the feedback we gave you a month ago, where you could come back and I still think there are potentially other locations that would render a better substantially equivalent protective, starting with avoid, so that you're not as close to that many receptors. And then we can look into the minimize and the mitigate. And so that's where I will come down on that. I am in agreement with you, Commissioner Messner, with regard to the town. I was an attorney for local governments that dealt with oil and gas for 25 years or so, and I have a lot of deference to local governments and local decision-making processes. But here, I find that the town board possibly could have been influenced by the land dedication. And I also look to the town planning commission, and planning commission is not part of that operator agreement. They didn't sign it. They weren't bound by it. They weren't influenced by it. And so I take some credence away from the fact that the non-biased members of town potentially, you know, voted to deny the locations. And I find that to be an important characterization. Back to the ALA, again, I'm influenced a bit by the fact that, you know, the Keir McGee, I believe, purchased this property, the surface property, well before 181 came into being. And I think we've heard testimony from a number of different folks that this has been planned for a long time. And unfortunately, I find the ALA, in particular with the McGavin, which is the bigger concerns for me, it just did not, again, get to looking at avoid. And in particular, I mentioned this earlier in some of my musings, but I think this is a situation where the ALA ought to look at locations where potentially not all of the targeted minerals are going to be developed. And so I think that's important. And I appreciate, Ms. Wazelinski, that the rule says that you are to do ALAs for targeted minerals. I understand that, but I think if it's between making a substantial equivalence determination or not, and like, you know, then you're putting the commission into a spot where we have to evaluate what is before us. And I appreciate Commissioner Gonzalez and Commissioner Messner's point that we're not to redo this, or we're not to build something up, and instead that's where we are. So I think with all of that, I would potentially take you up, Commissioner McGowan, on your sliver of a thought of potentially approving Columbine, not approving or denying McGavin at this point, with the direction to the applicant that I think there are opportunities for a new application that could develop some of the minerals that are not developable under Columbine on their own. And before I guess I can hear from the rest of my commissioners, since my approach is a little bit different, I would also want to inquire of the applicant, if I end up with a majority of votes for that, if that's something they're even interested in. In other words, you may want the whole boat or no boat? And I don't know the answer to that question. So y'all start thinking about that while I look to my fellow commissioners for further deliberations. Oh, one other point, and thank you, Commissioner Joppa. If Columbine were to receive approval, I'm interested in it getting developed up as quickly as possible to beat that subdivision that's near it, I believe, if I've got my facts right. And that could alter my thoughts about electric rig or not. I think there's a balancing there. So I just throw that out there for consideration. Now, I will recognize Commissioner Nanjapa.
Thank you, Mr. Chair. I want to thank all my fellow commissioners for their thoughtful and thorough deliberations. I did kind of write up my notes specifically on the points for establishing substantial equivalence under 604 B4. And so I'll just go through them. They're not terribly different from the points that have been raised now by a couple of the commissioners. But I'll just go forward. So with part A, it relies on the director's recommendation. Well, the director's recommendation ultimately said, it is up to us as the commission to decide on the specifics of substantial equivalence. So that is sort of not directly an issue that pertains to the operator's burden of proof, but relates to all the rest of this. So the second point with respect to the extent to which the oil and gas location design and any planned best management practices, et cetera, have been met. I think with geology, technology, and topography, yes. In my opinion, I think that was met for both locations. The location of receptors and proximity to those receptors, I would say no, and I agree with the comments that have been made with respect to McGavin. And also, again, just noting that it was only after the first hearing that additional BMPs were considered and adopted, even when some of those BMPs had been previously suggested via CDPHE. And then upon this second continued hearing, there were additional new design considerations only today that were presented. I do also agree, however, that the Columbine pad has met this. And with that specific caveat of ensuring that the location is drilled and completed before the housing development is built and before occupants begin moving in, that would be the ideal for this commissioner. With respect to the anticipated size, duration, intensity of all phases, et cetera, I think that that the information provided did meet that burden. With respect to the relevant local governments consideration, I also agree that that's a very important factor, but I also was concerned about the land grant that was part of the cooperative agreement and the way in which that cooperative agreement was phrased, which indicated that there was some contingency of a lack of objection by the local government in order for that land grant to occur, and that was troubling to me. With respect to part D, the alternative location analysis, you've heard a lot from me already on this. I do not believe that the operator met the burden of proof here. We did not receive additional locations after the first hearing of requesting specifically requesting trade-offs and alternatives and what would be stranded and what wouldn't, knowing that in the initial proposal, there were already a proportion of minerals that were going to be stranded. So we were asking for some additional views there, and we did not receive those. And I don't think that was true for either location. With respect to the siting and infrastructure, I think that for part E, that was met. I think for part F, with the oil and gas facilities associated that were designed to avoid, minimize, and mitigate impacts, I do not believe that the burden of proof was met there. With respect to McGavin, I think that it has been met with respect to Columbine, again, with the caveat of putting, of drilling and completing that location before the new development that has been platted is built and occupants begin moving in. With respect to the engagement with the nearby residents, Part G, I think this was a little bit unclear, and I agree with the comments that Commissioner Gonzalez raised, in that there were, it appeared that there were substantial efforts that were made on the part of the operator, but we did hear directly from impacted residents within the 2,000 feet that they did not hear, they did not have any information, that they had only learned about it in other ways. And so I do not believe, I think that was unclear at best, and potentially not met. So with all of that said, I think my overall inclination is to deny the permit as it has been presented because of all of the factors that have been noted. But I could consider an approval of Columbine with the caveats as suggested with respect to the time frame for development and completion, drilling and completion.
Commissioner McGowan and then Commissioner Messner.
Thank you, Mr. Chair. And I guess just to clarify, I believe the planning committee for the town recommended approving the Columbine site. So I just want to put that out there. And I think that aligns then. There's no misalignment between what's happening at the planning level and the town level. And so that to me was an important factor. And the other piece for me is, if we are going to consider the Columbine, it is with the BMPs that were offered today for that site, not just the trying to get it done before the development is built.
My perspective on that is, except I'd like to have a discussion about electrification and timing. There was some testimony that if it's electrified, it might be a year or two out. And if we go there, I would want to have that discussion. But the rest of the BMPs, absolutely, from my perspective. Commissioner Messner, you were up next.
Thank you, Mr. Chair. I think I had indicated in my comments that there, I did think it was possible, particularly to consider Columbine. I think it's a little unclean to consider it for us to split the application, I guess. And that's why I presented the thoughts that I did. I don't think it's unclean for the applicant to resubmit an application looking at the OGDP holistically. Again, this is why we have the OGDPs, is we look at it holistically, and again, incorporating, because we still have receptors associated with the Columbine site, and the receptors need to, there's still a burden of proof associated with 604B4. And while I appreciate some of the BMPs that have been suggested as written, there's still some that state that there's contingencies on the water piece, and that there's as feasible in the other thing. And I mean, there's some gray for me there. There's also some additional clarity that I would like to see around an analysis associated with potential public health impacts and emissions. And I agree with Commissioner Gonzalez. I think there was some good verbal testimony given today on some information that it sounds like KMOG has. I would like to see that packaged in a way that allows for the commission to analyze it, that allows for the public to react to it. And I think, again, there has to be a showing of that particular site of the ability to meet those standards. And so while I don't know as that would be precluded, and I think, like I was indicated, I think it's possible, but I don't know as today I'm ready to say what's being presented, because I still have the same concerns with Columbine as I do with McGavin, as far as the inadequacy of some of the information that's been provided in order for me to be able to make that decision. And then legally, I don't even know the answer to this, whether it's appropriate to split it if it's not an actual proposal that's being presented by the applicant. And so I think those are my thoughts on that. I mean, I agree with Commissioner Nanjapa. Ultimately, I'm going to be, I would vote to deny this particular application as presented, although I think that there's some opportunity depending on what exactly the operator presents as far as the burden of proof in meeting 604B4 on the Columbine site, although they may also be interested in reevaluating the whole site and looking at different options. And so those are just my thoughts on that.
Thank you, Commissioner Messner. Now that we've got 3 commissioners that are sort of thinking about this concept, I would like to ask 2 people 2 questions, or 2 people the same question. Someone from the applicant about whether you even desire that approach, or whether you desire just to, as Commissioner Messner and Najapa is just, denial, and then you can go back and readjust and reapply. I also am interested or curious to hear from COGCC staff about this idea. And so I would ask Hearings Manager Larson to elevate perhaps our OGLA and permitting manager Sabrina Trask as well. And that would help me get some sense of my thoughts about this proposal. Ms. Wozlinki?
Thank you, Chair Robbins. I was able to confer with Kerr-McGee, and while we respectfully disagree with the meeting the burden on substantial equivalence, at this point, it's the 2-pad proposal before you, and Kerr-McGee supports that proposal, and at this point would not support splitting the OGDP into just the Columbine.
Okay, fair enough. Thank you, Ms. Trask. We don't need you anymore. Love you, but we got an answer from the applicant, and so see ya. Okay. With that, are there commissioners with further deliberative thoughts? Commissioner Najapa?
Just a very brief one. I appreciate that response from KMOG. And obviously this doesn't preclude a new application coming forward, but now you know the types of things that we need to see. And that's really all I would say. But with that, I would make a motion to deny the permit as presented.
Second. We have a motion and a second. Is there further discussion? Commissioner Gonzalez.
Thanks, Chair, and I appreciate the motion. I won't be voting in favor of that motion. I do think the substantial equivalency has been met, and I do want to honor that we are working through this process and continue to. I do think the application could have been better, perhaps the better application. The discussion may have been a little bit different today. So that being said, I just kind of want to honor that we're all working through this, and I think that I was able to reach my determination through the testimony today in conjunction with the application, kind of looking at it, with a holistic view of the record. That's just my 2 cents on it. So I wanted to set that out there, and I'll let it go to a vote now.
Great. Okay, seeing no further discussion, and I guess I'll just call for the vote. All those in favor of the motion signify by saying aye. Aye.
Aye.
All those opposed signify by saying aye.
Aye.
So the motion carries. The permit as applied for has received a denial vote 4-1 by the commission. We want to thank the applicant and staff for all the work that's been done here. Hearings, or let's see, AAG Mercer. Thank you. Do we need to do anything further? Does this get articulated into a written or document or?
Yes, as with, just like it would be if it was an approval, there will be a final written order of the commission, and that will be issued within 30 days. But as far as business here today on this application, from my perspective, you've done everything that needs to be done short of a motion to adjourn.
Okay, and I know from our agenda, that we have now completed all business of the commission that was agendized. So I would look for a motion to adjourn.
So moved.
Second.
We have a motion and a second. All those in favor signify by saying aye.
Aye.
Any opposed? We are adjourned. Thank you, everybody.